I will need to conduct a Richardson hearing, there being a discovery violation, and that is those witnesses not ever having been listed by the defense. Is that correct?
Well, no, Judge. One of them have been previously listed since the day of the argument hearing. So they were listed as a category A witness. They was unnoticed of over 4 years or something. That's Mr. Shites.
Who testified at the bond hearing?
Correct. And he was listed, and even though he wasn't formally listed after, they are on notice that he's a witness. And not to mention, Judge, if you recall, they are the ones who introduced the contract that was done by Mr. Shites. They have been.
Well, that has not been introduced into evidence. Let's just make that clear. That was used to refresh a witness's memory. It's not been shown to the jury.
But just like how the state throughout the course of the past 2 weeks, we bring up something in particular, I go, that's a discovery violation because it's been provided to them in this version of the discovery. Just because it's an automatic exclusion, someone as a witness, Judge,
I am aware that that is not the go-to sanction for failure to disclose. I'm trying to right now just get a baseline understanding so I can conduct my Richardson hearing and make my 3 required findings. So first and foremost, I understand. You're saying Mr. Shites was listed for a bond hearing. You would acknowledge he was not listed as a Category A witnesses for purposes of trial. And Ms. Robinson was not listed at all in any way, shape, or form during the 5-year pendency of this case.
and that I will concede. However, I will also make the argument because I've dealt with this many times where they're like, oh, but that witness is listed in the supplemental report, so you are on notice. This is Mr. Robinson, actually senior's biological daughter.
Okay.
She's living in the house. She is the one that was driving the license law. They have been on notice that she has information from this case from its inception. Nothing prevented them from going and speaking to her. I will concede, Your Honor. We never listed her.
And look, I'm going to give both sides the opportunity to make argument. I just need the simple fact of, was she listed, was she not listed? Okay. In addition, and of course, the rules of discovery 3.220 require both parties to have that obligation to list the witnesses that they intend to call at trials category A. I think we can all agree on that. I will also add in there that my trial orders that I have entered throughout the pendency of this 5-year case, first done in February of 2023 and most recently done on February 19 of 25, also requires the parties to provide to the court the list of witnesses that might possibly testify. So I could read those names out to the jurors to see if any of the jurors are related by blood or marriage to the witnesses or have any business or social relationships with them. And I read out this complete list of names. And I asked the state, I asked Defendant Whitaker, I asked Defendant Robinson, are there any other names? You would acknowledge that Mr. Shites' name and Ms. Robinson's name were not read. Okay. That being the case, I need to conduct this Richardson hearing because these witnesses were not listed. Okay. So I need to understand first for Mr. Shites and then for Ms. Robinson how you came to know about them, when you decided to list them or call them as a witness, and why, so I can determine whether this was willful or inadvertent.
So, the decision to call them is strictly because of the evidence that was brought out when the state was doing their rebuttal of Abdul Senior.
And what specifically?
When they asked Abdul Senior, which was a subject, I think, of my motion to eliminate, about people opining on who the shooter is if they are not there. Okay? So, they have.
You mean looking at the video and identifying Mr. Robinson?
Correct.
Okay.
No issue with Byron doing that. He was there. Any other witness who was present, because it's not an improper opinion because they actually saw it. So we were not, and they didn't bring it up in their direction. It was in their rehab after we crossed that is specifically wrong with that video. Mr. Abdul Senior testified he had not seen him all day. So then they asked him, in your opinion, based on his body movements giving his lay opinion, yes, that's my son in a video where I cannot, identify that. That's my son, and in my opinion, that looks like him, even though there's nothing identifiable. We did object immediately, Judge.
Yes, and let me clarify though, that came out both during the state's direct of Mr. Robinson and on redirect. So it came out at both occasions where they showed him the video and he identified. And we came sidebar, I think on the first occasion, to hear the objection, and I ruled then, explaining, of course, that the law allows somebody who is familiar with the subject to look at a video or a photograph and identify the subject. So are you telling me that the court's ruling was a surprise that this was going to happen? Because I know you all have deposed Abdul Sr., I think the first time in 23, so over 2 years ago, and then again in 24. He was deposed twice, was he not? Okay. And presumably testified that he would be identified or would be identifying his son in the video. So that could not have been a surprise to now in the middle of trial decide, oh, he's identified him in the video. Because let me just say this, you all are smart lawyers, but you all know the case law. And 2nd DCA, 3rd DCA, 4th DCA, 5th DCA have all said that a witness can identify someone from the video. It does not invade the province of the jury. There have been cases where police officers have been able to identify. Parking security guards have been able to identify in video or in photographs if the predicate can be laid that they are familiar with the person, that they know the person, that they have some special relationship with the person that maybe a common person or a juror seeing it for the first time would not have. And that's especially true in cases in which the video or the photograph are not clear or don't particularly show the individual. And I'll just for the record cite a couple cases for these propositions that I'm stating, or not propositions, for the law that I'm stating. From the 3rd District Court of Appeal, we have Kopp, K-O-P-P versus State, and that is at 334 Southern, I'm not wearing my reader, so excuse me, Southern 3rd, 453, that the testimony of a parking garage security guard who identified the defendant on surveillance footage did not invade the province of the jury. The state is allowed to present this type of identification witness who is capable of independently identifying an individual from photographs, tape recordings, or similar evidence, or to simply support other identification evidence when that might be subject to challenge, assuming the state has laid the foundation. I don't know if this witness was an individual to the crime, but I'll cite just for the record, Day versus State. That's from the 2nd District, 105 Southern 3rd, 1284. Again, a police detective could testify that she recognized the defendant as one of the perpetrators in a surveillance video of a theft. Obviously, the detective was not a witness, but the predicate was laid that she was familiar with him from other communications and contacts. Likewise, in the 2nd District, Ratcliffe versus State. No, sorry, that's not the case. Anyway, and I'm only saying that to understand, knowing what Mr. Robinson would testify, knowing the law of the state, when and why did it take in the middle of trial, after the state is rested, after JOA, to list Ms. Robinson as a witness?
Well, Your Honor, if you recall, when we were at sidebar and we were addressing this issue, Mr. Nicole specifically said, if you are going to open this door, you have a courtroom of family members who are in a similarly situated position to give their opinion as to whether or not that is him. You are now opening that door. So when it was going on, we actually raised that issue to them. And Mr. Robinson wasn't really living at the house there. He was living in and out. So just to say, like, our expectation was, because we consider that we're coming up with information on the stand that we didn't know before, of him saying he's only living there, we weren't on notice that they were going to lay that foundation to try and attempt to bring that in.
Well, they are required to before I allow that to come in.
And understood, this is just for us to gauge it. This wasn't willful. It was not willful, Judge. So that's why I'm saying that in the moment where we sat, and if that was on the defense counsel for not knowing that specific case law, then that would mean that we were infected in not listing her before. So, and I will concede that if that's the situation.
So-
we should have known.
Is her testimony, because I understood you were calling her for reputation. Are you calling her to look at the video and say that's not Mr. Robinson? Are you calling her for reputation evidence against Mr. Robinson Sr.?
I don't want to get into an area, Judge, where it's going to be any doors. I will say that she is, I'm not gonna ask her, you were sitting here and watching your father, pine on littering, that's inadmissible.
Yes, I just want to be sure about that because you all kept saying yesterday that you might be calling someone from the audience for reputation, and that's a whole other decision I need to make in pretrial ruling of admissibility that I'd need to consider before allowing that in to see if that predicate is laid for reputation. So that being out the window then, your intention for calling Ms. Robinson is to show her the video to say that is not Mr. Robinson.
Correct. And I, the state is aware, and I will make her available. I asked her to sit outside this morning. If the state's in between and I want to take a break to be able to speak to her, since they're arguing, we haven't been able to take her depositions. They can speak to her before. If not taking deposition isn't, you know.
And then to be clear, since you've stated she's not here now, she has been here during the pendency of this trial this week and last week.
Yes, my understanding is, and I would have to ask her, is I do believe when she did at some point during his testimony get up and walk away when he said that he had no family in the courtroom. That's just so you know, I believe that she may have left during a portion of it. She is his biological daughter. Just to let the state of the court know the parameters of where I would go. I would say she was living at the house as well at that time. She saw Hakeem very frequently. She's very familiar with him. She was able to see the video on the media on multiple occasions. In her opinion, is that her brother, Hakeem Robinson?
Okay. And tell me, state then how you've been prejudiced or what other alternatives. If I gave you a break to depose her now, to speak to her now, to proffer her entire testimony here right now before we present it to the jury. It's that, or a mistrial or exclusion. As you know, and I will acknowledge, I think all parties can, exclusion is the last resort. It's the last remedy, and it could cause a reversal if I have not considered other less restrictive sanctions for the discovery violation.
I understand, Your Honor. All right, a couple things. I want to go back to, because are we still talking about Shipes as well?
We can talk about both of them, but admittedly, you will have Shipes testified not once, but twice at Mr. Robinson's bond hearings back in, I don't even remember, 2021, perhaps?
We shared with the court and counsel one of the YouTube clips, I believe of, I guess it was maybe the second bond.
That was the second bond hearing.
And so I don't think we have anything from the first bond hearing, but we have that. And in reviewing that bond hearing, the defendant repeatedly objected to the state's questions as being beyond the scope of the bond hearing. In addition, the court, rightfully so, but the court cut off the state's questioning as being far afield of what the issue was. So and if you watch that, we were exploring his basis of knowledge about how he knows, in his opinion, that the video is not the defendant. And those were objected to and then subsequently cut off by the court because of, we're here for a bond. It really doesn't matter to me the guilt or innocence of the defendant. The question is whether or not you can bond this guy out. We would not be able to depose this person because he's never listed. So, I mean, the fact that he's a record executive that would be willing to bond the defendant out gave us no notice as to what he's coming into this court and testifying to. I put him in the exact same boat as I do the daughter of Abdul Robinson. I think it is indistinguishable, those two.
And why, and what is the purpose of calling Mr. Scheitz? Are you calling him for what? Are you going to show him the video and ask him to say that it is or isn't Mr. Robinson? But he wasn't with him on the day. Well, but that's the argument you're making about Senior, that Senior wasn't with him on the day, so he shouldn't have been able to identify him, but you're going to put on Mr. Scheitz, who wasn't with him on the day, was out of state in New York, to identify or not identify Mr. Robinson? So let me, are you telling me that you could not in any way, shape, or form have anticipated or were prepared in your case to present witnesses to look at the video to say that's not Mr. Hakeem Robinson? You weren't going to do that? Someone was going to identify? And you didn't know Abdul Sr. was going to identify his son on the video? How are they to guess that you were going to show the video to a New York music executive and ask him to identify or not identify Mr. Robinson in that video? I don't recall hearing that at the bond hearing because I think I sustained an objection.
He did say that, and then we tried to explore the basis of it, and that's when the objections were sustained.
All right. What I don't like is, I will tell you honestly, I expect both sides to follow our rules of discovery, to follow our rules of professional conduct, ethics, civility, professionalism. This is not trial by ambush. To have a witness listed at 8:18 p.m. or sometime after 8 o'clock p.m. that has never been listed in the 5 years of this case, after the state is rested, after the arguments of JOA, I can tell you I don't like it. I can tell you the appellate courts don't like it. Now, whether or not I'm excluding, I haven't decided at the moment. I still need to hear further argument, but this is not how we handle trials here. Period. End of story. So I need to know from the state, if I give you the opportunity to depose Mr. Scheitz, to depose Ms. Robinson, if we break now, the jury can wait, I suppose, for you to talk to these people. Will that be sufficient to satisfy any procedural prejudice that you believe you have suffered due to the defendant's lack of listing these witnesses for purposes of trial?
The answer is no. It will certainly help, and we'll do it as quickly as we can do it. The answer is no, because deposing someone 5 minutes before they go on the witness stand isn't the purpose of depositions. I can respect that the defense is proffering what they're going to say. What we need to do after putting them under, we have thousands of photographs we can show these witnesses and go through and see if they can identify other things. We have then background research to see whatever else this person has done in their life, talk to people that they depose our witnesses for days, multiple times. And now in the absolute, when Mr. Robinson says, that's my boy, they're countering that with people that we've never even talked to. If we talk to them 5 minutes before, we don't have transcripts. We can't go and follow up on all the evidence that we have here and show those witnesses. It will take hours to depose these people properly. And so that's the prejudice. Our entire trial strategy may change because of this, which is completely unfair of the state. Maybe we wouldn't have asked that question. Maybe we wouldn't have asked Mr. Robinson that question, if we knew that other people were countering it. So there's a whole trial procedure from opening. We haven't mentioned these witnesses in opening. If we knew these witnesses existed, maybe we would have mentioned them in opening. Maybe we'd have gone through the process of all of our witnesses in our case in chief of building around how Mr. Robinson knows more than these other witnesses know. But we couldn't anticipate that they would call witnesses they haven't listed. That is the prejudice. And I know the court is aware of what trials are, especially this case more than others. The amount of time, effort, evidence that we've put into this case is unusual. This isn't a PFCF case where there's 2 witnesses or something like that. This is hundreds and hundreds of hours. I would also point out that the defense motion in limine that was filed in July that we heard, paragraph 2, they actually anticipated this exact issue by saying that they filed a motion saying that no officer should be permitted to give their opinion. And so it's shocking to me that the word no witness could have been included as instead of no officer. That the court can render its own judgment about whether that was intentional for what we're dealing with here today, or whether or not that was merely accidental that they just said officer instead of witness, knowing the only person in the case that was identifying someone from that video was a witness. And they filed a motion in limine saying no officer. And that was this defense motion in limine that was filed July 13th.
And Your Honor, I don't misquote the cases. So the case that I cited to officers, so I wouldn't put something more about the state of the case law that I cited.
I was not saying she was misleading the case law. What I'm saying is, if they believed that Abdul Robinson's testimony was inadmissible, they 1,000% would have put it in their motion in limine. And that was the only direct evidence of someone identifying someone was Abdul Robinson. Yet they took the time to put in a paragraph, no officer will identify him, when none of the officers identified him from the video. So I submit to you that this was intentional. They intentionally did not put no witness because they didn't want the state to know that other witnesses were going to come into this court and give an opposite opinion of Abdul Robinson.
So he said, I'm not saying it's intentional, but just argue that it's intentional as a defense to that, Your Honor. I am saying that that is what I put in there based on the case law that I was aware of at the time. In my opinion, I did not believe that Abdul Robinson, just because Joe Cooper says, is that him in the video, doesn't make that statement admissible. So I didn't believe that that was a proper that he was a proper person to make that opinion.
Despite the case law that says he can absolutely do that?
Judge, the case law that you're citing to, as you can see, I'm trying to differentiate it on the fly right now.
Okay.
So, and in those cases too, I would submit, and without looking at them and digesting them and studying them, almost one thing that I could differentiate them with the fact that this is not the same situation where you have a video of someone who is completely covered. There are nothing about what he can say. He is not, for him to say, oh, he's running in his body morphology, that is what he tried to find. He objected to it because he truly believed that it wasn't admissible evidence. That there, Your Honor, is indicative of what you believed at the time would have been admissible evidence. So it's, but then to argue that this was done on purpose is extremely disingenuous of an argument to me. We have been going through this trial. There are things that have been popping up on the fly that we have argued they should have let us know and change of testimony of certain witnesses, and that has all been allowed. So I'm just saying, they're saying that, oh.
Listen, I'm not saying, I'm here for this. I'm not going to rehash what testimony has already come up. Witnesses are impeached in trials all the time if they change their testimony from what it's been from deposition to current. Because that has occurred in this case for some witnesses, not others, I'm not, that doesn't play in my consideration. It's not like, oh, judge, because they did it, we can do it. 2 wrongs don't make a right. I am here to decide these witnesses. They were not listed, what they have to say, whether it was inadvertent or willful, whether what they have to say or whether this violation was trivial or substantial, and then how and to what extent the state was prejudiced, and then what sanctions I can impose for the violation. It's already been determined they weren't listed. So that's why we're having a Richardson hearing, because witnesses who are intending to be called by the defense were not listed by the defense as witnesses in this trial. Their names were not provided to the court. And further, at least as with Ms. Robinson, the rule of sequestration has been violated because she's been sitting through the course of the trial, and you all invoked the rule of sequestration. Again, I realize that violating the rule of sequestration in and of itself is not sufficient for the exclusion of a witness. I'm looking at this in the totality. And again, I just go back to the issue, Ms. Kawas, with all due respect of the defense, surprised to be admissible by Mr. Robinson. From all of these circuits is abundantly clear, and I will give you time if you need to read them. I don't want you to be on the fly about them, but I would think that from the Third Circuit, y'all's circuit, or the Second, or the Fourth, or the Fifth, y'all would be familiar that witnesses who have a specialized knowledge of the subject can opine about that witness's identification. And further, the appellate courts have specifically said that the state may introduce such identification testimony when a video does not provide clear images of the perpetrator. That's especially when it's most important, assuming the predicate is laid. And in this case, the state asked Mr. Robinson, and he testified that he'd been living with his son, that he had seen his son walk. He has been with him through other times. Admittedly, he served 10 years in federal prison sometime in the 90s based on another a conviction of his. So yes, he admits he was absent for 10 years, but otherwise, at least according to his testimony, if it is to be believed, to lay the predicate for the admissibility of his identification, the predicate was established. I understand you now want to call two witnesses that were not listed to look at that same video and say, no, that's not him. And so my question is, why couldn't you, separate and apart from Mr. Abdul Robinson Sr.'s testimony, have done similarly? Listed them, anticipated that you wanted to call them. Why now, in the middle of trial, after the state's closed and after JOA, are you now thinking, let me call two witnesses, Mr. Shipes from New York and Mr. Robinson's sister, to now look at the video that everyone has had for 5 years and say, no, that's not him? Yes, it is. Do you have a case law rule or statute that says that rebuttal witnesses don't have to be listed?
Judge, all right, I'm relying on the cases that I have where it specifically indicates that not listing, a case I sent you, Judge, was an alibi witness, where the rule requires that that witness should be listed 15 days prior to trial. Was listed 48 hours before he was called to testify, and he was allowed to testify.
Okay, well, all facts are different. I'm going by Ratliff versus State, 561 Southern 2nd, 1276, that holds that rebuttal witnesses are not accepted from the requirements of Florida Rule of Criminal Procedure 3.220.
Judge, in response to that is, I can't know who I'm going to exactly deem a rebuttal witness until I see what they put on. We are in a different posture than the state of Florida. We have zero verdict. This is a criminal case. I have no idea what they're going to do. They are at liberty to put on which witnesses they want, to prove the case whatever they want, but they also have an obligation to do a full investigation. They were on notice of Shipes from years ago. They are also on notice last week that we were intending to call him as a rebuttal witness if we were going to allow this testimony. All this research and phone calls and death rolls that you saying, well, we could have done that. Could have been facilitated over the weekend, but they stayed quiet until it was time that we're standing here now to say, well, now we don't have any more time. So regardless of what we've been here all this time, I have to do a client's life on line, Judge. So if this, I apologize that I didn't foresee and look into a crystal ball and determine how it is that they were going to present their case, but the moment that that testimony was coming out of Senior's mouth, Abdul Robinson Senior's mouth, we alerted the court and the opposing counsel. Maybe not Ms. Robinson, and I understand that, Your Honor, and I have argued separate to her, but specifically asked the Shipes. When we now look to Robinson, just because they have elected not to list certain people, they have known about her since day known about her since day one. I didn't stop them from going and talking to her. Just because we don't list people doesn't mean they don't need to continue their investigation. So their prejudice is, oh, well, we didn't know they were gonna call them. That, they can speak to anyone that they want. The fact that they chose not to speak to their star witnesses, Doggo, is on them. And I understand, Judge, that we weren't able to use them. I want the court to understand this. That wasn't done on purpose. Literally, the moment the court could see, everyone could see, that the moment that was being allowed, we immediately informed them. You understand that that's what it allows them. We specifically said, Johnny Shanks, that was last week, Friday. They still haven't arrested yet. They still called their lead detective. They had the whole weekend to go back to their cell phone expert and create a 171-page exhibit that we had never seen before and was given to us right before that person took the stand. So they had all the time in the world if they wanted to follow up. But then for them to wait until this time now, we put them on notice to say, well, now we don't have enough time for the remedies that Your Honor is absolutely correct. She's available. You could have taken your deposition if you chose to. We'll make them available for you to speak to. Other investigation, but I can't see how though that investigation, you just didn't do it before this time. These are not surprise witnesses. These aren't people that are so far disrelated from this case that you're like, I don't even know who this person was. Yes, this case is 5 years old with thousands and thousands of pages of evidence, but they knew exactly who Robinson was and that was only living in the house at that time. The fact that they don't want to speak to Hakeem Robinson's girlfriend, who was in the house at that time, that's on them. But to come in here now and say, oh, this is a surprise, you know who she is. So they, just because they failed to do a proper and full investigation, they can't come in here now and say, oh, well, now we don't get to the investigation. They were on notice, Judge.
So does that then remove the need for the defense to list witnesses?
No, Judge, and this is a unique circumstance, and I'm just taking it by step by step by step. If there was a witnesses that we could have just arrested just 5 minutes ago, but we don't know who were. I didn't have any clue that they were going to fail to call half of the eyewitnesses in this case. So we had to now push on our case and call those witnesses. They didn't tell us who they were calling. They would just tell us, oh, the next day we're calling this person. Don't call Raekwon Howard. Don't call Jarvon Williams. Don't call J.R. Smith. None of those witnesses were called.
Are they obligated to tell you who they're not going to call as a witness?
They're not, but Judge, I am obligated to tell them when I know I'm going to call someone. And I found out the moment that witness entered that evidence, and frankly speaking, as to Mr. Robinson, I was just talking to all of the family members yesterday to see which one. That's the reason I got today. But Ms. Robinson is someone that's within their control, not within their control, but someone that they were aware of. The rising problem that senior spoke about, it's her car. My daughter's car, that's her car. So that's someone that they were aware of at first-hand knowledge as it relates to this case. The fact that you only go to one family member and ask his opinion whether or not that's his son, that's on them for lack of investigation. However, we are here now, Judge, and they have been on notice. And then to now come in here as to Mr. Shanks and say, well, we could have accomplished that over the weekend with 2 months when that testimony came up. As it relates to Ms. Robinson, she's outside, you can speak to her. The very narrow area of where I'm planning to ask her about the fact that she knows. I'm not too sure what other investigation, what you're going to show her 800 other videos of a covered up Hakeem Robinson to ask if that's him too?
They're entitled to ask whatever the questions they want in deposition. It's discovery purposes. This is what we're going to do because it's now 9:40 and we have to do this test run with Ms. Ahmad, who's in the country of Jordan. I'm going to ask the state. Well, first, we're going to call Ms. Jordan, or the defense is going to call Jordan, Graham, and Gibson. Then we're going to take a recess. And I'm going to ask the state to make its best efforts at deposing these 2 witnesses. Ask whatever questions you want to ask of them. Take however long you want to take with them. We will have to recess these 2 juries. They will just be sitting in their jury rooms waiting. And then let me hear from you. If you have obtained whatever sufficient information you think you have, I'll hear further argument on prejudice, and then I'll make my decision. But I think we should at least take this first step of you talking to them, deposing them under oath, and doing whatever else you think you need to do to be prepared to question them should I allow them to testify. But so far, we've now wasted not 40 minutes of this jury's time. let's do this Zoom test with Ms. Ahmad, and then let's get started with trial, at least with these first 3 witnesses for whom there are no issues.
Your Honor, one of the defense counsel step out with me while I...
Okay. All right. Do we have Mike here? Who is doing the test run with Miss Jordan?
Your Honor, I haven't heard from the person from Jordan yet.
Oh, were they going to be calling in at 9:30?
Reaching out to Mr. Chris or myself. But
Okay. Mr. DeCoste, have you gotten any type of call from Miss Ahmad and Jordan? Okay. All right. Well, then I guess no test run on her.
So, Your Honor, again, in those, there was an asterisk next to Ms. Ahmad and Gibson based on Graham's testimony.
So you want to call Graham first?
Please, yes.
Okay. And who, Mr. Mizrahi, or do you need to be in court? Are you going to be out of court? I mean,
Those witnesses are being handled by Mr. Atkinson and Mr. Cooper. So I can step out and talk to...
well, no, I want to do it however y'all want.
I need to find something.
I understand. Go ahead and get whatever you need.
Ooh, child, they came in hot today on this trial. Hot. Okay, a lot of y'all was confused. So yesterday, if you tuned in, you know, the defense said they would, well, for the defense for Ksoo said they will put on a rebuttal case. They said they will be calling a record exec and Ksoo's mom. The issue arose that they never put Ksoo's mom or the record exec on the witness list. Okay, you supposed to update your witness list as you get witnesses, and all that's supposed to be turned in by a deadline. Okay, however, the defense decided not to do that. It was also an issue, the fact that Ksoo's mom has been in the courtroom most of the trial, and this trial has been sequestered, and I know I probably said that incorrectly, right? And the defense was the one who made it that way. So for them to now want to break the rule that they put in place for the trial to bring Ksoo's mom up, the judge told them they would need to find case law, which will provide a legal reasoning for why that should go on. Fast forward to today. We were a few minutes late to the court, but for the most part, they were still debating what to do. Now, this morning, they mentioned that Miss Robinson, who is Ksoo's sister, will be the witness, and the record exec. So the judge said it was 3 things that can be done as far as a result of the defense basically messing up, breaking the rule, right? She can declare a mistrial, right? Hey, I believe if this really is a play, personally, I feel like it's a play on the defense. But if a mistrial happened, this trial took 5 years. The question would be, will Jacksonville, the state of Jacksonville, no, not the state, Jacksonville County, be able to retry this case? That would be really up in the air, right? Will they really take resources to redo a 5-year case, similar to the Melly case, although they decided to redo it. Too much at stake, right? So the other one was to exclude, okay, the testimony of Blue, right? Because these witnesses are supposed to rebuttal Blue. The third one was to allow them to depose the witnesses now, right? And then go from there. Now, the state ain't happy with it at all because they don't have the time they need. As I said the other day, I think the play was to avoid the state digging in to the witnesses' background and business and all that. So, and the state basically said, like, they don't have time to do the background. They don't have time to go through everything they need to go through. They don't, like, that's not going to be time, right? So, that's kind of where we're at. So, what's going to happen this morning? They said they're going to have a few witnesses. I think they said 3. Come in. After that, okay, they're going to go into a long recess to allow the state to depose the new witnesses. Then at that point, they're going to have another argument and the judge is going to rule. So they're going to do the depositions. However, they still don't even know if the witnesses will testify based off whatever the judge ruled. So that's the best summary I got for y'all. I hope that kind of breaks it down a little bit. I know the audio has been real lacking the past 2 days. But yeah, I've been here with my eyes closed, just trying to hear it. So, there's nothing I can do on my end, but yeah, the audio is trash. So yeah, it's a lot. As far as Blue and Butter, the judge did rule yesterday during the motion for acquittal that they, like, as far as the legal attributes, they do qualify to give that testimony. And she takes the testimony as being what it is. It's up to the jury to decide if they're credible. So they're back. Let's go.
All right, so if you'll sit closely to those microphones and be sure to speak loudly and clearly into them. Thank you. You may proceed.
Thank you, Your Honor. Good morning.
Morning.
If you could introduce yourself to the 2 juries.
My name is Tim Graham.
Now, sir, back in January of 2020, were you working for the Jacksonville Sheriff's Office?
Yes, I was.
What was your position?
I was a police officer.
Around that time, were you training other police officers?
Yes, I was.
Specifically on January 15th, 2020, were you training a recruit?
Yes, I was.
Do you remember his or her name?
Prater.
Do all police officers train recruits?
No, sir.
You were tasked with training?
Yes.
Was Officer Prater fresh out of the academy?
I don't remember if he was fresh, but maybe a couple months out.
Does the academy include physical training?
Yes.
Was Officer Prater, in your opinion, fit at that time?
I believe so.
Now, turning your attention specifically to January 15th, 2020, was there a point in time when you responded to a call that was being dealt with by a former colleague, Jimmy Collins?
Yes, sir.
You could explain to the juries what transpired.
Officer Collins put out a call, shots fired at a shopping center at Maryland Townsend. He was in a vehicle pursuit. We responded southbound on Townsend. Officer Collins got into a pursuit on foot. We got to that location near the 900 block of Townsend. We saw Officer Collins pointing in the direction west of Townsend near Carlotta of a male subject running west. We started to drive towards Carlotta and we saw a male subject running.
Now, I want to make sure for the jury that we have the reference. So we'll use it north, east, south, west, okay?
Yes, sir.
Townsend pretty much runs directly north to south.
That's correct.
And Carlotta, is that west or east of Townsend?
Well, yes, sir. It runs east and west. West and east, yes, sir.
The area that you responded to, was it west of Townsend?
It was west of Townsend, yes, sir.
And, so I'm going to have you pick it up in what you were explaining to the jury. You and Officer Prater in your vehicle respond west and see somebody.
Yes, we saw a male subject running.
What was the distance?
We saw the male subject running from our vehicle,
The closest that you saw this male subject running that morning, how far?
50 to 75 yards.
Using this courtroom, how far would you say? If you could estimate it.
The closest we got was to the door once we closed the gap. But the first initial time that we saw him was past the courtroom.
We're talking about the closest you ever got. The closest you ever got was 50 yards?
The closest we got was 50 yards.
Estimate.
Estimate,
All right. Can you use this courtroom? Would that be from that corner to that corner?
if that's 50 yards, possibly.
Do you think?
Possibly.
All right. But you were able to see this person.
From the backside, I never saw the front of the subject.
You were able to observe that person's movements?
Yeah, he was running.
Yeah. And from that person's movements, were you able to make any assessment as to his physical fitness, his or her physical fitness?
I don't understand your question.
Did you see this person jump a couple of fences?
Absolutely.
He was able to evade Officer Prater?
And me.
Now, as you're responding and viewing this person, did you call out over the radio a description of what you saw?
Yes, sir, I did.
Do you remember what that description was?
Yes, sir.
If you could please tell the jury what that description was.
He was approximately 5'8" to 5'10", black male, wearing a black.
I'm sorry to interrupt. Can everyone in the audience please make sure that your electronic devices are turned off? Thank you. You may proceed.
Yes, ma'am. Black male, I believe it was a gray shirt with black sleeves and black pants.
Tried to chase him on foot, right?
We tried to chase him on foot, and we were in the car initially when we saw him. So
Was this person that was jumping fences that was 5'8" to 5'10", were they able to evade you?
yes, sir. Yeah, he did.
Now, the build on this person,
Yes, sir.
do you remember giving a description on the build?
I don't think I did it over the radio, but I think I have previously testified to that.
Do you remember the build of the person that you saw?
Yes, sir.
And what was the build of the person? Were they very fit?
I'm sorry.
Very fit?
I would say fit, yeah, medium build.
Would you say, quote unquote, very fit?
I guess so, yes, sir.
Would it refresh your recollection to take a look at the deposition?
Yes, sir.
Council pages 87. Your Honor, may I approach?
Yes.
You can just take a look at this. Starting line 14.
Okay, very fit. Yep.
You just said a moment ago, I want to make sure that it goes with the question. Would you describe the person as very fit?
It says very fit, and before that it says rather fit too.
So very fit, right? And again, I'm not here to put words in your mouth. The person that you saw was rather fit, very fit. They were fit.
They were fit.
Fit enough to outrun you.
Fit enough to jump fences. Yes, sir.
Did you author a report in this case?
Yes, sir, I did.
Before you retired from the force, you're no longer on the force now?
I retired in October of 24. Yes, sir.
All right. So the purpose of police reports, are they to make sure that the knowledge that you obtain at that time is memorialized for the future?
Yes, sir.
Was there anything in there that you remember where you say 5'8", 5'10", fit, jumping fences, but I'm not sure? Did you equivocate in any way?
No, sir. Not that I recall. I mean, it's been 5 years, sir.
Would it refresh your recollection? Take a look at the report.
I looked at the report already, sir.
All right. So was there anything in there in your testimony where you're saying to this jury, look, I gave that description, but I'm not sure?
Sir, I could have been wrong on the height. He could have been 6'2", 6'4". He was running.
But on that day, when you wrote the report, you wrote it, and that's what you believed it to be, right?
I believed it to be, he could have been 5'4", but he was running.
And regardless of the height, regardless of the weight, it was somebody that was fit enough to be jumping fences. And evading.
Absolutely. Yes, sir.
One brief moment, Your Honor.
Okay.
Nothing further. Thank you.
All right, cross-exam.
Officer Graham, you were with the sheriff's office for a long time.
24 years. Yes, sir.
Wrote a lot of reports.
Yes, sir.
In your reports, is it like a diary where you write your emotions and your feelings about how you feel about something?
No, sir.
It's your best effort to write in a short narrative what you observed.
That's correct, sir.
And when you saw the suspect for the first time, you were still in your police car,
That is correct.
and so was Officer Prater.
That is correct.
And you said that the suspect, at best, you got 50 yards in distance. At worst, when you first saw him, you were 75 yards away.
That's an estimate. Yes, sir.
Okay. And you don't believe that you ever got a good look at this person.
The whole time, correct. It was from the backside.
Okay. At all times, this person was running away from you.
That's correct. Yes,
This
sir.
is in a crouched running motion.
That is correct.
People run standing straight up.
They could, but this person was running away.
Okay.
So
They're trying to run away from the police.
that is correct.
They're in full sprint.
Yes, sir.
You said his back is towards you at all times.
That is correct.
So you never saw him from the side or anything like that.
No, sir.
You said that he jumped a fence.
2 fences.
So by the time that you get to the first fence, he's already in the process of jumping the second fence.
That's correct.
So again, at all times that you're seeing this person, he is running away from you and is either in running motion or is jumping a fence.
That is correct.
And you described this person as not slim,
That's correct.
not skinny.
That's correct.
You said that he was repeatedly told defense attorneys he was medium build.
That's correct.
Okay, if you'll rephrase your question.
You repeatedly said that he was medium build.
Yes, sir.
Overruled.
At the defense counsel asked you on direct examination that he was very fit. He was wearing a tracksuit, so you couldn't see what his muscular tone was.
No, sir. I could not.
In fact, you said that he did not look like a person who always lifted weights.
That is correct.
You described him as a person who didn't look like he ever missed a meal.
That is correct.
I don't have any other questions.
All right. Any questions from for Mr. Whitaker? No, Your Honor. Thank you. Any redirect?
Yes, Your Honor. So, Mr. Graham, what you're saying is he didn't look like a malnourished person.
That is correct.
Now, you as a police officer, when you're giving a description, you're giving it so that your colleagues can help find the person, right?
I'm not a police officer anymore.
When you were.
That's correct.
All right. Because this person, this shooter, is running through neighborhoods, and that could be a threat to all of the residents of Duval County.
Absolutely.
All right. So when you're giving the description, you're taking into consideration, you as a trained police officer, things like the fact that the guy was running, right?
Yes, sir.
You didn't say, it could be a taller guy, but he was crouched. You gave your best estimate at the time.
Did the best I could, sir. Yes, sir.
Yes. And you also had points of reference, like the fences, right? You saw this person run, approach a fence, and jump over.
It's 75, 50 yards. Yes, sir.
I understand that, but you saw the point of reference, right?
Sure, I did.
And you took all of that, the totality of the circumstances, to come back to your best estimate. You didn't say specifically height. You said 5'8" to 5'10", right?
Yes. Yes, sir.
Thank you, Your Honor. Nothing further.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you, sir. You are excused and free to go. All right, you may call your next witness.
Your Honor, our next witness is.
That was a bad witness defense. Cause basically it just put out that the man wasn't skinny. He was never missed a meal. He had some meat on him. Bad witness, bad witness. And I think most of these witnesses are police officers, if I remember correctly. I Other than the other two they was talking about, we'll see. I think they are. Ooh. But I hope now the one from yesterday did better, you know what I'm saying? Because he said the dress he saw in the front of Ksoo's jacket the day before was short. Now, if y'all remember in King Von's and Young and Ace video, Ksoo had his hair like put up in like a mohawk where you can, you know what I'm saying? So I wonder if his hair was like that, but we know them dreads was definitely longer all around. But yesterday police officer was better than the one from today. What's up, Jody? Jody said they're having multiple witnesses to say the shooter was less than 6 feet. Ksoo is well over 6 foot. I honestly, because the height ranges has been all over the place, I really don't think it's gonna hold no weight to the jury. Um, just because it's just been all over the place. And everybody said he was in running position. Kiki said I took a private investigator class. Police are trained to identify and describe the description. Oh, they bad.
All right, let me look at the exhibit and let me clarify when you say present sense impressions, and that, since that is not an exception to hearsay, which of the three are you talking about? Number one, spontaneous statement. Number two, excited utterance. Or number three, then existing mental, emotional, or physical condition.
So I would go, one brief moment, Jeremy,
Okay.
pull up the note. Your Honor, I pause because humbly, I would disagree that present sense impression is not a hearsay exception. It would also fall with an excited utterance because both of them testified that they're calling out over the radio while they're chasing somebody and going through that adrenaline of chasing somebody. So I would say that it could also fall within the parameters of excited utterance.
I'll have to look up my notes on Officer Collins, but I don't recall former Officer Graham testifying to that. That wasn't asked of him.
I just asked him, Your Honor, that, and I'm happy to recall him, I can text him and bring him back in, that he receives a call out in the radio, and contemporaneous to that, we all know that the officers are conveying information on the radio, and the information that Your Honor will see from these CAD notes is exactly what he just testified to. And those are the only two officers that witnessed somebody in that area.
I understand. I'm just trying to understand which of the hearsay exceptions you believe the CAD notes fall under, because of course they are hearsay, because those CAD notes are an out-of-court statement offered to prove the truth of the matter asserted. But if it fits under one of the numerous exceptions under 90.803, that's what I'm trying to specifically understand. So you're saying excited utterance, subsection 2, and you're saying public record under subsection 8 or some other subsection? Tell me what is your argument as to why the CAD report should come in, under what exception to hearsay, so I can appropriately rule.
So we would say for the purpose of authentication, we've laid the predicate for business record. That was done through Smith. As for the hearsay exception, it would be twofold. I believe that it falls within present sense impression being an exception to hearsay in the state of Florida. In the event that that
Which
is,
subsection under the statute is that?
oh, give me a second to pull that up then.
Okay.
And Your Honor, if you want me to, while I'm pulling that up, I can publish to you what's in the CAD note.
That'd be great.
Great. I'm getting better, AJ. Yeah. So Your Honor, right here, 5686, they put in the badge number of Collins, which the state brought out in their direct. And that is 100% consistent with what he stated, 55 to 59 west from Townsend.
So this is a 53-page document. Are you redacting portions of it? Because it includes more than just these two officers.
Correct. I could either redact, or if it's done, the same way that we would do stipulation, that there was call action detailed notes stating just this. I mean, I could do it in its separate memo. The other statement, which is consistent with Graham, black male, gray sweatshirt, black sweats, 5'8" to 5'10", westbound on West Lawn, last seen jumping fences.
How do we know those statements are from those officers? Because it's not identified on this CAD report.
On the first one, it is.
Let me see, go back up there.
5686 is Collins's badge number,
How do we know that?
because he testified to it on direct examination.
He gave his badge number?
Right, literally the first question was asking his badge number. I was surprised. It saved me a question, but it was brought out.
Okay.
Not a badge.
5686 is his badge number. Literally, if Your Honor goes back, literally, he gets up there, Jimmy Collins, badge number 5686.
All right. And all right, but so let me go back to your request for admissibility under what particular exception?
Your Honor, I'm pulling that up now so that I can give you the specific number.
Okay.
.803 1 and 2, I believe.
So spontaneous statement and excited utterance.
Yeah, or use my computer, will be faster. Yes, Your Honor. So I'd go with Florida Statute 90-803-1. which allows for the admission of a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. And I don't, the only times that it would be inadmissible is if it lacked trustworthiness, but the cumulative evidence in this case between their testimony of what they stated, the reports that support it, there's no question that it's trustworthy.
All right, so those two exceptions, so not business records.
No, Your Honor, we'd move to admit it of those two in conjunction.
I'm sorry, in conjunction with what? With business records?
Together, yes.
Okay.
We add in the business record exception given the fact that that also goes to authenticity because the government's stating that it may not be accurate, but we know from Officer Smith, and I did ask the questions, the predicate for business record.
And let me ask about this. Were those records obtained with a business certification?
Yes.
Okay.
That it was provided by the state to me, I can show it to them. Specifically for here's the digits at the top of all the cat notes. And it was authored for, like at the top it says, JSO 2001150003434. Business record certification we have specifically has that in the title, and then on the left-hand column has all the other CAD notes that were provided.
Is it a certification though that comports with 90.902 subsection 11? In other words, signed under oath by the custodian of records? The typical business certification that one must have to enter any kind of business records.
Yes, Your Honor, I can put it on the overhead.
Okay.
So if Your Honor sees, and I've got two of the documents up here, the 34354. Put them side by side.
All right, and last question then. How do I, what's the word I'm looking for? As you know, typically, police reports are inadmissible in evidence. They contain inadmissible hearsay. And indeed, in 90.803 in particular, with reference to these public records and reports in subsection 8, it says that it is excluded in criminal cases matters observed by a police officer or other law enforcement personnel. How do I jive those two provisions when police reports in and of themselves are not admissible in a criminal trial?
Your Honor, it's twofold. First, the call action detail notes are made in the moment. Officers can write reports much later in time. But more importantly, the second point, that reports are created in anticipation of litigation, whereas call action detail notes are made in the moment. I think the fear was, it was a two-edged sword that they were concerned about, that officers could create documents to strengthen a case because you can do a report, and sometimes the reports are months, years later, whereas the call action detail notes, they only happen in the moment. You can't go back and change it later.
All right, so then I'll hear any further argument from the state. Otherwise, I'm going to go ahead and rule on this exhibit.
Your Honor, the only thing I can add, similar to a 911 call or body cam.
Okay. So the 55-page exhibit obviously cannot be moved in to its entirety because it contains other statements by other individuals whom we don't know. and who have not testified here today. So that would be an admissible hearsay. I will allow the first one that is identified by Officer Townsend's badge number. I honestly don't recall that he gave his badge number, but I'm going to take your word for it.
Collins, not Townsend.
Oh, Collins, excuse me, right. Talking about Townsend Road, getting the names mixed up. The second one is unidentified as to who said it, or, so I'm not going to allow the second statement because it doesn't show in the record who made that statement. So we don't know. But the first one, if identified as Officer Collins's, I will allow you to excise just that line out of the entirety of the 55-page document, and you can move that in to evidence on an exhibit if you have it.
So let Your Honor, and I do have it, it's already up there, but what I can do is this, where the first page I black out pretty much everything except the information that shows that it's CAD notes, delete out all the other pages, and just have that 1 second page and black out everything on that page. I think it's better than blacking out 50 pages.
I agree. I mean, State, I understand you object to this exhibit coming in, but as knowing my ruling and as explained, are you acceptable with that? Okay. So if you will make just the 1 page with everything blacked out other than Officer Collins's description given at the moment. All right. All right, so we will just await. Is Mr. Mizrahi deposing the witnesses outside? What's happening? And what's the time frame for him? I know he's in Europe. What is his, where in Europe? What's the hour delay? Oh. Okay. All right. And just from clarity of record on the issue of the CAD report, since 3 hearsay exceptions were delineated, and so the appellate court knows my ruling. As for spontaneous statement, I will allow it. As for excited utterance, I will not. There was no testimony from Officer Collins establishing excited utterance. And for business records, I'll allow it. So that's why I'm allowing it with the edits that I have already described.
Your Honor, understanding that we have the jury waiting, I'll make sure that I move very quickly. Can you step out so I can make that phone call?
Yes.
And then just write me back how that document should only take me minutes.
And that's going to be what, defendants 2, 4, what number? Okay, we don't have a defendants 2. I just want you all to know we've skipped. We have defendants 1, which is the photo of Chris Brown, and defendants 3, which is the video from January 14.
Correct. Defense 2 was a disc that was CAD notes, but it's unedited. So I don't know if we just leave it as 2.
Not if it's going, I mean, if you want to make it part of a court exhibit for appellate purposes, that's fine, but let's not confuse the numbers for the jury. I mean, I'll let you number it, I guess, how you want.
We'll do 4, and then that one, at least it's in the record, the other note that we were trying to get in.
You mean the 53 pages?
That's what's on the disc.
Okay.
Once it's written, but the other document.
All right, so for the record, defendants 2, which is not, let's call it not a number. The numbered exhibits are evidence, lettered exhibits are for identification. So we can call this defendants A for identification. So the record is clear. It is the complete 53-page CAD notes that are not being moved into evidence, correct?
Correct.
All right. Or however many pages, 52, 53.
I believe 53 exactly.
Okay. All right, well, if any of the court staff need a recess, we'll take this time to be in recess while we do these things. Thank you.
Thank you, Your Honor.
All right, y'all. So we're in recess for now. Hold on, give me a second. Antonio said Mickey, he the only one who did. They only need one person. Y'all, like, listen, a lot of y'all may not like Butter for whatever reason, but nevertheless, as far as the courtroom, he is the eyewitness that placed Ksoo on the scene. So in regards to evidence, guess what? Part of evidence was provided that Ksoo was there. Hence Butter's testimony. It's up to the jury to decide if Butter is a credible witness or not. Y'all know over here on my channel, when we watch trials, we make ourselves the jury of the public, okay? And I told you, I believe Butter. For sure. Some of y'all don't believe him as a credible witness. So I know over here, if we really was a jury, it would be a hung jury if my channel, okay, was responsible for the jury. Because we are divided as far as if, you know, Butter is credible or not. So that's that. So nevertheless, as far as evidence provided, like I said, the state has painted a good case. The defense has done good trying to poke holes into the story. The most doubt that they have caused, in my opinion, is the possibility that Chris Brown could have been the shooter. Other than that, you know, that's the only thing that has me on the fence based off what they presented to, you know, there. Lil Jesus got to be a child. Said you can say Ksoo was there, but did they prove Ksoo was there? Yeah. Like the witness said he was there. Like, I don't get what do y'all mean by that? That is proving Ksoo was there if a person physically put you there. Like, what you mean? A person that was in the car with you, a person that like that is putting you there. I'm confused. Your DNA is in the car. Although they can't prove when the DNA got in the car, your DNA is already in the car. A person is saying you're in the car and you got out with the gun. Like, come on, y'all gotta understand how courts work. You know, Ruben said, I believe Butter, but I don't believe he's a credible witness. Well, you don't believe him then. That's kind of like, confusing. That's kind of confusing. Because for you to believe, you got to think he's a credible witness. I mean, like I said, hey, he's definitely a messed up individual, but he seemed believable, okay? So, and for those, because I know we be using legal jargon. For those that don't know the definition of a credible witness, it's someone whose testimony is deemed believable and trustworthy. Okay, their words carry weight because they came across as competent, honest, and reliable. Factors contributing to a witness credibility. Several elements influence whether a judge or jury perceives a witness as credible. Knowledge and experience. Let's talk about that. Knowledge and experience. Butter has already pleaded to his part in the crime. Okay. He has been doing crimes for a long time, including testifying in a previous case in 2017. Next, honest and forthrightness. Witnesses will appear sincere, honest in their testimony. Honest in their testimony, even admitting what they don't recall specific details as seem more credible. Butter didn't flinch when he was on that stand, okay? Did not flinch when he was on the stand. He did not get defensive. He said what he said and kept moving. He answered all the questions. He wasn't dodging no questions. So I think he meets that. Consistency. He was definitely consistent. Okay. He definitely was consistent. And we can just go on. But yeah, he like I said, he fits the definition to me. Outside of butter, what else places him there? Boy, go to school, because you gotta be a child. The fuck? You don't need that many people to place you there. One person placing you at a murder scene is enough. Like, where do y'all get you got to have 1,000 things to be there? Like, they may have a lot of circumstantial evidence as far as other things, but you got a witness that place you there. That's enough to get your ass locked up. So while y'all think it's funny, one person just got to put you there. Now, if Ksoo had a actual airtight alibi to place him somewhere else, that would be different, right? Because you can go against that. But obviously, he ain't had no alibi, hence why he's on trial for murder. Hold on, y'all. All right. Angel said the fact that you think Butter is a credible witness is crazy. Hey, it is what it is. It is what it is. Look, y'all ain't gonna make me feel bad. I feel like it makes sense. The hell? His testimony matched all the other witnesses that came in before him. So it is what it is, you know. Yeah, like it is what it is. You know, like I said, y'all don't have to, like, we are definitely divided when it comes to the witnesses. But hey, that's just how I feel. He's believable. Hell, he ran in a crew. He done put himself there. So who else know better than somebody who claimed to be there? It has been proven that Butter was on the scene. Y'all want to argue about a witness that was actually there, and y'all wasn't there. Now, if y'all show me a witness that said Ksoo was not there, then we can have a conversation. No witness, nobody, not even his own witnesses yet, has said he was not there. So let me ask y'all that. What evidence has been provided that he was not there? Y'all tell me that. FDB said Ksoo needs an actual alibi to prove he wasn't there. He's been placed on the scene with the weapon during the crime and fleeing the crime scene with the weapon. That's a wrap, kids. Exactly. Where does it say he was not there? I'll wait. Betty said people change, I believe, but yes, one person is all that's needed. Ksoo doesn't have any alibis, Mickey. Right. So I need everybody that's on the side that Ksoo wasn't there, didn't do it, and there's no evidence. Then where is the evidence that show he was not there? What evidence has been provided from the defense? The defense done went through 3 witnesses. Oh no, is it 2? No, 3. 2? I don't remember. 2 or 3 witnesses since yesterday. Have they proven that Ksoo wasn't there? So Angel said, I don't think, damn, y'all commenting quick. I don't think the defense is fighting that he wasn't there. They are causing doubt to if he committed the murder. So, I mean, whether he's a shooter or not, by placing him there is sending him up the road. He's guilty. Y'all gotta remember that. Scotty is not accused of being the shooter. He's accused of being there, being part of the plan. This is premeditated murder. So by not putting in that Ksoo wasn't there, he's gonna still be found guilty. It has to be unreasonable doubt that he was there. The only doubt, now this is my opinion, y'all can say y'all opinion about it. The only reasonable doubt that they have placed is that it possibly was another shooter. But other than that, it still doesn't change the fact that Ksoo was there. Where we at? So what is his so what's reality said? What is the lawyer arguing to get him off? That basically he doesn't fit the description of the shooter. Jeezy, yes, Scotty phone ping that. Y'all going so fucking fast. I can't even keep up. I gotta look on my phone because the screen is going too fast. I can't keep up. Yeah, Scotty phone ping at the lady house and his DNA was there with butt snitching. He cooked. Okay. Yeah, it's really not much that Scotty can do on that one. I don't think his defense did a good job causing doubt. Yeah, I will agree that on the burglary, Scotty is definitely going to get found guilty on that for sure. Now, I'm not 100% sure about the murder charge for Scotty, but that burglary charge that he's on trial for right now, definitely. Betty said they are forgetting about the digital expert. I think a lot of people just not agreeing with the digital video expert, Betty. Like I told y'all, the fact that he could not exclude him as the shooter was definitely strong for me. But, you know, some people are saying it's not reliable. So I think people are 50-50 on that. Ruben said, I think the height is a good argument. I said that too on day one, and then as we went on, everybody was all over the place with the height. So me personally, if I was on the jury, I wouldn't even be listening to height no more because it's just too much of a range between the height differences. Like nobody said the same height. So it's just all over the place. I wouldn't pay no attention personally. What's reality said, but she's not trying to prove to us who the shooter would be to make us believe it wasn't Ksoo. Well, like I said, on Blue testimony, Ksoo's defense did ask Blue, showed Blue a picture. We couldn't see it, but the court saw it. Showed Blue a picture of Chris Brown and went over the description that was provided from the original witnesses of the shooter. And according to Blue saying yes to it, he did fit the description, although Blue still said it's Ksoo, it's not him. Where are we? Econ said the height from eyewitnesses is overridden by the digital expert. And I think it's gonna be based off the type of people that's on the jury. Because if it's people on the jury that get hung up on technicalities like height, they might have a fighting chance. Like if the truth team was on the jury, we would have a hung jury because a lot of y'all are hung up on the height. But if they have people that can overlook that and look at the full story, yeah, they're gonna be done. But if they have somebody that's hung up over height, then that's gonna be an issue. Where we at? Easy S said Scotty was in the car, so he was on the scene. Plus, he did the robbery. Yeah, he cooked in both charges. The only thing I would say, the state did not prove, even by their own witnesses, that Scotty knew of the plan. So some people may give him leniency on that, and some people may be like, "Yo, you was with them niggas, so you done." So that's up in the air. I'm gonna be honest. If I was on the jury, I probably would vote not guilty for Scotty for the murder, but guilty for the burglary, just because Butters couldn't pinpoint no activity that Scotty did during, like before the shooting, during the shooting, only after, because they ran in the same direction. So he didn't like provide that he was involved in the conversation about the plan. So that kind of stands out to me on the murder part, you know. So I don't know if I would really say, if I was on the jury, that Scotty was guilty of the murder. I definitely would say guilty on the burglary though, because they did not give a clean rebuttal to why his DNA was on that lady's pants. Where we at? FDB said, in a planned premeditated murder, all participating parties are guilty of committing first-degree murder, not just the shooters. That is true. But I'm like I told y'all, what stands out to me is basically the way Butter told the story is that he was just a body there, right? He said that Scotty didn't say anything or nothing, right? So that's the thing, like, that stood out to me, you know? Cherie said, yeah, I didn't care for additional expert testimony. Great use of technology, but new to me to trust. That made sense. Vonnie said, yeah, that looked bad for Scotty. Jaquan said, you act like Butter a legit believable person. I mean, he's a damn criminal. Telling on a criminal. Why? I mean, like, I don't get that. Why that? Like I really want to ask y'all, why is it so hard to believe a criminal when they tell on a criminal situation? Like, I don't get that part. Like, what y'all don't like? What be wrong with that? Y'all acting like it never happened before. Like, criminals don't tell. Like, why shouldn't? Okay, let me ask y'all this: why shouldn't I believe Butter? Why shouldn't I believe Butter testimony? Now, I broke down the other day exactly why Butter was so believable in this case. But I want to ask y'all, because a lot of y'all in the comments, like, you really believe him? So y'all tell me, why shouldn't I believe Butter? Angel said, I think you are judging case on what you think he is when Buddha is an actual criminal with a past. I ain't judging him on nothing other than what's been presented in the case. I don't care what he is. You know what I'm saying? To be honest, if I was a juror on the thing, I wouldn't care because I would only be looking at what they provided. So a lot of y'all probably just start tuning in, right? But from day one, I thought he was innocent. But as the trial went on, it goes to that. So, like, I mean, I'm waiting for somebody to tell me why shouldn't I believe Butter though. Where we at? Always Awesome Nail said criminals selling on criminals to help themselves are not easy to believe when they are involved in a crime. Let me read that. Criminals selling on criminals to help themselves is not easy to believe when they are involved in a crime. So why would you believe a person that's involved in a crime? That's what, like, that kind of sounds funny. Like, why wouldn't you believe a person that was there? Whether it's a criminal or not, like, why? So basically, like, because you don't believe eyewitnesses. Because, like, why wouldn't you believe a person that was there? Ruben said, I don't condone criminality, but Ksoo should have stuck to the plan. That's probably why Butter tell him. I mean, even if the original plan where Scotty and Ksoo would have got out and shoot, Butter was going to tell regardless, being that he was the only one caught. They couldn't arrest nobody else until Butter started talking. Betty said, right, FDB Butter isn't going to take the stand to clear himself. He will be shredded. Kiki said they have motive. Butter looking at life in prison. But see, the thing is, most snitches are criminals that's looking to get something out of it. So, like, I don't know. Like, it just that still don't stop me believing what he's saying just because he was facing life. Hell, that's most people under pressure is going to tell it. Whether you, like, no matter what your background is, if you ain't built for prison, if you ain't built to do a life sentence, you're going to fold under pressure. Half of us, okay, half of us right now tuning in having this conversation is going to fold if we're facing a life sentence. Like, on some real stuff. Where we at? It's all gravy. Butter lied under oath before Mickey. But did he lie in this case? I told y'all when that happened, they painted him to be a liar, but could not prove near time he lied in this trial. I wouldn't have gave a damn what he lied about before. Did he lie now? They couldn't pinpoint that he lied anything. Did he lie now? No. And I say no because Ksoo defense team couldn't point out where he lied at. All right, where we at? Always Nell says Butter was Daddy's favorite boy and seemed closer to Blue than Ksoo. I wouldn't even say he was the favorite. He was a dude, the dude boy. He did what Blue asked him. For sure, Ksoo's not his favorite. That's for sure. All right, where we at? Patchy, Salmon the Bull was believing he killed dozens of people, so why isn't Butter believe able to some people? I agree with that. Don't be like I said, I told y'all yesterday, at the end of the day, let them take each other out. That's a true saying. So that's why I feel like the jury will believe the criminals y'all say that have these long histories, because let them take each other out. They run in the same pack. They do the same thing. So we're going to use him to get the other one that's out here doing crime, get him off the streets, cut him a deal. That's how I go. Charles Dixon said because he's a rat. Hell, in court system, rats are the best things to have. Yes, tell us what goes on the streets. Tell us, enter the street life for us on this stand while we are in the comforts of our house. So the only people that have issue with rats per se is the streets. People in the courtroom don't give a damn. Tell on everybody. Tell it. Regular people that's working 9 to 5 don't give a damn about somebody telling. Tell it. So I don't think that's gonna play a factor in the jury. Courtrooms love snitches. And hell, at this point, the internet do too. AB said yes, initially it's to get himself out of trouble, but you don't get off, you still get that on your jacket regardless. And based off the evidence, yes, I believe him. I agree with that. Angel said, I think all 3 were involved. Butter did all the research, found his address, and was a hitman. Ksoo is a leader and has people under him. Even though Butter is a killer, Ksoo can't cause more crime. I think Ksoo got involved because of his brother. Abdul Jr. was the ringleader in this situation. Everything points back to him being the middleman. Hold on, y'all. So yeah, I think Abdul Jr. was the ringleader. Kiki said, oh, hold on, y'all. Detective Smith summed up why Butter was informant for the police. Did they say he was an informant or he was just telling? I didn't recall them saying that Butter was an informant. Only Blue was an informant. Did he actually say the word he was an informant? Ruman, Butter wasn't the brains because he had to report back to Abdul Jr. You can't be the brains if you reporting back to somebody. He was the researcher, but he still had to provide the information that he found to Abdul Jr. So he definitely wasn't the brains of the operation. Betty said exactly why shouldn't he be credible? I believe him 100%. Vonnie said, but remember he said yesterday he would have been able to pull off quicker. He think if Ksoo would have followed the plan, Butterfield, that they wouldn't be in that predicament. Yeah, because they would have never had to go to the house technically. I do remember that. It's all crazy. Exactly. Butter ain't want to go down by herself. Yeah. But that still don't say that he's not a credible witness. High Thoughts TV, what it do? I seen you go up over there now. Keep working. AB said, I'm folding, baby. That's why I don't do shit. That's gonna get me in trouble. I agree. Me too. Shit. I stay out the way. Out the way. Okay. Where we at? Jeezy said, I know Blue going to the Hall of Fame for snitching. Hell, he gonna be a free Hall of Famer. All right, hold on. I got to go because I'm so behind. In the comments, I'm gonna skip down some. Where we at? What's reality says? So, what would it take for Ksoo to get found not guilty? I mean, if the jury, okay, so if the jury don't find Butter reliable or Blue reliable, he can get off like that. If they don't believe the star witnesses, he can get off like that. Sharice said why they didn't use the wire at Sally Ward. They didn't need to because Butter told the story himself. The only way they would have had to enter that into evidence is if he got on the stand and started acting like he don't know what they talking about. That's why in a YSL trial, they played so much of Woody's past recordings with the police because he was acting like he didn't know what was going on. But Butter came on there and said everything from A to Z. So yeah, they didn't have to. Betty said rats are credible in court. That's true. Now, let me tell you, if he would got on the stand acting like he was holding back, Butter didn't seem like he was holding shit back. Okay. He said his head was up the whole time. Like, he didn't have no body language that made me feel like he was lying. I ain't gonna lie. Now most criminals are manipulative, but I believe Butter because his story matches up to the witnesses that wasn't getting deals. If his story came differently, then that would have been a different story. But his story matched up with the lady from Express Employment, the lady that got her home broken into, the officer first on scene, the man who recorded the murder. Like, his story aligned with them. BJ said he was just snitching on other cases. And he got a history of telling. And y'all gotta understand, everybody don't believe the system is broken. So to some people, they gonna look at it with shit. If the state using him again, then obviously, he's a good snitch. Just saying. And the fact that he's a repeat offender ain't gonna hold no weight either, because most of them do be repeat offenders, in my opinion. All right. Rumor said he made the plan. Yeah, that's he had to run the plan by Abdul Jr. too. So he was not in charge. Just period. It's nothing that screamed Butter was in charge of shit but driving. E-Cop said, I was on a jury that had a snitch and every single one of us believed him with zero hesitation. Right. Like, just because he's a criminal or he was involved, shit, that's gonna make him more believable. Kiki said Blue said Butter was the hitman to go to when you want a leak done. But he can look. It must be some hits we don't know about, like the defense said, because so far the first one was a dub because they got the wrong person. And the second one, hell, they got the right person, but it was just, Abdul Joint was really into getting him. Yeah, everything had to run by him, so I definitely believe Abdul Jr. was the person. Blue said the street said Butter was a good hitman. It seemed like Butter is a good stalker. He can get that intel. Man, they about to give Butter 50 years. My estimate was 40. I did say I think he's gonna get about 40. Bonnie said all them cook for real, and I fuck with Ksoo, and this ain't looking too good. What's up, Black Butterfly? Said Butter could have an interior motive. He can tell the exact story and replace people at the same time. Sure, it matches. Of course, it would. All the things happen. No one can possibly identify anyone. I'm gonna disagree with that, because how can you say no one can positively identify anybody if he said he was in a car with Ksoo, waiting for the dude to make a move, drove over to where the dude made the move? Like, you can't say he can't positively identify him. He was there. Like, he saw him before he put his hoodie on. So, like, being that he was in the car, this is the thing. If y'all didn't know his background, right? Somebody says, yes, I was hanging with this guy, waiting on the victim. Me and this guy got into the car. We went to where the victim was located. I saw the guy get out the car. I saw the guy get back in the car. We drove off and then we ultimately crashed. Y'all mean to tell me y'all gonna say that's not believable? If y'all didn't know Butter background at all, and somebody told that story, y'all mean to tell me y'all wouldn't believe it? Come on now. Come on now. Where we at? All right, hold on. I gotta scroll down some more. I had got behind. JC said, if he already knew his daddy was a snitch and had been a snitch for years, why would he even consider involving his dad in anything illegal? His dad just sold his son out for 10 less years. I don't think nobody knew. Most times nobody don't know until they hit the stand. Most informants don't have to take the stand. So yeah, I don't think they knew, to be honest. Johnny, you gonna have to go back. Why you believe, but you got to go back. I done said that 100 times. Where we at? FDB said in court they call witnesses not rats. Most witnesses to crimes are criminals themselves. It is not uncommon to be convicted based off co-defendant testimony. Facts. I agree with that too, FDB. Black Butterfly said, right, Mickey, he identified them. I'm talking about the lady at the store, the cops said are not Butter. I'm missing your point still then, Black Butterfly. Cause you saying that nobody identified him, but somebody did. Y'all don't supposed to like when you look at the trial, and I know this is just us doing it in our leisure time, but like you can't just look at it and look at hold one piece of evidence as like the heaviest weight of everything. You gotta look at everything. So although nobody could identify Ksoo by face that wasn't involved in the case, doesn't mean that the storyline is messed up for his involvement. Now, that's how I just look at it. Cause like I don't really get what y'all keep saying when y'all saying none of the other witnesses could identify him like that. I mean, I don't get it. I don't get it. I don't know. Maybe I done been doing this too long for leisure and in real life. Maybe I'm missing it. Y'all don't gotta explain to me what I'm missing because I don't really get what y'all mean. Like just because the other people couldn't identify him, make it less. I don't know. I don't even know how to explain the question because y'all kind of got me lost. I ain't gonna lie. Because I'm still waiting on somebody to tell me why Butter ain't credible. I think only one person said because he lied in the previous case. Other than that, somebody tell me why we should not believe those of us who believe Butter testimony. Why we shouldn't believe it. Now, if y'all ask us why y'all should believe, we can answer it. So I need those who don't believe but a testimony to tell me. How is court back in session? Back in session on what channel? I'm on my phone. I don't see it. Nothing is back in session. What y'all talking about? I'm on my phone. No, it's 2 news channels that's running it. Nothing is going on in either one. So what y'all talking about? Like nothing is playing on either one. You only see the carpet on News Jet. So what y'all talking about? Y'all done had me jump up. This is First Coast News that we're watching. They still got their blue screen on. What are y'all talking about? First Coast News not playing. Oh, y'all done threw me off. I don't even know where I was in the comments. Oh, where we at? Cherie said, you're saying it right, Mickey. That's why jurors can't discuss among each other until everything's presented. Each piece count. Facts. I see they trolling because I'm like, what the hell? I'm like, I try to stay. Y'all know I jump and go up to the other news, but yeah, I'm like, they ain't even saying nothing. Where we at? Betty said police officers are rats, but credible in court sometimes. Black Butterfly, what witness other than Butter and Blue did a positive identity? How do we know the story is right, but the shooter was Chris? Because the two witnesses that was part of it said it was Ksoo. Now, if you was on the jury, Black Butterfly, you could say, well, I don't believe Ksoo was the shooter because of this. That would be all right. But you don't have to have any other witnesses. Blue and Butter is enough witnesses. It will be up to you as a juror if you believe them as telling the truth. So, like I said, the cases spread out by the state. The cases like done. They did a job painting the picture. It's up to a juror to say if they believe Butter and Blue. But you don't have to have nobody else besides them. Now, being that you think that Chris could be the shooter, like I told y'all the other day, the defense did good on Blue testimony, causing reasonable doubt that possibly Chris Brown could be the shooter. So, Black Butterfly, if you was on the jury, then you would have reasonable doubt and you would say, I don't believe Ksoo was the shooter. Cool. But nobody else got to be in there saying they saw Ksoo. Because regardless, even if the lady from Express could have said, yeah, I saw the shooter's face, he was Ksoo, you would still have in the back of your mind that it could have been Chris Brown. Because just because a criminal is the one or a snitch is the one that's saying it's somebody, you mean to tell me you would disregard Chris Brown if the lady from Express would have said it was Ksoo too? Because if that's the case, if you're saying if another witness said Ksoo, you would disregard the fact that Chris Brown fit the description just because it was a different witness, that means you're biased against snitches, you're biased against criminals, and then you shouldn't be on the jury. If that makes sense. Where we at? Betty said Chris Brown wasn't in the car. I done got behind too. I'm trying to catch up. What's up, Blue? Blue said take your feelings out of it when watching Ksoo. We want Ksoo to beat the trial. I ain't gonna lie now. I'm be honest. If Ksoo really did it and shot that boy face off and teeth on the ground, hell nah, keep his ass in there. Cause he gonna do it again. Now if it's not him, then I hope it go the right way. But I ain't gonna say all that. Whoever did it need to stay their ass in jail, okay? Or go to jail because shooting somebody's face off is crazy. Parker said Ace can't go back to Florida, and now they trying to do bull to Ksoo. The prosecution haven't proved that Ksoo was there either. Yes, they did. They put Butter on the stand. Ksoo was there, according to the state's case. The question is, did the defense prove he wasn't there? Kiki Mickey, did you go back yesterday and listen to Sergeant Smith? No, I ain't gonna lie. That's why I ain't drop a video yesterday. Cause I went back to sleep. I ain't gonna lie. It was storming. I went back to sleep. Always awesome nail said, but did they go check any creek? That's what bothers me is lack of actual investigating. I don't think they checked no creek. Now, yesterday with the Sergeant Smith, that definitely was a good one. I missed most of it because I had fell asleep on the second half. But yeah, the investigation, they definitely had tunnel vision for sure. I agree. They definitely had tunnel vision with the investigation, and that came out yesterday. Kavan said, I know I said your name wrong, said, who is to say Butter wasn't the actual shooter and to save his own ass saying it was Ksoo, ring the police wants Ksoo so much more. He didn't have no hair. Like he has hair now. He ain't have hair back then. But I see where you're going with that. But that would be a stretch for me. But well, technically the jury shouldn't have known that he ain't. No, because they showed the picture. So yeah, they would have known he ain't had no hair. He been locked up since the day of the shooting. You know. Black Butterfly said, yes, Mickey, now you understand what I'm saying. I personally have reasonable doubt, but respect those who don't. I'm biased against liars because liars I have no limits. Okay. Well, that means you would never believe anybody. Because I don't care how honest you may think you are, you have lied before. And lying one time makes you a liar. Everybody has lied before. Whether you claim it as a small lie, white lie, everybody has told a lie. Everybody. So if your bias against liars, then you should never be seated on the jury because everybody should be a liar to you. Because everybody has lied. So I respect that. Just don't be on no jury. Please. Make sure you excuse yourself from juries. Parker said it was more people involved that the detective could have interviewed, but instead they put it all on Ksoo. Well, according to the storyline that they're going with, they ain't have to interview nobody else. Now, if you was on the jury, you could say they give you reasonable doubt that they actually investigated correctly, and you can put not guilty. Dior said nobody other than the criminals are saying Ksoo. And remember, Dad said if I didn't say Ksoo, I get life. They pressured them to say Ksoo. I mean, you can put it that way. I really doubt anybody on the jury gonna go with that, but you can put it that way. What's up, picture this and that? Please go listen to the Detective Smith. I got to make time for it, to be honest. I don't know. It may be after trial or something like that, but I doubt being on here for 8-9 hours. I doubt I'm gonna go back anytime soon. But when I do, I'll do a video on it. And depending on what happens today, you know, I may have time today, but yeah. Jaquan said, Mickey, so believe in Butter that Ksoo was there. So you are ruling out the possibility of Butter being the shooter. Mickey, how you know Butter? Ain't that the shooter? Oh, but you believe Butter. Most of your comment don't make sense. What I said is, I do believe his testimony, right? However, when it got to Blue, the defense did poke a hole with the Chris Brown. Now I said, being that we heard Chris Brown name come up throughout the whole case, that does give some reasonable doubt. No, I don't believe Butter is the shooter because he doesn't fit the description at all. He didn't have hair. We saw that. So if you're saying that Butter was the shooter, then you're not paying attention and we need you off the jury. Boom. Because how now? And then let me ask y'all this. Y'all be like, oh, the witnesses said the height is different. So now you're saying if you think it's Butter, that the witnesses made up hair on his head? Like, you know what I'm saying? Like, come on, it don't make sense. FDB said these folks don't know how the court system works and they are Ksoo fans. The reality is that the testimony offered in court has them convicted. The only hope for freedom is for jury nullification. Yeah, I do. I can tell, and I be trying not to like pinpoint it because I know everybody doesn't understand how the legal system works. But it is, good conversation. Patrick said we all liars. I have lied before. You right, Mick. I'm telling you, that's true. Always Awesome Nail said, I think you were asleep yesterday when the defense brought up to the detective that he started pulling stuff on Ksoo 2 days after, even though he wasn't a suspect until Butter told months later. No, I was up during that part because they found, well, hold on. I thought he was talking about Scotty. So with Scotty, they did say that his DNA was in the car. They knew that beforehand. And his fingerprint was on the gun. They knew that beforehand. but they couldn't arrest him to after butter because you need an eyewitness. You can't, like, this is the thing. Trials is all about people verifying physical evidence. You can't just have a trial with physical evidence. You have to have people that can verify it. So I was up, and then they said that they also pulled Ksoo's Instagram records. Remember, Ksoo fingerprint was on the gun, the 9, was that a 9, whatever, the handgun. Ksoo's fingerprint was on that. And regardless, I didn't believe the detective when he said he ain't know who the hell Ksoo was. Okay. Like, I'm pretty sure you're a Jacksonville officer. Remember, the Jacksonville sheriff already said it's a whole ATK task force. I do believe he was capping on that. Okay. So he knew the history with them. So I definitely believe that he was capping on that. Is the state asking for death penalty if he found guilty, Mickey? No. What's up, Leah? Leah said the only thing that doesn't make sense to me is Colin saying he didn't see 3 people in the car. Nobody saw Scotty in the back seat. Then he just ended up at the lady house. Yeah, that was weird. So Colin's whole testimony was a little like shaky, but yeah. Black Butterfly said, I've never said on the stand in court and lied. If that's normal for anyone, it's okay for them, but not me. No, you can, but see, when you say people, this is the thing. Technically, if we be technical about it, Butter never lied on the stand. Butter lied in a deposition. So, I mean, it's still under oath, but technically he ain't lied on the stand before. This is first time on the stand. Because like they said, in 2017, the dude ended up taking a plea deal, so he didn't have to take the stand. You know what I'm saying? So, I mean, you can take that as you want. And it's cool not to believe liars. I just feel like if you don't believe liars that have ever lied, period, because you didn't just say that people that lied in court before. You said you don't believe liars. That means you're biased. You don't need to be on the jury. And even if you change it and say you don't believe people that have lied on the stand, you should never be on the jury. Because you never know what witness. It didn't even have to be a criminal. It could have been a mother that said she lied for her son on the stand in 1990. But guess what? According to you, you still won't believe her now in this situation. So, I mean, I get it. And it's cool. But you just should never be on nobody's jury. Because, people have lied before for whatever reasons. Me personally, I don't like liars either. Especially people that just lie all the time. However, I will believe a liar in certain situations depending on what they say. Because again, it could have been a woman that got on the stand that was facing food stamp fraud and lied that she never lied on the application. According to your logic, you still not going to believe nothing she had to say in a murder case because she lied on the stand about food stamp fraud. So that's all I'm saying is like that's too biased for a person to be on the jury. Not saying you're wrong for feeling that way. It's just that's too biased. And I hope nobody on the jury feels that way because that would be too much for the legal system. We got to have unbiased people on juries that can put their personal feelings aside and look at what evidence was presented. Now, again, you may never have to report to jury duty because in my whole life, I think I only went one time and I was so mad I didn't get picked, but you gotta be able to put it aside, Mickey, I'm not changing. Hold on, what I can't read. Mickey, I'm not changing anything. I speak in reference to the situation. You can only type so much per comment. Yeah, I'm not saying you're changing. All I'm saying, you clearly already admit that you're biased, right? But I just feel like you're limiting how you're thinking about the situation because you're pinpointing that somebody that lied on the stand, you can't trust their testimony. And I just want to put out there that it could have been many things that person could have lied about. And I use the example of a mother lying on the stand about food stamp fraud, but then she becomes a witness in a case of murder. And based off your logic, then you wouldn't believe nothing she said in a murder trial because she has lied on the stand. And I just think that's real hard to have that type of standing on business. That's a lot. Because you would definitely let a murderer walk just because you didn't believe a person that had lied before on the stand. Not in the case that you're a juror on, but in a previous case. You know, I just think that's fucked up. I'm just gonna be honest. But that's just my view of it. You know what I'm saying? Ebony said, my mom got picked for a murder trial. She was grazed in the face by a bullet in the 90s in her car as an innocent bystander driving. Ooh. Sorry to hear that. On here go Orange Crush back again. He still cook in the next trial for Bibby. But we won't know till that trial happen. They don't have the murder weapon. No, they don't. If someone lies about food stamp fraud and comes to another food stamp fraud case, no, I would not believe the person in the same circumstances. Black Butterfly, you changing your tone every time you comment about it. Like, it's either you don't believe liars or you believe liars. Because now you're saying if the person lied about the same situation, then you wouldn't believe them. But if it's different, you'll believe them. I don't think you really being honest.
He has had conversations with the defendant that were letting him know that the trial was going to happen. And then the discussion about testimony came at the end of last week, was his statements. Or over the weekend. It may be over, but I'm not 100% on that. Regardless, his European trip was canceled in, I think he said Sunday, maybe the weekend it was canceled. And so today's Wednesday. They have made no arrangements for him to be here. He certainly has the financial wherewithal and otherwise for him to be present here today. He is not present here. He is in New York on Zoom. I normally wouldn't object, but I'm objecting for a slew of other reasons, and that's just one more on top of it. The dealing with Zoom in terms of showing of evidence to the witness is very difficult. We had some difficulty even in depositions accomplishing it. And all of these things have been known for the defense for a long time. We are objecting to their testimony in entirety, but I have to acknowledge that I have deposed them now, and I know generally what they're going to testify to in court. Other things beyond our strategy, beyond going and doing background work and all that, I can't accomplish any of that, but I do know what they're going to say. The court is inclined to allow them to testify. The state would ask for the remedial measure of letting the jury know that these names were not read to them. They were not listed by the defense. They were, we learned about they were listed by the defense last night, and there has to be some negative information given to the jury in instruction that these names should have been given earlier. There has to be some penalty for doing what the defense has done. If the court's not inclined to strike, which is what the state is asking for, we ask for that penalty to be some instruction about the late disclosure, which is not the state's fault. It has prejudiced them.
All right, I'll hear from the defense as to the alternatives this court has, because as I see it and as I've thought about it, we took an hour and 15-minute recess to allow the state to talk to these individuals. I've now heard from the state about the remaining prejudice, even having now talked to the individuals. I could recess this court or this trial for the rest of the day into tomorrow to give the state an opportunity to conduct the investigation that they are entitled to conduct of these witnesses. I could grant a mistrial, as your case, Ms. Kawas, that you provided to me indicates I could do. And for the record, I will state that if a deposition during a break in the trial was insufficient to cure a procedural prejudice to the state, then the trial court should have declared a mistrial. That's the Second District Court of Appeal in Mosley v. State. Actually, I'm not sure if you gave me that case or I found it on my own perhaps, but it's 182 Southern 3rd, 797. But the other cases that you provided to me do talk about the alternatives. That is brief recess, day recess, mistrial to allow the state to then rebut or get witnesses or present their trial or case, now given the testimony of these two witnesses who have never been listed, have never been deposed, and have not been investigated. These are all options I've been considering. I'm sure all of us can agree, none of us want a mistrial. I saw you shaking your head no. We've been here now, we're into our second week. It took 3 days to pick these juries and then to have this. So I am mulling over what should be the applicable sanctions. I've heard of something new. I've not ever heard of that before, Mr. Mizrahi, advising the jury that these names were not read to them, which they weren't at the beginning of jury selection, despite my court order asking for the names to be provided of any possible juror that might testify in this case. That, again, was in my trial order that I entered and that all parties received on February 19 of 2025. So tell me, what alternatives, what sanctions, what should I do from the defense perspective?
So, Your Honor, first, I did not hear the state move for a mistrial, because that is the remedy that they wish to see. So they didn't move for a mistrial. I still haven't heard any articulable prejudice other than we're not able to run background checks. They are the state of Florida and have an entire agency that works for them. I can advise them that Robinson has no bias. So I still haven't heard any prejudice, real prejudice of what they would have done. We did make them available. Mr. Mizrahi had all the time in the world. He was limited in the questions that he was asked. I advised him of the scope of where I was going with these witnesses. He went way outside of that, was able to show them evidence that has been admitted to the trial, offer their opinion. There was nothing prohibiting him from asking anything he wanted. So him just not being able to go into the background, I don't think that that's a prejudice, Judge. The request to ask for a special jury instruction that the defense somehow violated the law is not supported anywhere in law, and I would say that that would constitute reversible error. But then to give an instruction from the judge in the form of jury instructions or an admonition by the judge is going to create, I think, more undue prejudice than anything.
Well, let me ask you this, because I'm agreeing with you that a negative inference admonition, I don't know that I agree with that, but these names have not been read to this jury. And at the very least, I think I should, before these witnesses are called, simply state 2 other names of potential witnesses were not provided to you when we selected you all last Monday. I need to know if these jurors are related by blood or marriage to these witnesses or know them from any business or social relationship. Because if they are, I'm not going to allow that witness to testify if it's going to affect their ability to be fair and impartial in this case. And that was not inquired of them last Monday, because we did not have these names last Monday.
And Your Honor, I would think that that's okay, because that's something that the court has done. You know, at the beginning, I don't think that that would have any negative connotation. It's just, you know, it's come to our attention that there are 2 other potential witnesses. I need to read your names, if you could provide them. It's free cross-examination for Mr. Mizrahi to say, the first time that you spoke to defense counsel was 2 days ago, or something. He can say that, you know about this, although he opens that door, it's free game for you to say, the state has never come and spoken to you, even though they know that you are being daughter. So I am trying, Judge, to make sure to avoid any undue prejudice on their part. My intention is to limit it to that particular testimony, and if the court allows them to testify, obviously if they go into an area of cross-examination that then flings open the door, that I would allow to go back. But I still, as we stand here today, Judge, if they need more time, obviously I don't want to stretch this off, but if Your Honor is left with, I'm going to refuse to allow them to testify, or I'm going to break 7 days so the state can do whatever investigation they want to do into these 2 individuals before they take the stand tomorrow. That I would think, I don't think they need it, but obviously I understand, Judge, I would probably make the same request if that was done in reverse of a surprise rebuttal witness. For example, if they were intending to call someone that wasn't listed to specifically impeach the witnesses that we put on, we'd be having the same discussion, and we didn't know we were going to call them until we put on your defense witness.
But you, at least from what I just heard today, are you acknowledging that as of 2020, each of these 2 witnesses told you all that they had viewed the video and that it was their opinion that it was not Mr. Hakeem Robinson in that video?
So Your Honor, I was speaking to Ms. Robinson back in 2020 as a family member to my client. To be honest, every one of them, pardon my language, said guess I spoke to her before, and I basically was like, hell no, that's not my brother in the video. It was said in passing, not in like a formal, hey, listen, so you have this information, and I'm going to now list you as a witness. It wasn't like that with Mr. Scotty, Mr. Scotty was making it seem it wasn't. That's the conversation I had.
And with Mr. Shapiro?
Mr. Shapiro, after the bond hearing, all conversations with him have been with Mr. DeCoste. As Mr. Shapiro said to Mr. Mizrahi on the oath, the conversations leading up to with Mr. DeCoste talking about this was letting him know the case is going to trial. It wasn't about him testifying. He actually said on the oath, when Mr. DeCoste asked me about testifying, it was 2 to 3 days ago, which it was a square within the weekend, which is right after being testified, and we were scrambling on what we were going to do with that. So, and your representation by Mr. Mizrahi, then he said, oh, he was in Europe and he canceled her last week. He just said on the oath he canceled his trip Sunday. So, Judge, had we had the opportunity to fly him down here, we would have made those arrangements to do so. But Mr. Mizrahi, when we brought this to his attention at sidebar on Friday, that we would bring in Mr. Shites, didn't say, well, that happened here in person. They had no objection to Mr. Ahmad appearing by Zoom over in a completely different country. So they wouldn't have had any other problems showing her pictures or anything like that. And what he says about Mr. Shites is they're so adamant and now locked with this objection, because just like we did yesterday when they spoke, we didn't object to certain things. I'd expect them to extend the same courtesy to Mr. Shites. If the court is going to recess, we have to scramble to put him on a plane to come down here and question him about what his schedule is like. He is available to testify by Zoom today. And that was something that would cause a recess. So, Judge, in this moment, I don't think a recess is necessary because I haven't heard really any prejudice other than his guy in today's case. We won't be able to find something to impeach them with. It just sat down with them and had all the time in the world. Not sure what it is that they haven't shown them already that they would use to be able to impeach them. They have free range talk to them just now. So, in my opinion, I think they should be allowed to testify. Anything about them being listed names, Your Honor can just ask the names. They can bring out in cross-examination that, oh, you spoke to Mr. Colas in 2020. I mean, if he brings that out, I would be able to say, what did you tell me in 2020? That your immediate reaction when you saw that video was, hell no, that's not my brother. So, that's basically my position, Judge. Obviously, it's within your purview. I think exclusion is absolutely way too far of a, especially in these cases where the ultimate issue is the identity of the shooter, and they face basic testimony that we're seeking to introduce square within the realm of these witnesses, because their last witness last week, family member of highly confused. And Mr. Shites also was very clear, Your Honor. He spent so much time with Mr. Robinson leading up to the day of murder. So he does have the requisite knowledge to offer his opinion. And he was so candid. He goes, listen, I'm not an expert. This is just my main opinion from what I know of who Ksoo was back then and what I saw on that day.
And since Sunday, I guess, because there is an objection to Zoom testimony, and obviously Zoom testimony, I allow if both parties agree to it. Otherwise, this is a criminal proceeding. Witnesses are expected to be present unless there is some undue hardship or some other reason why the witness can't be here. Obviously, the woman in Jordan is, I think by all accounts, and both parties agreed, that's an undue hardship. And by the way, she was on Zoom earlier at 10 o'clock when we were speaking. So she was there. I just wanted you all to be aware of that so that your decision not to call her wasn't because she wasn't on Zoom, because she was. Okay. But as to Mr. Shipes being in New York, at least as of Sunday, what efforts have been made to get him here, and or what undue hardship exists that he can't be here because there is an objection to him testifying via Zoom?
So, Judge, after the ethics came to bring him here, we weren't going to fly him down here when they have been adamant that they would be objecting. So there was no ruling by the court. The state didn't have to litigate this before when we were brought to. So I'm not going to make arrangements and spend all this money to fly him down here for the court to say he can't testify. And we actually learned last night at 7 p.m. that he wasn't in Europe. He was planning to be in Europe, Judge. It's just that he had told us one of his artists that's
All right.
Your Honor, I can share on the hardship thing, at least know the part, I don't speak in a lot of constructive parties. Variety did a recent news article, this supports what I'm about to share with the court.
I'm not relying on a variety article.
Oh, no, just.
Okay.
What it is as to the hardship, that he had just sold a common pilot in Movers.
Okay.
To FX, and that is one of the projects that's being worked on. And I'm just sharing the hardship with Your Honor, that was at least, I didn't have a full conversation as to hardship, but that was one of the things that has him where he is right now.
In New York?
Correct.
Well, isn't that where he lives?
I believe he is.
Or LA and New York? I think, I don't know. When he testified at the bond hearing, those are the two locations he mentioned.
Correct.
Okay, well, I don't know that that qualifies as a hardship if I were to believe the Variety article, but thank you for that. I'll give you one last opportunity to explain to me then, given what Ms. Kawasas just said, what is the prejudice to the state? Because let me say this. Again, Richardson hearing, I got to make 3 findings. Was it inadvertent or willful? I'll tell you right now, I'm finding it's willful. Was it substantial or trivial? I'm finding it was substantial because this is significant evidence that is now being introduced that was never listed. These witnesses were never deposed. It was known about since 2020, apparently, that these witnesses have seen the video and don't believe that it's Mr. Robinson, but I still need to determine what the prejudice is to the state. You've now talked to these 2 witnesses.
Yes.
You're asking me to strike them. You understand if the appellate court decides I have stricken them inappropriately, we are doing this trial all over again.
I understand, Your Honor, and that's why I gave up the other proposal about some type of instruction about these witnesses were not named and listed. There has to be a consequence in the state's opinion for this. The prejudice is perhaps we don't call Abdul Robinson Sr. Perhaps we don't ask him the question about seeing the video. I don't know those answers. We didn't have this information. If we had multiple witnesses that would have come into court and said, that's not him, or we knew somehow that was going to open the door to a listed witness that had that, that's a strategic decision the state can make and say, well, listen, we're not going to go into whether or not people can identify a hooded masked individual on a video. But because there was nobody listed, we had no idea that any of this testimony was going to come. We said, well, I mean, if Abdul says he can do it, let's put that information in front of the jury. That's the kind of prejudice that can't be undone with time, with effort, or not asking for a mistrial. The state would be highly prejudiced by that, and that the time and expense and effort it is to go through all of this. So I'm trying to come up with the ability to give the defense a fair trial. And by the way, the testimony from Abdul Robinson Sr. is ripe for arguments about his ability to make the identification that he made. Just like the cross-examination, the testimony of these other witnesses is ripe with that. I mean, I think everybody acknowledges looking at a fully covered, masked individual from behind, from a dash cam video. The weight of this evidence, I don't think it prejudices the defense that much to exclude them, but I understand the court's apprehension. I'm apprehensive about it. I believe that there has to be some indication to this jury that these witnesses were listed late by the defense, and there should be some type of negative inference. I can tell the court, I hate to do this, but I'm going to do it anyway, that I had a case where we listed a witness late, and the court's ruling was you can call the witness, but I'm telling the jury that you listed the witness late.
Did the appellate court ever pass on the propriety of that admonition?
It did not.
Okay.
So I have no case law support. I believe the defendant was found not guilty, so there was no appellate court.
Oh, okay.
I think that the instruction inured very poorly against the state. So I can let the court know that. We should probably win in this case too. There's probably a way to word it more innocuously as opposed to not criticize the defense. I don't. There's nothing more in the next 6 hours that the state is going to do to change our position. We'd like to move forward. And I don't want to recess this jury any longer than we have to. But we believe there has to be some consequence when they intentionally, knowingly withheld this information allowed the state to go forward and state his case in chief, and then sprung these witnesses on.
Well, I don't disagree with you there. I am not at all happy about the proceedings as they have unfolded today, because we are all supposed to operate under our rules, under our laws, under our code of professional conduct. And springing the defendant's sister, by the way, who he has known has existed this entire time and who has been available to the defendant and his counsel since 2020. It's similar to the Scott case, which the defense provided to me. 17 Southern 3rd 766 from the 4th DCA, where the defendant's sister, who'd been willing and available all throughout the pendency of the case, was sprung on the trial on the prosecution at the last moment. In this case, was excluded, and that was affirmed. I'll state specifically, as the Westling Court stated, and for the record, that's 877 Southern 2nd 877. That's a 4th DCA case from 2004. That the witness was not newly discovered. It wasn't as if they just found the witness who had been unknown to them. It was the defendant's sister. Her whereabouts were known. Her willingness to provide information that was favorable to the defendant was known. But the defense provided really no justification for the 11th hour disclosure. That being said, I don't want to risk this case being retried. I am not going to strike the defendant's witnesses. I understand what I have ruled so far, but I gave the state an opportunity to talk to them. At least you have. You've deposed one. But let me say this. Their testimony shall be limited to what you've said it's limited to. If it's for impeachment or for rebuttal as to the identification of the video, that is all that is coming. Don't be delving into other areas that we have not discussed here already or that are not proper impeachment. Because as I recall from Mr. Shipes or Mr. Shapiro, in his testimony and bond hearing, he would keep saying, oh, he's a good kid. He's of good moral character. He's not violent. He wouldn't do that. As you well know, that is all completely inappropriate, inadmissible evidence during this trial. You ask him pointed questions and I expect distinct answers, or I will be sustaining objections as they're made, because he was going above and beyond the things that he was saying before. But tell me with specificity, because now if I'm going to allow the Zoom depo over the objection of the Zoom testimony over the objection of the state, what difficulty or what do you need to present him with? What documents, so that we can get those to him ahead of time or send them to him now via text or email or whatever it may be? Because I do know and recognize the difficulty in showing a witness on Zoom an item of evidence. We can't show them.
I believe I can share a screen on Zoom.
Okay.
I believe I can from this. All right, so I think we can set it up.
Will that appear appropriately on all the jurors' monitors and everyone else? Okay.
So I think we can share screen. I won't be able to use the physical evidence as well, because that you'll have to hold up to the camera. But I think most of what I need to show.
Yeah, and where would the camera for the Zoom be? Is it that one back there?
It will be on wherever we put it on. Yeah, it'll be that. Sure.
Right, so no one can hold up a gun or a rifle or anything up to that thing.
I'll figure it out, Judge. I mean,
Does the Elmo show on the Zoom screen?
We can put whatever we want on.
Okay.
I mean, we had a little bit of difficulty in the depth I was holding up to the camera.
I understand.
These are problematic things. I appreciate and respect the court's ruling.
I am, however, going to tell them the names of the witnesses, because I do need to know if they know them or not. I'm not going to say the defense failed to disclose the witnesses. I'm just going to say 2 additional witnesses have, let me see how I'm going to say this. 2 additional witnesses have just now been made known to the court, whose names I need to advise you to make sure that you're not related to them by blood or marriage or know them from any business or social relationship. And then I will say their names. So I do need their full, complete names. What's Miss Robinson's name? Can you spell it for me?
I sent it to
And then Mr. Shipes, AKA Shapiro, what's his first name?
It probably should be read Shapiro, also known as.
Okay,
It's Shapiro is his real name.
all right.
Okay. Are you ready, Your Honor?
Yes.
And so I believe it's pronounced Shardeja. Shardeaja. The initial K, and then last name Robinson, regular stuff.
Okay.
And Your Honor, if I could post her testimony, just to make the same request that I have with other civilians, if her face not being placed on it.
Okay. We'll be sure not to show her face on the camera if we'll adjust it. Is that who you're calling next, or are we calling Mr. Shapiro? All right. Do we have Zoom ready?
Do not, Your Honor.
We do not. Okay. Well, do y'all have the number to give to our IT folks so we can get that set up?
I understand he's already on. Is he? Let me go check.
I don't see anyone on Zoom.
Let us Zoom now. I'm going to admit you. Go ahead and join. I'll admit you. I can make it cool.
Yes. Uh-huh. The Elmo cannot? Okay.
Whatever else is on the computer, yes.
Okay. Well, let's hope resolve that.
All right, so real quick. So they don't, if you get subpoenaed for court, you don't get perjury. We found that out with Butter. So they don't get perjury if they're subpoenaed to be a witness. We found that out early on. And yeah, so I think the remedy to yesterday's situation, remember they wanted to call the mom, but the mom has been in the courtroom every day. Remember, the defense was the one that brought them in. The sequential, I know I said it wrong on the case. So I guess their remedy was to bring in the sister instead. Because remember, yesterday was the mom, but today is the sister. So the sister in the record exec will testify, but they have a limited scope. Remember, they're supposed to be rebuttal witnesses, impeachment for, I believe, Blue, really. Yeah, I think it's just Blue testimony, but it's gonna be real limited. So we'll see what they got to say. Y'all make sure y'all hit the like button, share the live. They should get back started in a minute. I gotta walk off from the computer real quick, but I'll be right back.
All right. Good morning, Mr. Shipes. Can you hear me? And no, you can't see me. Hold on.
I can see.
Okay. I'm fine, thanks. So our jurors are not in yet. We're trying to get this set up and bring them out so that you can testify. I want to be sure that you can, A, hear and see me. Is that correct?
Yeah.
There's another square that just has me in it. Are you on an iPhone or an iPad? Okay, if you swipe, you'll see all the different squares. Okay. And then there is a square where you should be able to see Mr. Robinson with his counsel seated at counsel table. Do you see that? Okay. And let me confirm that counsel and Mr. Robinson can also see the witness on the Zoom screen. Okay. All right. Anything we need to take up before we bring the juries out? And has Mr. Shipes, I understand Mr. Shapiro is your actual last name? Okay, we'll go by your official name. That he has been advised about what he can and cannot say?
Well, Your Honor, we can do that right now. We've talked about a little bit an abundance of caution.
Okay,
The only lines of questioning that we intend to get into with Mr. Shipes are this: his basis for knowledge leading up to January 15th, 2020, how he knows Mr. Robinson, whether he's viewed the dash cam video, what his opinion is on the shooter in the video. And Your Honor, there was another thing that we discussed. I'm not trying to throw this in now. We did discuss it. It impeaches Mr. Robinson. Mr. Shipes is the one that signed Mr. Robinson or Mr. Shapiro. And Abdul Robinson Sr. said that he was, involved and he was managing it. And Mr. Shipes, his only testimony is he may have signed paperwork. I never met him. I may have spoken to him once or twice, but that he wasn't as involved as Mr. Shipe was with the music stuff. That we considered to be impeachment. We did talk about it in the back. I don't know if the government objects to that, but that would be the extent. Obviously, the previous portions are the biggest ones.
okay. Any issue with that? I mean, understanding my ruling that I'm allowing this witness to even testify, even though, I'm sorry? Oh, yeah, very funny, Mr. Mizrahi. Okay, then we're going to bring the jury out. I'm going to first ask them about the two witnesses who are now going to be called, and then we will continue with Mr. Shapiro's. Right now, he does not need to be shown on the jury monitors just yet. So if you can turn it off on the jury's monitors until he's... No, you're fine. We can handle that. Then I will have them call him as a witness. He needs to be sworn in by the clerk, and then we'll turn on the monitors before he's sworn, obviously. All right, you may go ahead, tell me now, but I thought he was the next witness. Oh, okay. No, I don't want this jury to take another recess. They've been out almost 2 hours now.
Show her some videos, depending on what their questions are and answers. Obviously, it would be a rehab and strictly to what they ask. I may just build on that if they ask anything specific, but that is it, Judge.
You can redirect based on their cross. Okay. Okay. Then if there's nothing else, let's bring out the jury.
Honor, the jury is entering the courtroom.
All right, you all may have a seat. Thank you. Let's wait for Mr. Whitaker's jury to come in.
Jury's in the courtroom.
All right, thank you, ladies and gentlemen. You may resume your seats. First, I want to profusely apologize for that very extended delay for you, ladies and gentlemen. You know, sometimes things come up at trial that have to be handled by me and me alone, and we take as little of your time as is necessary to be able to resolve those issues. And so please blame none of the parties and none of the attorneys. Put it on me. But we needed to take up some matters outside of your presence. Those have been resolved now. So we will continue with the defense case. That said, I've also recently become aware of 2 additional witnesses whose names I did not read out to you last Monday when we were picking the jury. So I'm going to read them to you now as they are going to testify. And I do need to know if any of you are related by blood or marriage to either of these 2 witnesses, or if you know them from any business or social relationship. On Zoom, and he will be on those monitors in front of you. We're going to turn on those monitors now, and I'm going to ask the defense to call its next witness. All right, let's confirm, Mr. Shapiro, that you can hear me and see me, correct?
Yes, sir.
Can you hear and see the courtroom on your Zoom screen?
Yes.
All right, and can all the jurors see the witness on your monitor? Yes, I'm seeing head nods. All right, if you will please raise your right hand to be sworn.
Okay. Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may proceed.
Mr. Shapiro, if you would please introduce yourself to the jury.
Jonathan Shapiro.
And sir, if you could very briefly explain to the jury about that record label, about what you do in the industry.
Yes.
Have you been successful ever in developing a superstar?
Okay, just a minute. When there is an objection, and I know you're on Zoom, but I'll need you to stop speaking so I can rule on it. Okay, that's all right. So be sure, attorney, since this is on Zoom, that you speak into the microphone so that the witness can hear you. Do we have all your microphones on and working? Okay. All right. And the objection was relevance, and I will sustain the objection.
Mr. Shapiro, let's now talk about your artist, Hakeem Robinson, aka Ksoo. Did you get to know him before January 15th, 2020?
Yes.
How many weeks, months, years did you know him before that date? Now, beyond the trip in New York City, did you ever spend time together? Did you happen to spend significant time with him in December of 2019 in California? Now, these times that you're working together in the studio, was it solely in the studio or would you hang out as well too? Did you ever see Mr. Robinson playing basketball? Did you ever see him swim in your pool? Assuming he was in a bathing suit and not wearing a suit like he is today? Oh, no, you answered it. I was pausing for the next question. So now turning your attention to January 15th, 2020, was there a point in time that you had the opportunity to see a dash cam video related to this case of a shooting?
Yes.
Now, did you come to, based on your knowledge of Mr. Robinson, the time you had spent to him, did you come to an opinion as to whom that shooter was?
Well, I don't know.
Were you basing that solely on the height of the person in the video, or were you taking into consideration all aspects? Were you taking into consideration the fact that you were looking on a screen as opposed to in person? Any of your work within the media industry, does it ever involve things on video? So I don't know if that was a question to me. I apologize. Experience on viewing things on video to see what looks good and what works. Now, put that on me. To change gears now to the last topic of the signing of Mr. Robinson, you signed him to your music label?
Yes.
You were the CEO of that label? What involvement, if any, did Abdul Robinson Sr. have in Ksoo, Hakeem Robinson's career? Did you ever meet him in person? One moment, Your Honor.
All right.
Nothing further, Your Honor. Thank you. That's what it is.
Okay, cross-examination.
I'll use this one.
Yes. As long as you speak into that microphone.
Good morning, Mr. Shapiro. Alan Mizrahi again. I want to show you a series of pictures and see if you can identify them. Mr. Kruger, if you could help me.
Share screen.
Yeah, let me see here. Share, but I want to use the PowerPoint. Do you remember which one it is? We're going to start with this one. I think we spoke earlier today, and I showed you some videos with regard to a gray and black. Can you see that? Are we sharing the screen? And you would agree that you have seen the defendant Hakeem Robinson in this black and gray sweatshirt. And that is Hakeem Robinson in that? Okay. I also want to show you what's been entered as State's Exhibit 230. Mr. Cooper, which one's that? Which PowerPoint's that going to be? Ostrich tags? I got it. All right, do you see that PowerPoint now, Mr. Shapiro? Okay, I'm going to show you a photograph that's contained within that. Eventually. I thought I had it. There it is. The last one, right? Do you see those two people?
Yeah.
And can you identify the one that appears on the right side of the screen? And does that fairly and accurately depict the way he looked in January of 2020? We testified that you spent 3 to 6 months with him in the time leading up to this. But you can't say whether or not States 230 appears the way Mr. Robinson looked at the time of this incident? Right. Okay, well, I'm asking from your memory, is it consistent with the way he looked back then? Do you know the person in the red sweatshirt? I think you said he looked familiar. You saw photographs of him with Mr. Robinson. So before your testimony here today, you've been watching social media about this case? Okay. So we established that. I'm going to show you. Get PC. Defense exhibit. Number 3. I'll try to, it's still sharing. It's going to take me some time to get to that other one. So just be patient with me. Okay, let's see here. Oh, share. Okay, do you see two different pictures now? I have to get rid of you, me. Okay. So the jury can see the photographs. And showing you defense 3, Mr. Shapiro, does that fairly and accurately depict Hakeem Robinson on January 14th of 2020? Does it fairly and accurately represent the way he looked when you were with him in the months leading up to this? Okay. Stop sharing. The other thing I wanted to discuss with you, Mr. Shapiro, is the concept of drill rap. And sometimes, you objecting? Would you agree that Ksoo would sometimes participate in rap songs that depicted violence and death? For entertainment purposes, of course.
Yes.
And that the defendant, Hakeem Robinson, was part of the ATK rap group. Okay. Well, you would agree. I understand. You would agree that Hakeem Robinson and Kenyatta Bullard in the ATK rap group did not like the group 6 Block. You would agree with that? And so 6 Block was a rap group, ATK was a rap group, and they would both do diss songs making fun of the other members' deaths, correct? Sure. But the trash involved the deaths of real people, correct? So it doesn't matter to you whether children are killed as a result of these rap songs?
Yeah, just a minute. There's an objection. There's an objection, Mr. Shapiro. Just a moment. And what's the ground for the objection? All right, I'll sustain the objection. We'll move on from that question.
But you were aware that the two groups, 6 Block and ATK, had bad blood between them. And is it fair to say that you signed the defendant, Mr. Robinson, in part because you wanted to make money on his record sales? Sure. Well, sir, you were protecting your investment. Fair? Okay, Mr. Shapiro, you've answered my question. Thank you. I have no further questions.
Okay, is there any redirect?
Mr. Shapiro, 2 quick questions.
Are you here testifying out of financial motivation?
Absolutely.
Your Honor, objection, relevant.
All right, okay, I'm gonna sustain that objection. If you'll just answer the question asked, Mr. Shapiro, thank you.
I
think we got the answer, Your Honor. I can go to the next question.
Okay.
Mr. Shapiro, you were asked about a Nike jacket. You remember that on cross-examination? Going back to January of 2020, specifically within the music community, were Nike Tech fleece suits popular? That colorway, the black and gray, is that a common colorway or is it unique?
No.
Now, with respect to Mr. Robinson's size, do you have any personal experience or knowledge with what size clothes he wears?
Objection, Your Honor. He just said he's speculating.
All right. If you know, you may answer, but if you don't know, we don't want you to guess.
Mr. Shipes, last line, or Mr. Shapiro, last line of questioning, you were asked about drill rap. And within the music industry, are there rappers that try to co-opt the life of others to sell records? One more. It sells better than what I've referred to in this courtroom earlier as happy rap.
Yes, sir.
Nothing further, Your Honor. Thank you, Mr. Shapiro. We're all set with you here today.
All right. Thank you. May this witness be excused then?
Yes, Your Honor.
Okay, sir. You may zoom off now. Thank you. All right, defense, you may call your next witness.
What y'all thought of that witness? Put it in the chat. Let me know. Was it a good witness for the defense, bad witness for the defense, or what? I believe the sister will be the next one up. A lot of y'all saying it was a bad witness.
Do you know someone by the name of Hakeem Robinson?
Yes,
How do you know him?
that's my brother. 3 to 4 bedroom.
How many people lived there at the time that you knew?
So it was my dad, Kenyatta, which is his baby mom, my brothers, me. All of us had access to the home. So
So when you say all of you had access to the home, is it all the siblings or is it everyone or?
all the siblings and kind of whoever close to us too, but all of us all the siblings, we all had keys.
Who would be the closest, would you say, in that group that would be coming and going, just so that we have an idea?
My siblings.
Okay, so I'm just gonna throw out some name. How many siblings do you have?
It's a total of 11 of us.
Okay, so Abdul Robinson Jr., is that a sibling of yours?
Yes, that's my brother.
Okay. Was he living in the home?
Yes.
Does he have also a nickname?
Yes, Kareem.
Kareem, okay. Was Hakeem Robinson living in the home?
Yes.
Was that the only home he was living in at the time?
He always was in between his mom and his dad. Well, our dad.
Okay, but his mother is it's a different location.
Yes.
So you bounce back and forth.
Yes.
I know there's another Abdul Robinson brother. Did he live there too?
I believe he was incarcerated still around that time.
Okay. And then anyone else of importance that you know would come and go that you can think of now? I know it's 5 years later.
All of my siblings, my dad, Kenyatta, the people who live there.
Okay, now drawing your attention to, so during that time, would you see Hakeem Robinson a lot?
Yes.
You were familiar with, for example, his height and his weight?
Yes.
Okay, you'd see him in regular clothes, sleeping clothes, all type of clothes?
Of course.
Okay. And then there came a time later in September of 2020 where he was arrested,
Yes.
right?
Yes.
Was your dad arrested at the same time?
Yes.
At that time, was a video released on the media about what is the subject of the case that we are here for today?
Yes.
There were several videos that were released into the media,
Yes.
right? The one I want to focus on is the one that was depicted of a strip mall, which showed someone shooting the victim in this case.
Yes.
Did you see that video?
Yes, I did.
Okay. And how many times would you say that you saw that video?
It circulated around the world, the internet, so I would say I've seen it numerous of times.
Okay. And knowing what you know of your brother, when you saw that video, what was your opinion of who the person was?
I immediately said, excuse my language, hell no. I was like, wow.
And how did you what was it about looking at the video and then knowing what you know about your brother that led you to come to that conclusion?
So if I can give a description of how I describe my brother, I would say that I call him fat, slew-footed, which we would say 2 left feet. I call him stocky and tallest. Tall. He's a giant to me.
Okay, and how tall are you, just to give the jury some reference?
I'm 5'4".
Okay, and so as you describe him to you, he's a giant.
Yes.
And so when you looked at this, is that what it was that, in your opinion, made you believe that it was not him?
It was honestly being a sibling and a sister. It was the intuition, the gut feeling of just like almost if you know, you know. So it was gutting, but seeing it initially, I was just like, hell no.
Okay, no further questions, Judge.
All right, cross-exam.
So, Ms. Robinson, it's true when Abdul Robinson Sr., your father, indicates that Hakeem Robinson was living with him. That's true.
That's true.
And you were there too.
Yes.
And your father certainly would have had contact with Hakeem Robinson during the period of time he was living with him.
He contacted all of us.
Yeah, okay. And is it fair to say that everyone in that house had multiple phones?
Yes.
And I think you've indicated that you even have multiple phones.
Yes, I have 2.
And Abdul Jr. had multiple phones.
Yes.
And Hakeem had multiple phones.
Yes, we've had them.
And then Abdul Robinson Sr., that he would provide sometimes that for y'all as a father giving to his children.
For myself, I
Yes.
took care of myself.
Okay, well, good
But
for
he
you.
took care of his son, so yes, he would.
Okay, so he would provide them things like phones.
Yes.
When Charles McCormick, Little Buck, you've heard of him?
I heard of Charles McCormick.
And you were aware of, before your brother ever got arrested, you were aware of a disc track that he sang making fun of Willie Addison. You remember that?
Yes.
And you were aware of that.
Yes, I was.
And the defendant was aware of that.
Yes.
In fact, Leroy Whitaker was aware of that as well.
We all who are associated with each other are aware of that.
And just so to be clear, Leroy Whitaker and the defendant Hakeem Robinson are cousins.
Yes, they are.
And they're close.
Yes, they're cousins.
And so the whole group, including Abdul Sr., Abdul Jr., and the two defendants, were upset about this Charles McCormick making fun of the death of Willie Addison.
We all were.
And so that was discussed among the group.
We all were upset.
And one of the reasons for being upset is that McCormick was in 6 Block, this other group, correct?
We were upset that he was dissing my dead brother, Willie Addison.
And Leroy Whitaker was upset, and Hakeem Robinson was upset.
We all were upset.
And Hakeem Robinson was in, referred the group was ATK, correct?
He was the brother of Willie Addison.
Okay, so Hakeem Robinson, this was his stepbrother, I think, correct?
Yeah, we all act.
He was that close to Willie Addison.
Yeah, we were blood.
So he knew who he was.
Of course.
So Hakeem Robinson, he's right-handed, right?
From my knowledge, yeah.
I mean, you've lived with him for 20
Yeah, that's my brother, so I would say right-handed, yes.
But it'd probably be weirder if you were left-handed. You would notice that, right?
I don't think left-handers are weird.
Okay,
so-
well, unusual, not weird. That's a better word.
No, not unusual. If he's left-handed, he's left-handed. If
He's right-handed.
he's right-handed.
Right, okay, let's get past that. So you saw the internet stuff, and you didn't participate in this crime in any way.
Absolutely not.
You didn't pick up Leroy Whitaker and Dominique Barner.
Absolutely not.
You didn't drive them away from the scene, any of that stuff.
I did not.
Showing you what's been entered into evidence of Stakes Exhibit 230. I'm just going to do it like this. You recognize?
Yes, I do.
And the person on the right is,
Hakeem.
the person on the left is,
Leroy.
and do these photographs fairly and accurately depict the way Hakeem Robinson and Leroy Whitaker looked in January?
Yes.
Show you a couple more things. I think I have to use this. Where's the desktop? Okay, there we go. Okay, showing you what's been entered into evidence in State's Exhibit. Excuse me, Defense Exhibit 3. You see that photograph on your screen, Ms. Robinson?
Yes.
Does that fairly and accurately depict Hakeem Robinson in January of 2020?
Yes.
And what do we see in his right hand there?
A phone. Oh. A phone. Sorry.
And finally, Mr. Cooper may need, I think I can get to it. Does it show? Smith has the video.
I'm showing you states 192. You see that on the screen?
Yes.
And you see Hakeem Robinson in the smaller box?
Yes, I do.
Is Mr. Robinson wearing a black and gray two-tone sweatsuit?
Yes, he's wearing a Nike sweatsuit.
And you've seen him wear that before?
Yes.
You've seen him wear that in the time period leading up to this homicide?
Yes. And I just wanted to clarify because you said leading up to this homicide, like because you said.
Well, January of 2020 is the, yeah. Okay.
Oh, yes.
I wasn't trying to trick you. The defendant, Hakeem Robinson, as we sit here today, is bigger than he was in January of 2020.
Slightly, yes, but he's always been just about that size. He has picked up a slightly amount of weight, and his hair has grown, but he's definitely Hakeem that I know.
I understand that. He's put on weight since January of 2020.
Slightly, yes.
You didn't tell me slightly an hour ago. You said he was bigger, and now you're changing it to slightly.
Well, you asked me, was he bigger? I clarified. Well, you said significantly, and I clarified that significantly was a big word to explain this person. So I clarified to you that he was about and slightly the same size. Because you said, did you use significant?
Yes. I'll ask a question, and you can respond since we're in a little difficult position here. I asked you if he was significantly bigger, and you would not say that he was significantly bigger, correct?
Correct.
But then we both agreed that he was bigger today. You never said
Yes.
the word slightly, correct?
All right, he's bigger today.
Okay, so you would agree that he's bigger today than he was in January of 2020.
Yes, not significantly bigger.
Okay, well, I didn't ask that, did I?
Thank you.
Okay, thank you, Ms. Robinson. I have no further questions.
All right, is there any redirect? Oh, I'm sorry. Yes, of course. For Defendant Whitaker, go ahead.
I've been quiet for a long time this morning. And I like to talk. Good morning, ma'am. How are you doing?
Good morning.
Ma'am, you're familiar with my client, Mr. Leroy Whitaker?
Yes, I am.
And he's been referred to your home on the one you used to live with your dad?
Yes, he has.
Okay. And you mentioned that, actually, first, let me back up. In terms of siblings, who's older, yourself or Hakeem?
Myself.
Okay, and if you don't mind me asking, how much older are you than him?
A year?
Okay. And Willie Addison was older than you, ma'am?
Yes, he was.
How much older than you was he? And I realize this might
5 years. It's a lot of us. We rarely remember each other birthdays and dates, and we don't. So sorry if when you ask me about these times, because it's a lot of us. So the birthdays and stuff is a little.
completely understand. But you think roughly about 5 years older than yourself?
Yes.
And you're a year older than Hakeem?
Yes.
Okay. Leroy Whitaker is substantially younger than you, correct?
He is.
Okay. Back in 2020, Hakeem was 21 years old. Does that sound about right?
Yes, it does.
So you would have been about 22, right?
Yes.
Leroy Whitaker was 19, right?
Yes.
And so Willie, had he lived, would have been, if you were 22, he would have been about 27, 28.
Correct.
And it sounds like maybe about 27 when he was killed.
Right.
Okay. Leroy Whitaker didn't have any kind of a relationship with Willie Addison, did he?
Not from my knowledge at all.
I don't have anything further, Your Honor. Thanks.
All right, thank you. And redirect.
Ms. Robinson, as you sit here today, has Hakeem Robinson shrunk between 6 inches to a feet in 5 years?
No, he's still a giant.
Okay. Has he put on over 100 pounds since he is in the past 5 years?
No.
50?
No.
Slight, as you described it, right?
It's slight.
Okay. Now, the state got up and asked you about the relationship with Blue. Would it be fair to say that Blue started to get closer to Hakeem Robinson when his rap career started to take off?
Objection beyond the scope of cross.
And repeat the question.
If he became closer to Hakeem when his rap career started to take off?
I'm going to sustain the objection.
And the state asked you about multiple phones. Would you know whether or not Blue gave him those phones, or the phones that belonged to Hakeem were given to him by his mother?
I wouldn't know that. That's not something that he would do as far as go to get them phones, but I wouldn't know who actually got it.
He also showed you a couple of photographs of Hakeem with a sweatsuit on. Did everybody have a sweatsuit like that?
Around the time that pattern was popular, Nike was making this ashy gray and light gray black pattern way, also with this orange. So around that time, the Nike colorway was popular.
I'm sorry to interrupt. I need to see court reporter and counsel at sidebar, and I need, yes, right now. Thank you.
Oh, shoot. What happened just that quick? Oh, snap. What y'all think happened? Lord, that was like abrupt. I don't know, y'all. I don't know what just happened. I ain't hear no objection or nothing. The witness was talking, and all of a sudden, the judge said, "I'm sorry to interrupt. I need to see y'all sidebar." Ooh. I don't know. Do y'all think the sister is telling the truth? Or no? I normally put polls up. I just ain't been in my office, y'all. Y'all done got me used to chilling in my bedroom, so that's why I just been asking y'all. It kind of seemed like it might be a mistrial. I wonder what happened though. Like what took place to make it just happen abruptly like that? Oh, snap now. Yeah, she did well. I saw some of y'all saying she had an attitude. I didn't really sense an attitude from her. She just made sure she was clear on what she said. So she's definitely the first witness to finally say that he's fat. I can't wait to find out what happened though. Oh, they back.
Thank you. All right, Ms. Robinson, I think you just answered the question. You were finished with your answer?
Yes, I am.
Okay, no further questions, Your Honor.
All right, thank you. May this witness be excused?
Yes.
All right, ma'am, you are excused and free to go. All right, and from defendant Hakeem Robinson? Well, let's take a recess then. It is now 12:30, ladies and gentlemen, and we are going to give you all a lunch recess for 1 hour. So I'm going to ask that you leave your notepads behind, lock them, secure them, and we will return them to you when we reconvene. Thank you for your patience throughout the course of this trial, ladies and gentlemen. Please be sure that during this lunch recess, you do not speak to anybody or allow anyone to approach you to say anything. Be very mindful, as I know you have been, about not watching or reading or listening to any news stories that might be aired. Audience members may have a seat if you don't mind. Thank you. And if you wish to remain eating in the jury rooms, you absolutely may do so. For those that need to go grab some to eat and bring it back, if you want to do that, that's acceptable. We will be back here. Let me do 1:45, a little bit longer lunch. We've got some other matters to attend to. So 1:45 is when we would like you all back here for continuation of the trial. So you are now excused for lunch recess. Thank you.
What I don't like about this trial that we don't get to listen in on the stuff that happened when the jury is out all the way. I don't like that. You know, most trials we get to hear the lawyers go back and forth about stuff. So now we're not even going, oh, is they back? Hold on. Maybe I spoke too soon.
Just one? Okay, we'll await that person's exit. But in the meantime, you all can have a seat. Court is not recessed yet. I have to inquire, Ms. Ksoo Robinson, are you present? If you will please raise your hand. Where is she? Oh, she did step out? Okay, she's not going to be allowed back into this courtroom. Her Facebook has been live streaming this proceedings and specifically live streamed this witness who asked that her face not be shown. That's why our cameras did not show her face. Yes? And how is her account live streaming her face? So that means someone in here has an electronic device that is on and functioning. And I have told everyone in here that they are not allowed to have that. So whoever has that phone and was live streaming this, you will not be allowed in this courtroom. Who has Ms. Robinson's phone? Someone obviously must have. Her face was not shown on the video screen that we have. The camera that we have up there has been showing the carpet, which I'm looking at right here on my monitor during her testimony. What I have been advised is that her face was being shown on a live stream of Facebook, and that could only occur if someone's electronic device in the audience was on. I cannot stress this enough, ladies and gentlemen, but unless you are credentialed media, you are not to be having any cameras, video, audio devices on in this courtroom. And if we find you with that, you will be excused from this courtroom. So we need to find out from Ms. Robinson who had a phone or who has her Facebook account, because you are excused. That is not acceptable when a witness has requested that her face not be shown on the camera. You all have to follow the court rules just like the attorneys do, just like the defendants do, just like the jurors do. Otherwise, you will be excused from this courtroom. Is that understood to everybody?
And just a point of clarification, because I initially made that request when I gone outside and asked Ms. Robinson, listen, I made this request. She has clarified to me that the only thing she didn't want was her name being broadcast. I did let Mike know that it was the camera wasn't an issue, but that her name was an issue. But now you're telling me that even the live stream was on the part.
The live stream is on. Well, Ms. Robinson's in the courtroom now, ma'am. I'll just let you know, I was told you didn't want your face on screen. Your testimony was live streamed on Facebook. No, it's not perfectly fine, because I've said, excuse me, I've said no electronic devices are allowed to be on and used in recording in this courtroom. So whoever has your phone or whoever did that, you need to let me know who that is. Who is it? Okay.
I didn't have anyone recording. I have no knowledge of someone else recording besides the news. And what I was stating was that the actual testimony itself was perfectly fine to be recorded, but I did not want to introduce myself by my first and last name.
All right, well, your entire testimony was live streamed. On Kashala, I don't know who that is, but it is on the Facebook of Kashala, spelled Kashayyla Robinson. Who is that? Is that you?
Yeah, that's my social media.
Okay.
I don't know why they went back mute. Was they done? I can't find the page, y'all. I've been over here trying to look for it myself. I can't find the page they talking about. She spelled it, but shit, the spelling I got, I can't find it at all. Probably done took it down, put it on private or something real quick. I don't know. That look crazy though, especially being that it's from her page. She's the witness on there. Could have been part of the whole play of getting her to testify. Because, you know, anything that happens during trial can be used as a reason for a mistrial. But I doubt this is going to be a good enough reason for a mistrial. Hold on real quick. She said she using this as her come up. She testified at the trial. I think it's more so done to do to irritate the judge. But I really don't think it's gonna go into no mistrial or nothing like that. That's just how I feel. Oh Lord. Young and Ace posted on Instagram, my brother's coming home. I can't wait to see their mama smiling again. He wrote that 31 minutes ago. It might be whoever phone went off earlier. Could be. She probably just gave her phone to somebody and that's who was recording. But we'll find out, you know, if it's gonna hold that much weight to people. But ECOP said this isn't a reason for mistrial. They weren't showing her face because she requested. If she is the one who broadcasted it, then there's no problem. I ain't gonna say it's no problem, but I mean I don't think it's that massive since she is her page and she's the witness. I think that's what's saying. Now if it wasn't her page and it was somebody else that did it, that would have been a different story. No mistrial here. The streets will certainly handle it. The streets don't be handling nothing. Hence why, you know, people redo what they already did. The judge said no faces as well. The judge can throw her in jail. I doubt she gonna do that. She's just gonna ban her from the courtroom. Hopefully they didn't catch any jurors on that. That would be the thing too, Leah, for real. If they was recording the jury, and she's a defense witness. So yeah, that would be bad if they did. That's why I wanted to watch it to see if it was just on her face or what. They must ain't got the people in the courtroom like down here, man. Them old people be on your ass when you pull out your phone in them at the courthouse. Especially at like our general session courthouse, like where murder cases and stuff, man, they be on your ass. You can't even, man, as soon as they see a phone, them yellow jackets be on your tail about that, okay? On your tail, okay? ECOP said it's still not a reason for a mistrial. The person who did it, did it could be in illegal trouble. I mean, I ain't gonna say, do y'all understand? A mistrial can be for anything. They can, now whether it be granted is one thing, but anything can be a mistrial. A motion for mistrial. Trust me, I lived through it. Anything can be a motion for a mistrial. The question is, would it be granted or not? Abby said we can't have our phones period in our courthouse. We gotta leave them in the locker car. Ooh. In the courthouse that the magistrate courts that I be working in, it's the same way. You can't take no phones in there either. No. You can take a phone. I'm lying. You can't take no persons and stuff in there. So yeah, you can take a phone in there. What about that with the other errors like the mention of Bibby? Sure, I missed that. When did they mention Bibby? But I doubt, because a motion would have had been put on record. I ain't hearing the defense call or put a motion for mistrial on them. Cherie says it's on record that the witness didn't want to be shown. Maybe there could be a liability if she's shown or something happens. But I think what makes this a peculiar situation is that she is the witness and it was on her Facebook. So it's not like somebody else was doing it, you know? Will the judge continue to allow the sister to be on the stand, being that somebody went live? Well, she was done with her testimony, so she got her testimony out the way. Pat G said Ksoo sis bought Nicki Minaj tickets a year ago. That's random, okay? Bronco said I guarantee it wasn't a phone used. Could have been glasses for sure. Oh, they said Bibby name during Detective Smith's testimony. Gotcha. I could rewatch that right now. I just don't feel like it. I could though. I could go in the office and rewatch that part. Bet they was gonna use the footage for a music video. Could be because Show put some of the trial footage in his video. Oh. How did it come out in the testimony of the detective? If the defense didn't use that as a motion for mistrial at that time, then they're good. Like, it's not gonna cause an issue. Econ said it wasn't that big of a deal. He didn't say Bibby was murdered or Ksoo killed him. Oh, they just because they said his name, then yeah, that's not a big deal. Bobby said you was asleep. It was yesterday. One of the officers said Ksoo mentioned Bibby every chance he gets. Oh, saying in that context is fine. I thought y'all meant that he actually said like he's accused of being the shooter in that case too. Betty said in Florida you can, but they have to be on silent or turned off. Cherie said they were discussing if they were real ops. Defense call for a sidebar. Oh, I can't wait till my food get here. I be trying to eat my lunch around the same time they go on lunch. So by the time their lunch break is over, my food should be in the guy here. I'm gonna have to look on my phone because I can't see that. A witness said that he said Ksoo standing over Bibby. He ran but fell. I don't have I've never looked at that case. I don't know nothing about that case. And I'm actually trying not to look at that case. So when the trial comes, I can just watch it with a fresh perspective. It'll be the first trial that I've never like researched prior to the trial. So I'm trying not to look at the Bibby case because I want to watch it without knowing anything about it. So I really can't have a conversation about the Bibby case because I don't know. Nobody. Oh, man, who's Bibby? Bibby is a 16-year-old that was murdered in Jacksonville. Julio Fulio friend. All right, so let's kind of like go over what transpired. Hold on, y'all. All right. Dang, where do I want to start at? Oh, let me clear up the debate we was having earlier. So, when me and Black Butterfly was having our debate, Black Butterfly has been around for a long time. She's one of my conspiracy truth team members. But she said that she doesn't like people that lie, so she wouldn't listen to anybody that is known for lying. And she made clear she was definitely biased about that. So that's what started the conversation. Ultimately, the whole point of that conversation was that I don't feel like nobody should be on a jury if you come in biased. Not saying you have to think every witness is credible. So let me elaborate because I was having a conversation in the comments once we went back to it. When you go into a jury, they ask you, would you be able to be impartial to this case? And if you don't believe liars, right? So a liar, so anybody that come in there and that's called out to be a liar, you're not going to believe them. You shouldn't be on the jury because you're not being impartial to the case, right? So that was the whole situation. It went left because everybody started saying it was about credibility and all that, but that's not what it was about. It was just about getting on a jury and then you already biased. So, I mean, the case won't be tried fairly. So that was that. Now, what else? Personally, I don't think what was his name? Shipes? Shipes was a good witness. I don't think Shipes was a good witness. I really don't think none of the defense witness was good, really, because even a sister, she still, like, I feel like she was being truthful, but she was still saying, yeah, I seen him prior to the shooting in that sweatshirt or the hoodie. So it's like, that hoodie is like, I get it's a common thing, but if you have pictures and videos in a hoodie prior to a shooting that you are now on trial for, and the shooter in this case had on that same hoodie, I mean, I get it. Like, you can't determine that's exactly the hoodie, but that looks bad. Hold on, y'all done jumped to talking about Julio Fulio. Hold on, I stopped looking at the chat. Who's something in the message? All right, let's see. Aaliyah said Fulio and Bibi are blood brothers. They have the same mama. That's a lie, Aaliyah. That's not true. Fulio and Bibi was friends. They don't have the same parents. Big Wolf says, what if the evidence supports the story? The witness who previously lied is testified to understand. That's what I said too. So that's why, like, if you go in there saying that you don't believe liars, then you're not impartial. So that was the whole thing. Hold on, let me get on my phone because y'all moving fast. Ebony said, "Oh, LOL. They was telling me Bibby was a part of Fulio's clique, which made me think that their trial coming up. I mean, the trial should be coming up because I mean, it'll been years since he been charged with it. But yeah, he was from the neighborhood. I don't know if he was technically because he was younger. I don't know if he was technically part of it or just from that area. And then I said 16. I think he was younger than that, like 13, 14 or something like that." Orange Crest said Reddit is saying case of defense plan this for a trial. I don't know. That's crazy. I ain't gonna say they planned it for no mistrial. It's definitely, you can tell they was running a play for sure. Aaliyah said Fulio said himself, go look at the picture. They have the same face. Aaliyah, I mean, you got to understand, like, Fulio mama talked about this. So, like, I get where you come from about pictures, but after Fulio died, his mama was very active on social media. You can just go back. It's on my page. It's on multiple different YouTube channels. She clarified that they were not brothers. They were not brothers. She did not bear that child. She said it herself. Black Butterfly said, Mick, I love our debates. I still feel the same way and correct. I will be a bad juror. Debates give this channel zest, and it's never a bad thing. I know you know. That's for our new members. Facts. You know, we had a lot of people that was new to it, and I was like, hold on. Because y'all know some people they take offense with debates because they don't understand that's what we do over here. But yeah, that's all that was. It was just a debate. Where we at? Lil G said Bibby mom is delusional. They act like he didn't kill nobody. Well, technically he didn't. Like, he never went to trial for killing nobody. He never got charged with killing nobody. Is Bud a witness for the state on Ksoo and the Bibby case too? I don't know. I don't think so. According to when they broke down his plea agreement, it was just for this case and the other case with Blue, Chris Brown, and the others. Pat G said, who's acting like Fulio operating his page after he died is the question. I think the mom said it was like one of his friends, but then she took over it. Wildcat said, Butter a snake. He probably had Ksoo hoodie on. Y'all funny. Kiki said Fulio did an interview saying Big was his friend. Yeah. I mean, you could just Google it. His parents and did news interviews. You can tell it's not the same person. We know what Fulio mama looked like. She done spoke out multiple times. Aaliyah said, is there any more witnesses for this, or they're doing closing arguments? Not that should be it. I don't think so. We could barely hear, but I don't think they said they had any more witnesses. I think that's it. So closing arguments should be soon. I'm thinking the jury should be deliberating by like tomorrow sometime. Bobby said they said the jury face got shown on the live. Who said that? I didn't hear that. Where did you hear that from? Where is my food? Picking up my order. I spent so much money on doggone food delivery. I can't wait till it's fall. I can't stand the summer heat. It be hot. Conviction, no mistrial, exactly, Mickey. Orange Curse said, yeah, they said that on Reddit. I don't know the way for evidence. Hey, don't be talking about everything Reddit be having going on now. Although Reddit be having some good stuff, sometimes everything that's on Reddit ain't accurate. The courts will probably next decide the jury's instructions, then give closing arguments. They should have already had the jury instructions. If anything, they might need to adjust them. But they don't just start creating them this late in the game. You think the judge gonna instruct the jury to dismiss what the sister said about the Nike track suits? No, I don't think so. Pat G said, I'm in Texas. I know what you mean by summer heat. Yeah, it's been hot. Like, I almost passed out twice Saturday at the party. That's why I ain't been outside since. I'm glad I got the ability to like work from home and stuff. Cause boy, going out in that heat will be taking me out. E-Cop said, why are we saying mistrial when neither lawyer brought it up? Yeah, I don't think that would have been put on record. I really don't think that's gonna be an issue. Cherie said, this record's all part of hip hop culture. Is meant to be disrespectful. Drill rap took it to the next level. These guys made drill songs, not this. Yeah. Jaquan said, this recess a little long. I smell mistrial. No, they only did the lunch break a couple minutes longer because they had to address the situation about the Facebook Live. Kiki, what order? 110. That's how I feel here too. Hot, okay? It's hot. I feel like Vegas right here. Okay. Betty said, one day I did see some of the jurors' face. Be glad you aren't in Florida, Mickey. Yeah, Florida hot. Y'all know I went to Miami last month. It was hot as shit down there. I ain't gonna lie. It was hot. Pat G should have made Will Smith tight rap, whatever that means. Oh, what did I order? A salad from a grilled chicken salad from this place called Vary's in Columbia. Y'all know I can't eat too much of other things, so I made a salad because I ain't went to the store. Last time I went and got salad stuff, the lettuce kept going bad, so I just order it when I want one. The first day Drew was shown, they took it down. I think I still got it, but yeah, I remember that. Ooh, chicken Alfredo. I miss being able to eat Alfredo. I love Alfredo. Okay, I love Alfredo. I miss being able to eat it. Same my mother ordered eat lunch, ate chicken Caesar salad. Oh, that sounds good. I'm really not a big salad person, but it's like it's the best thing I can eat right now, other than like doing like too much cooking, because this is my thing. For those that's new, I talked about it yesterday, but yeah, I had sleeve surgery last month. So like I can't eat much. But cooking, especially cooking food that everybody else ain't gonna want to eat, I be wasting so much food. Like I got food in the freezer right now that I made like 2 weeks ago that I need to throw out because I'm not gonna eat it. So I just like, just be wasteful. Okay. Yes. What y'all having for lunch? Everybody should be eating lunch. Watermelon. Let me tell you, I had bought me some watermelon. It was so sour. I said, ugh. I need to be able to pick out watermelon better because I like sweet watermelon. But the last, matter of fact, the fruit tray that we had for the party, that watermelon was not sweet. It was sour. I like plums too. Can't eat plums yet, but I do like plums. Yeah, so yeah, I can't wait till this food get here. Cause I am starving. And I got to go out in the heat today. I hope they finish because by 5, 'cause I gotta leave at 5. If they not done by 5, I'm ending at 5 because I gotta go somewhere today. Not exactly at 5, like a little after 5. Ksoo, I love all kinds of salads. Yeah, salads is good. Mr. Pitbull said Mexican. Oh, I love Mexican food. I haven't been able to eat it though, but I love it. Y'all making me so hungry. But yeah, I do miss eating Mexican for sure. For sure. I like grapes too. That's what you're eating for lunch. This has been up and down roller coaster. Y'all, I may have to go back and watch the testimony I fell asleep on yesterday. I ain't gonna lie. I know y'all done already seen it yesterday, but I think I got to go ahead and finish it because I feel like I can't really do a recap video without watching it because y'all said a lot of stuff happened. So, I was trying to eat cheesecake too. Oh, that sounds so good. Some cheesecake. You think they're gonna go until 6 today? Possibly, depending on, because at this point the judge don't like to waste the jury's time. So yeah, I think I'm gonna have to go ahead and watch that, y'all. Hold on, I need to switch to my desktop. Hold on. All right, I'm back. Let's see. Protein shake full of information. Listen, I was so happy when I could stop drinking them things because, like, the first 2 weeks after surgery is all I could have. All I could have was freaking protein shake. Right. What day? We on day 6. Day 5. Where did I stop at? I know after lunch I fell asleep.
He was working out at the Baileys. He was on a Stairmaster.
Oh, I forgot I can't hear on. I don't know what's going on with my computer. I can't hear. That's why I've been on my tablet. For some reason, y'all can hear. I can't hear on the computer. See. He might get the other if it was so damaging. He got to save it. The main thing that makes it for the jury are the great jumpsuit that he also had on in the music video. Definitely If you put all the circumstantial evidence in, like, into the story, for sure. Like, it's everything is on. All my stuff, I don't never cut it out. Ooh, we got 45 minutes. I think, cause I think I slept for 2 hours yesterday. So to 7:24 starting at, oh, we ain't gonna finish right now. All right, this what I'm gonna do, y'all. I'ma just let this play. I'll be in the comments because we only got 45 minutes. I missed 2 hours. And there was something real, and then we'll just do a recap of that because I'm just gonna go ahead and get started. All right, that's what we're gonna do. So this is the part I missed yesterday. So now I got to go get my tablet.
Without telling you a specific name, I know there was one person I spoke to that was at the gas station.
So you had unbiased eyewitnesses, no connection to this case, not being prosecuted, give you a description of what they saw.
Yes.
And as you're investigating Hakeem, you haven't met him before.
No.
You have a description on what the shooter was like. And on the day that he comes into the station, was ultimately arrested, you met him for the first time, right?
Yes.
And you were surprised by how big he was.
Like his weight, yeah.
No, you were surprised with how big he was, height and weight.
I'd say weight. Looks a little skinnier on Instagram back then, from my recollection.
Would it refresh your recollection to see your reaction in the interrogation video?
No, again, I said there was the weight that kind of threw me off.
The day that you met with him, and this is for impeachment, the day that you met with him, there was a recording device in the interview room, correct?
Correct.
And at one point in time, he went out to go to the bathroom, right?
Without watching it, I don't remember.
And you walked back into the interview room and he was in front of you.
Okay. I don't understand exactly what you're saying.
He answered the question.
Right? Okay.
Sidebar, I disagree that it was answered.
All right, well, if you're going to show the video, only he is to see the video because the video is not in evidence.
Okay. It's for impeachment, but I'll show it to him.
But it's only to be shown to him
I'm sorry?
first.
Well, the only thing is there's audio, Your Honor,
Then I need to excuse the jurors.
or I can bring him over here and play it for him.
And the audio won't still be an issue?
It'll be very low.
No. I mean, I'm going to have to excuse the jurors at this point because then I also have to be able to see and hear it.
Understood.
And I won't be able to if it's low over there. So ladies and gentlemen, I'm going to ask y'all to have a step into your jury room for a quick moment, and then we'll bring you right back out here.
Bigger than I thought you'd be. Right?
I've already answered this, but yes,
Please answer it again. They're not objecting. You don't get to make that choice.
yes,
All right. Now, it wasn't just about his weight, was it?
it was about his weight.
Then why didn't you say it before he stood up?
I vaguely remember being in that room briefly. I don't think we made too many comments to each other.
If I'm sitting down, you can tell from my face, from my body, you can tell if I'm wide shouldered, right? You can't tell my height until I stand up.
At that point, I don't remember looking at his body. I was looking at his face, and then I think he has to go to the bathroom. And then as he comes back in the bathroom, that's when I make the comment.
You agree that you made the comment?
Yes, never done that.
Yeah. My client was arrested that day?
Yes,
You didn't take any photos of him, did you?
we did not.
No. One moment, Your Honor. I'm showing you one of the government's exhibits, but you guys took photos of Dominique Barner, multiple photos.
Yes,
So, understanding that we may have a recording, we could have had photographs just like this for this jury to see his exact size on that day,
correct.
but you chose not to take photos.
With respect to Dominique Barner, the tattoos that he had at that date and time were the reason he was photographed.
Isn't the first photo of him with a shirt on?
Yes, they do overall photos.
Thank you, Your Honor. We're having a tech issue there for a second.
Okay.
So, this photograph, this is taken so you know who you're taking the photograph of, right?
That's correct.
There's no policy, there's no law, there's nothing saying that you couldn't have taken the similar photographs of my client, Hakeem Robinson.
No, there's no.
Be able to see what kind of weight he's carrying. Right?
Right.
You agree, though, that he doesn't have a single tattoo?
I have not seen the extent of his body, so I can't say that for sure.
Well, if there was tattoos, you'd be taking photos.
If they were described by a witness or a victim as it relates to the case, and it makes sense, yes.
Let's move on now. Call action detail notes.
Now, again, this is back in the day when they had the CB radio. Now it's digital radios. But anything that's going out there from all the different officers, it's going to a central location and being recorded, right?
Yes.
It's both typed out and audio recorded, right?
Yes.
So somewhere out there, there's an audio recording of two of your colleagues giving a description of the person they're chasing.
Yes.
Why don't we have that?
Objection, Judge.
Richardson hearing.
What? Okay, if I can have a grounds for the objection?
Yeah, subject to a motion filed.
Okay. Will overrule the objection.
There's an audio recording of your colleagues, literally as they're chasing after the person, going out on the radio. I need backup. I'm chasing somebody, giving a description. Right?
At some point, yes.
At some point?
Yes, there would have been.
Okay. Now, both the call action detail notes and the recording, those are kept in the normal course of business for JSO, right?
That's correct.
They're created literally live. So they're created at or near the time of when the items are being reported, right?
Yes.
And they're organized and collected by somebody with personal knowledge about what they're doing. It's somebody from JSO.
At least someone in the comm center, but yes.
Now let's talk about body cams. January 15, 2020, body cams were required for officers, right?
Yes, I believe so.
Officer Collins, although he was getting a rap at Publix, he was on duty that day.
I don't know if he was on duty or going to secondary employment.
If he were on duty and in uniform, he would have been on that date wearing a body cam.
He should have been, yes.
And per your policy, if somebody is chasing after somebody else in a vehicle and then on foot, you're supposed to activate that body cam.
Yes.
Now, obviously, sometimes that doesn't happen, right?
Yes.
But sometimes there are recordings, right?
Yes.
You as a lead detective, is there a recording?
Of?
Officer Collins chasing on foot the shooter?
No.
Doesn't exist or it can't be found?
I don't believe it exists. I asked for all body worn camera from that incident. I never had that.
Now, presumably, if that camera was on, we would have live images of the shooter, right?
Reasonably depend on when he got out of the car and what his body cam caught. I can't speak to that.
Let's go back to warrants now. Let's talk about search warrants. Now, you were looking at my client. You had probable cause basis to request those meta records, right?
Yes.
Did you ever search my client's residence?
No.
Did you ever search anywhere and find either the Nike tech suit that the shooter wore?
No.
The shoes that the shooter wore?
No.
You would agree that if you were to execute a search warrant on my client where he was living at that time at his mother's house, and that isn't there, that could lead to an argument of those aren't his clothes.
Potentially.
Now, these Nike tech suits, Nike tech fleece suit is what you think the shooter may have been wearing?
Sorry, perhaps, yes.
Wildly popular. They're popular. Right?
I have seen them, yes, but I don't know how popular they are. Can't speak to it.
You're the lead detective. You didn't look into this?
How popular Nike tech suit is at that time?
We're not talking about a unique, suit jacket covered in rhinestones. We're talking about Nike, popular brand, right?
Yes.
And their sportswear is big, both domestically and internationally.
Yes.
So what I'm getting at here is that there's more than one of them out there in the world.
Yes.
More than one of them out there in this county.
Presumably.
So it would be speculation to say that the one that we saw in the video with my client on the FaceTime call, that's the same one. That'd be speculation, right?
Yes.
You don't even see the full thing.
You can't from the video.
Now let's talk about the posts. The shooter that you interviewed in this case, they covered up their appearance, at least their face, right?
Yes.
There was attempts to evade the police, to run from them, right?
Yes.
There was destruction of evidence. Some stuff was burned, right?
Yes.
You'd agree this is sort of like crime 101. You get away with it, right?
I'm sorry. When you say crime 101, what are you referring to? Burning stuff?
The people that committed this crime, the shooter that covered their face, the people that ran from the cops, the burning of the evidence, the cell phones under other names, those are people trying to protect their identity, to hide it, right?
Yes.
Okay. So about a week later, my client posts on social media about doing something and getting his toes done. Right?
Yes.
And you believe that that's evidence of this murder?
In context of everything else that was posted, yes.
So there's all these attempts to cover up identity, and then he goes out into social media with, how many followers does he have? Hundreds of thousands?
Without looking at his page, I couldn't tell you.
You know that it's a lot.
Yes.
Right. That he then goes out there and confesses? That's your belief, that he everything is done to hide in the moment, and then 5 days later, I'll just confess to the world.
Yes.
That's your belief?
Yes.
All right. Now that statement, and I'm not going to repeat it like the government has a couple times. That statement, that could apply to anything, right?
As far as?
If one of your say the government, one of our witnesses, and they have a riveting cross-examination. I killed him. I killed that witness. Doesn't mean they actually killed him, does it?
No.
Have you
Not in
ever
that
heard the
context.
phrase, for some people, I could only hope that someday my life is as interesting as I make it seem on social media. Have you ever heard that?
Can't say I have.
Now, you know that my client's an artist, right?
Yes.
You know from the videos and from the followers, right?
Yes.
Do you have any way of saying that he wasn't just co-opting the life that he saw growing up to sell records?
I can't say that.
You know, because who else would be stupid enough to post on Instagram, yeah, I just killed a guy. But the person that is trying to sell records to go, you know what? People out there are going to believe it because they don't know it, but I feel secure enough that I'm not going to be charged with this because I know I didn't do it. You understand the question?
No, if you could repeat it, that'd be great.
Have you ever heard the phrase, it can't be smart and stupid at the same time?
Can't say I have. I haven't heard that one.
It would be smart if somebody were trying to hide their identity in the moment. It would be stupid of them to then go onto social media and confess it if they were actually involved, right?
Yes.
Now, we're not saying that my client didn't like Willie Addison. We're not saying that my client didn't dislike Charles McCormick. But him disliking Charles McCormick doesn't mean that alone doesn't mean that he killed him, right?
No.
Posting, bye, bye, bye. That could just be a reflection of him disliking the guy, not necessarily killing him, right?
Right.
You agree?
Just the post itself? No, I agree.
This guy's dead. I mean, agreeably, it may not be tasteful. I don't like this guy. This guy is rapping about something, about somebody that me and others cared about. I don't like that. He's now been killed. Bye-bye. And you want to know what? I'll probably get a bump in records too. You agree with that? How about this? We'll move on. You can think up something. We'll come back to it, okay? Now, Charles McCormick, you know Charles McCormick was never a suspect in the Willie Addison murder, right?
Not that I'm aware of.
So he's rapping about something that he was never involved in, right?
As of now, I did not investigate that case. I cannot say who was or was not a person of interest for that case.
You're being asked this question right now. Charles McCormick, to the best of your knowledge, was he rapping about something that he was never involved in?
As far as I can say, I can't say he had any involvement in the murder.
You can't say that he had any
I'd say
involvement. So it's okay for Charles McCormick, but it's not okay for the guy that actually has the record. Is that what you're saying?
It's not okay for the guy who has a fingerprint on a gun inside that vehicle that was used to murder him.
You already agreed with me that that fingerprint could have been left at any time.
It could have been, but there's any vehicle that could be tied to Charles McCormick? I can't say. I know you probably can't say as well, but I don't think I would be posting or rapping about something I might have remotely had anything to do with.
Let's go back to the fingerprint now. After you got that fingerprint, you didn't arrest my client, right?
No.
Because it wasn't enough.
No.
You didn't arrest Chifton Hogan.
No.
Right? His DNA's in there.
I followed the evidence to verify where they were at that day.
You followed the evidence as far as the fingerprint and then just kept on that track.
The fingerprint and then the DNA when it came back.
The DNA that easily could have been transferred from the shirt that had my client's DNA on it.
I don't know the specifics of how it got on there. I can't tell you that.
Should we save that testimony for the DNA expert?
Yes.
All right. Now, let's talk about those civilian witnesses again. Renata Boston, she got vaguely a look at the person, right?
Yes.
Jarvis Roberts, right?
Yes.
Michael Williams.
Yes.
But Renata, it was something different because the person's hood was down, right?
Yes.
You never went out there with a photographic lineup to see if she could identify anybody, right?
Yeah.
There's nothing stopping you.
No.
If she were to come back and identify the wrong person, your case would be toast.
No, not necessarily. I just have to if she picked out the wrong person, picked nobody, I'd verify who the person is that she picked and see where he was at on the day in question.
But it was never done.
No.
We don't know what we don't know.
She saw him, I believe, from the second floor.
No, she was sitting right there talking to her friend. She was sitting on the stoop. Saw the person come out of the woods. Able to distract the hair and the skin tone. No photo lineup was ever shown to her.
No.
Now, let's talk about House of Pain. And you know the relevance here, right?
I'm sorry. So you,
House of Pain 904@gmail.com.
yes,
You remember that, right?
yes,
Okay. Now, you were born last century, right?
yes.
I was born in the 70s, about the same age.
No.
House of Pain was big in the, it made me feel old with that one. House of Pain was big in the 80s and the 90s, right?
Is that the jump around?
Yep.
There you go.
Jump up, get down, that one. That's way after my client's time, right?
Yes,
But it's within the time frame of Blue, Abdul Sr.,
that's correct.
right? Now, you did look into Abdul Sr., right?
Yes,
His Instagram account is h.o.p_CEO, right?
yes,
A bunch of stuff when you searched his house, there was a bunch of House of Pain paraphernalia, right?
yes.
Are you able to say who that email account belonged to?
No.
Now, you could have found that out, right?
Perhaps, but then if they did the same thing that happened with the iCloud, where there wasn't like a direct name, then that'd still be dead in the water.
Let's do this. We got a whole box over there of Instagram records, call detail records, Meta, Facebook.
Yes,
You're the one that's the lead on this throughout the entire case.
yes,
There's never a search warrant sent to Meta, that's Facebook and Instagram's parent company, to collect the records for HOP CEO Instagram account, right?
no,
Got it for my client days after the shooting.
yes,
Never got it for that.
that's correct.
Okay. You could have also, you could have gone right to the source. You could have sent a search warrant to Google because it's a Gmail account, right?
That's correct.
And we could see, to get to the bottom of it, who this account belongs to.
Potentially.
Potentially?
I don't know what information that the Google account would have contained.
Now, all we know is that there's a few photos of my client that tie back to the iCloud, the Apple, right?
That's correct.
So you guys get the records from Apple, but not from Google, not from Meta.
I'm sorry, Meta. When you say Meta, we
Facebook, Instagram.
do have records from Facebook.
So Meta is Facebook and Instagram. You don't get records from them.
I do have, I'm sorry, you said I did not?
Let's back up. HOP CEO, that Instagram account.
Yeah, specifically that Instagram account. No, I did not get that one.
Okay, that's Meta. Now, for the House of Pain 904 Gmail account, you could have sent a search warrant to Google to get you could have seen all the emails.
Could have, potentially, yes.
You say could have. You had the basis to send out search warrants. You did it on everything else.
Yes.
You did it on the Apple account. It would have been the same thing. You just change out Apple for Google.
Yes.
But we don't have that.
We do not.
But you get the Apple account and there's some selfies of my client, right?
Yes.
You're not able to say that Blue, Abdul Sr., who was admittedly doing some management for my client before he signed up, that he didn't have access to my client's Instagram, right?
I can't say that, no.
Okay. You can't say that my client, maybe was visiting, and I won't refer to him as his father, but Abdul Sr., he was seeing him and took a selfie on his phone. Right?
No, I can't say that.
Ms. Kawas and I are generally always together from work. If I were to take a selfie with her phone, that doesn't mean that's my phone.
Right, but generally, most of the photos on that device would have been of her, not you. I'm sorry, does that make sense?
It doesn't. What we're talking about, though, is who the House of Pain email account belongs to.
Correct.
More work could have been done to other companies to find out the answer to this.
Again, as it relates to the House of Pain, yes, I could have subpoenaed, I guess, Meta to see if there's any other accounts tied to that account email.
So, but when you see a selfie of my client from the Apple return, it's just, okay, that's good enough. That's his account.
It wasn't just a selfie, it was multiple pictures, but okay.
We have the evidence. There's about a dozen photos, right?
Yeah, there's multiple photos.
Dozen.
Still multiple.
Okay, my client's phone, the 1595 that we have in evidence, how many thousands of photos are in that?
It's different. I have the entire device. I don't have the entire device for that 478 number.
At the end of the day, you cannot confidently say who that email address belonged to.
No.
House of Pain 904 at Gmail.
No.
Let's talk about Raekwon Howard. Now, you've seen the meta records for Raekwon Howard, right?
Correct.
Now, we have to assume that that's actually the Raekwon Howard's Instagram, right?
Yes.
You've met with Raekwon.
Yes.
He's next door in the jail right now.
I don't know exactly where he's currently being housed, but I know he is in jail somewhere.
Now, Raekwon Howard at one point in time tried to kill two of the witnesses in this case.
That's correct.
It's the next question, Your Honor.
Okay, I'll allow one more question and see if you can tie up relevance.
Never tried to kill my client. Right?
I don't know what all he's tried to do.
So let's back up to make sure that we're clear. You answered yes, that he did try to kill witnesses. He tried to kill Torgon Williams and Natalie Gant.
That's correct.
He's been charged with that.
Yes.
You know of no time when he's tried to kill Hakeem Robinson.
No, I can't say so.
Now, the relevance here is that these warring factions on the street, that they don't get along, right?
That's correct.
That could have been payback for the murder of Charles McCormick. Happened months later, right?
It did.
Okay. So let's get into the meta records of Raekwon Howard, or somebody that could be Raekwon Howard. We'd have to hear from him to know that these are his records, right?
There's several pictures of him on that account. The email address is Raekwon Howard 4.
Are you saying that Raekwon is a unusual name?
I don't know. Without looking it up, I don't know how many Raekwon Howards are in the world.
Didn't Raekwon Howard try to kill another Raekwon? If you know.
I don't know.
All right. Give me 1 second, Your Honor. I've got to DJ over to another screen. I'm getting better at it. No, we're good. We got it here. Okay. I'm going to wait to publish it. I don't want to show it yet. Okay, let's just jump into this. Let me know if you can see that on the screen.
Yes.
So what I'm showing you is admitted into evidence as a state's exhibit. Unfortunately, I don't have the number, but I'm sure that either Ms. Kwas or the government can tell me what it is. Raekwon Howard's meta records. Meta records. Oh yeah, this one would be Hakeem's. The whole thing. Huh? Hold on, go. Yeah, we'll enter the whole thing. Yeah, that's fine. So you've reviewed these records, right?
Sorry, yes.
All right. Now, what we're talking about, we're going to focus on Hakeem Robinson's records.
Okay.
His meta records. You've reviewed those because you received them, right?
Yes.
Raekwon Howard. One of his usernames is rpg.poppy.
Yes.
Now, there's several other names, but that's one of them, right?
Yes.
Now, the records that you get, it's only for a small period of time.
Yes.
And within that, you looked at the communications, the volume of communications in December before the murder, right?
I believe so.
And then after it.
Yes.
In December of 2019, my client's having conversations. They're texting back and forth and speaking, both my client and RPG Poppy. Would it refresh your recollection to take a look? One moment, Your Honor. Statement starting on page 5,916. Do me a favor and take a look. Scroll down there. I want you to start on, you'll see the username highlighted.
Let me move this just so I have someone to kind of place that.
Just let me know when that helps your memory.
All right.
Does that help your memory?
Yes.
Can you replace the microphone back where it was? Thank you.
In December, the month before the murder, they were talking regularly, right?
Yes. Sorry, 1 second.
At times, right?
Yes,
One of the comments was LMFAOOO,
it was.
right? There was another comment about somebody losing weight.
Vaguely remember that, but yes.
Now, these communications continue through the time of the murder, right?
Yes.
And up until the end of the records, which were about a week after the murder.
From best I remember, yes.
So it wasn't uncommon for my client to be speaking to Raekwon Howard.
No.
Your belief is that my client killed one of his people, one of his group.
Associate, maybe, yes.
Doesn't that prove more that my client is not part of all of this? That he's not at war with this group like the others that are involved? They can't give you the answer.
Sorry.
You got to look at me.
He stood up. Sorry. No, I don't know. Just without knowing all the context of the conversations, I don't know what they're saying to each other.
You saw the text messages.
Yeah, I saw them teasing each other, but that doesn't necessarily mean that it's not still bad blood there. I think it's weird that they talk as much as they do. I'll give you that, but it's doesn't mean that they wouldn't have to.
Let's break it down. You view my client, you're like, he killed somebody that's part of this group 6 block. It's weird that he's talking to somebody from 6 block, right?
Yes.
Doesn't that weirdness go away when you finally admit, oh, wait, maybe my client didn't have a problem with this group 6 block and that was everybody else that was still battling on the streets?
I'm sorry, repeat the question.
All right. You think it's weird because you believe that my client has this problem with all the group 6 block, right?
Yes.
Doesn't that weirdness, that weird feeling you have, doesn't that go away?
No.
You admit that.
And the reason that
I could ask a question.
Sorry. Go.
All right, we just need one person speaking at a time. So let the attorney ask the question and then we'll let the witness answer the question without interruption on both ends. Go ahead and ask your question.
Doesn't that weirdness go away if you realize, wait a second, if Hakeem gets along with Raekwon and they're even joking around, and you can't speculate whether it was positive or negative, maybe he isn't part of this rivalry in between the two. That clears up the weirdness.
It does not, because he mentions Bibby almost every chance he gets.
Sidebar, Your Honor?
Okay, let's come sidebar.
The terminology. That's it.
Give us.
We say a pre-meeting, it's just a meeting.
You have a conversation with Dominique Barner, who's now about to become a witness in a case, and the very first meeting that you have where all of you are in there is not recorded.
That's correct.
Then you go into
All right, we're gonna pause. Hold on, can I hear myself? Hold on, let me go mute the other thing. Hold on. What lady was on live? What you talking about? All right, we're gonna pause the rewatch of Detective Smith, since the lunch break should be over in about 5 minutes. It definitely seemed like they got tunnel vision on the investigation for sure, based off Detective Smith testimony. Dior said, "Can I call in?" I don't do call-ins, y'all. I don't have the patience to deal with trolls and all that, so I don't have people come up. I used to try to do that, but yeah, I don't be having time. Don't be having time. I ain't got the patience. Unless you like a day one person that have been on my channel for a while, those are the only people I do allow to come up. But yeah, just a random person that just popped in, yeah, I don't do that. I don't have patience for it. Let me see. What's reality said? Hold on, let me put it on the screen so I can see it. So no one was snitching at first. What evidence did the detective find to make him believe Ksoo was the shooter? Because his DNA on Butter gun. So I believe they went off of, based off what we just listened to, I feel like the detective went off of the fingerprints that were left on the guns in the car. Now, mind you, they got Butter day one because his DNA was at the home, right? So they got Butter for sure day one, and fingerprints and all that. So they got him day one. But I do feel like that's why before they even went to do a warrant, or before they even talked to Butter, they did the Instagram search of his Instagram and stuff and all that. Now, I'm still unclear, when did they talk to Raekwon Howard originally? To know that it even was communication on Instagram. Betty said the informant probably had, the detective probably had an informant that gave him information. For sure. They definitely got informants that do that for sure. For sure. This is like the YSL trial. Oh, are they back? I think they're back. They're about to be back. Why ain't pop up on my screen? Hold on, they back.
All right, Mr. Robinson, you of course have been present throughout the entirety of your trial, and you've seen all of the evidence and witnesses that the state is intending to introduce against you. Is that correct? And you understand, sir, don't you, that it's the state's burden to prove this charge against you beyond a reasonable doubt? That means that you do not have to prove or disprove anything in this case. Do you understand that? That also means that you do not have to testify, again, because you do not have to prove or disprove anything. You have the absolute right to remain silent. Do you understand that? On the other hand, of course, you also have the absolute right to testify if that's what you wish to do. Do you understand? Now, you have two very skilled attorneys whose advice you should listen to and consider. But at the end of the day, the decision about whether or not to testify or not testify is yours and yours alone to make. Do you understand that?
Yes, ma'am.
That is, Ms. Kawas can tell you one thing, Mr. DeCoste can tell you another, but only Hakeem Robinson can decide if you want to take that stand and testify. Do you understand that?
Yes, ma'am.
If you choose not to testify, I will instruct your jury, as I already have in the beginning of trial, that in every criminal proceeding, a defendant has the absolute right to remain silent, and that at no time is the jury permitted to draw any inference of guilt on you exercising your right to remain silent. Do you understand that?
Yes, ma'am.
I would also tell them that the fact that you did not take the witness stand must not influence them in any manner whatsoever, or influence their verdict in any manner whatsoever. Do you understand?
Yes, ma'am.
On the other hand, if you choose to testify, you will take that witness stand, you will be sworn in to tell the truth, and you will be treated just like any other witness. You will be examined by your attorneys. You would then be cross-examined by the state attorneys. And if you have any convictions for felonies or crimes of dishonesty, then that fact would be able to be brought out against you to impeach your credibility. Do you understand that? And so that we're all on the same page, state and defense, does Mr. Hakeem Robinson have any convictions for felonies or crimes of dishonesty?
I believe he has a crime of dishonesty.
You have that judgment and sentence, and you've shown that to defense counsel?
I don't think I've shown it to them, no.
We know
Okay.
that.
Right, but,
And I believe that is the only one, but I am aware of that.
okay, so you're not contesting that?
No.
All right, so let me explain to Mr. Robinson what that means is if you were to testify, the state would be allowed to ask you two questions. They would say to you, Mr. Robinson, have you ever been convicted of a crime of dishonesty? And if you are answering truthfully, you would have to say yes. Then they can ask you how many times. And if you're answering truthfully, the answer would be one. Now, if you say no, or I don't know, or hemming and hawing on that, they then would be able to actually introduce the certified judgment and sentence, which will indicate what the crime is for. Otherwise, they would never get to know. They're not entitled to know what the crime is for. Do you understand that process? Okay. Have you had enough time to consult with your attorneys about whether or not you wish to testify?
Yes, ma'am.
And have they answered all your questions to your satisfaction with regard to that issue?
Yes, ma'am.
Do you need any more time to consider your decision? Have you made a decision about whether or not you wish to testify? And what is your decision?
Not testifying.
You're not testifying? Has anyone pressured you or threatened you in any way in order to get you to make that decision? Has anyone promised you anything in order to get you to make that decision? Have you made that decision freely, willingly, and voluntarily? And is that a decision that you and you alone, Mr. Hakeem Robinson, is making here today?
Yes, ma'am.
All right, thank you, sir. In addition to having sat through the trial and seen the state's evidence, you've also gotten to see your attorneys cross-examine the state's witnesses. You've also gotten to see your attorneys present witnesses and evidence on your behalf. Is that correct? And are you satisfied with their representation so far?
Yes, ma'am.
Are there any other witnesses you wished that they would call that they haven't called?
Yes, ma'am.
And who is that?
Well, I mean, no,
Oh, okay. So you're satisfied with the witnesses that they've called on your behalf? Okay. Are there any exhibits or other items in evidence that you wished that they would introduce that they haven't introduced? Understanding the CAD report is coming in here in just a moment, so that will be introduced. Other than those items, anything else that you wanted them to introduce that they have not introduced? Okay. And again, you're satisfied with their representation? All right, sir, thank you. You may resume your seat. All right, then that being the case, when the juries come back out, I'll allow the defense to introduce that edited CAD report that I'd already ruled on. That will be defense exhibit number 4. So we have going to the jury, just so the record's clear, we have defendants exhibit 1, 3, and 4. And that is as to Mr. Hakeem Robinson. Okay, is that correct?
Yes, sir. And just so I'm clear, what was marked originally as 2 was the entire CAD report, which was not introduced to go back to the jury. That was then supplemented, not supplemented, but exhibit 4 is what is the redacted CAD.
Correct, correct,
Now we have exhibit 1 that's been moved in, exhibit 3 and 4, but we have no exhibit.
correct. All right, and then after the CAD report is entered, the defense will rest in front of the jury?
Yes, Your Honor.
Okay, so that we don't have to bring him out, move the CAD report in, rest, and then send him out again. Would you like to make your second JOA at this time? All right, go ahead.
Ms. Cross is making that. I don't know. Is the charge conference also happening before close?
Yes, it is.
All right, I just needed that. But I didn't want to stop the full floor and let Ms. Cross again.
Okay, go ahead, Ms. Kawas.
Thank you, Your Honor. So at this time, with the defense, so Mr. Robinson, formally resting his case after presenting the witnesses that we did present. The standard at this time, as the court is aware, has changed. Prior to making this motion, second motion, I do want to renew all previous motions and objections that have been made up to this point. At this time, the standard has changed in that no reasonable juror, based on the evidence that was presented to this court, could find Mr. Robinson guilty of the crime charge. It is first degree premeditated murder. I'm going to echo the argument that I made previously in that for the first JOA, which is the ultimate issue in this case is yet we are not contesting that the state in fact did prove that the crime was committed, a first degree murder. The issue here is who committed that crime. The evidence that they have presented, while they have presented DNA and fingerprints and phone records, that is all conceivably just circumstantial evidence that shows that none of that directly proves that the shooter in this case is Hakeem Robinson. That came from the testimony of Donnie Garner and Hakeem Robinson, well, not really Hakeem Robinson Sr., only because he wasn't present. Based on the fact that those 2 witnesses judged and believed that they were heavily, their credibility was torn to shreds basically because of the inconsistencies in their testimony, the fact that they have been promised things in exchange for their testimony, and mostly because they said if they didn't testify that it was Hakeem Robinson, that they would be against their deal, that their credibility has been attached to a point that I don't think any juror could find their testimony credible, and I would ask at this time for the court to, for that reason, to grant our second judgment.
Okay, does the state wish to respond?
Not unless the court has any specific questions.
Oh, I have no questions. All right, I do acknowledge the standard has changed. At the same time, I also acknowledge that issues of witness credibility, as all counsel here well know, is an issue for the jury's determination. Whether they believe the defense witnesses or whether they believe the state witnesses is not for me to decide. That is for the jury to decide. So that being the case, I'm going to deny the second motion for judgment of acquittal. All right, then I guess we need to do charge conference then, so that when the jury comes out, we will, well, the state will let the defense rest in their presence. And let me just ask again, is there a rebuttal case from the state?
No, Your Honor.
Okay. And then we'll be prepared to go into closings, but then let's do charge conference now. And I'm going to begin with Whitaker. So I know Mr. DeCoste isn't here at the moment. So this.
Directly to those arguments, and we want to bring that to the attention like that before, so that any arguments can be made. And I didn't want to be a situation where those arguments was interrupted for objection, so this wasn't go. So I'm going to, as it relates to Halliburton, there's also another case called Lena versus State. I will send it to everyone, which basically stands for the property. It's actually what is yellow key flag on Halliburton is Lena. And it basically states that when the defense calls witnesses that were on the state's witness list, we are allowed to also going to be making a Halliburton argument as to one specific witness, which would be Raekwon Howard. And I just want to just premise what I'm going to be arguing, so everyone can have time to respond. Our argument would be is that we shouldn't be allowed to comment on the state's failure to call Raekwon Howard as a witness. He is a witness that is peculiarly within the control of the state. In that, if you recall, Your Honor, I filed a motion to exclude Raekwon Howard for his invoking his Fifth Amendment privilege during his deposition. You denied that motion, and then we came here, and the state failed to call him. We can't call him because he has several open cases with the state of Florida. I can't confer immunity on him. The state can, which would have allowed him to have been able to take the stand, answer questions without worrying about incriminating himself. So I am not in a position to be able to call him because I have not conferred immunity on him. I believe that this applies particularly just to this witness, because there is no way for the defense to be able to put him on the stand. So I will be arguing that Halliburton actually supports our position that we should be able to comment on the fact that the state did not call Raekwon Howard because we are not able to.
All right, why don't you send me those cases so I can review them? But let me go ahead and begin, and I'll give the state an opportunity to respond. But let's begin with Mr. Whitaker's jury instructions, if we might. All right, so I did receive the latest draft version, and that's the version we're working off of. So both for state and Ms. Schlacks, on behalf of Mr. Whitaker, I like to go page by page, and I want to hear either consent or object to each page of the instructions, because as you know, one hard copy will go in with the jury during deliberation. So let's begin with the cover page. Any objection?
No, Your Honor, unless I say something, I have no objection since I provide.
Okay, thank you. Next page begins members of the jury. Any objection?
No, Your Honor.
Statement of the charge. Any objection? Or charges, excuse me. Hold on, I'm not.
I agree with Mr. McRocky's suggestion. I do not think under the facts of this case that it makes sense to instruct on justifiable or excusable.
So you want those eliminated? Okay.
Agreed.
All right, so that entire highlighted area will be removed. And are you making these corrections as we go? Because I will need a clean copy of this.
And Ms. Bledsoe, sitting in the third row, she is doing it probably faster and better than I can, because she corrected all the formatting errors that existed.
Okay, very good. Thank you.
Yes, we are doing it. We are both doing it.
Okay.
So it'll look like it is, and the court can look at the screen and see how it's going to look.
I don't have a screen that's showing me anything. It's not on my screen. Do I need to press a particular button?
Check the computer.
Yeah, we all have it, yeah.
Okay, now it's on my screen. All right, then we have the instruction on murder in the first degree.
No objection as presented.
Okay,
We'll take away the highlighted or principle.
Yes.
okay.
Just the highlight, not.
Just to highlight those three words in element number 2. Okay. When there are lesser included crimes or attempts, do you want to take away the word or attempt, since that's not charged or focused here in the title?
No objection.
Senator, I think attempted first-degree murder should be part of it. Mandatory lesser included offense.
It's not mandatory. It is-
Not attempted.
Yes, we'd ask for attempted.
Oh, you did ask for attempted?
We would.
Okay.
Honestly, I did look these over. I honestly, that just went right over my head, but yes, I absolutely think that should be part of the instructions on the facts that are alleged by the state.
All right, I'll hear from the state on that.
Your Honor, there's no evidence that this is an attempt. The victim was killed at the scene by the act that would constitute the attempt. I think it's.
Yeah.
I just don't, I'm looking, my understanding is that the only mandatory lessers are,
Second degree and
second
manslaughter.
and man, which I've provided. We're going to look at it right now together.
Yes, it's not a category 1 mandatory lesser.
I would have to concede that it's not mandatory. In fact, I don't even see it as an option under category 2. Is there a second page, Alan?
Yes.
Okay, I will concede that it's.
Okay. So let's just remove those 2 words on the title of attempts or attempts. And so do you agree with second-degree murder and manslaughter as the 2 lessers to be given?
Yes, Your Honor, I concede that I'm not entitled to that.
All right. And to the instruction itself, are you agreeable to that?
Yes, Your Honor.
Very good. All right, then we have the instruction for second-degree murder that's covered on 1 page. Any objection?
No objection as viewed right now. You can take the highlight out.
All right, so we'll take out or principle under element number 2, and with that edit, any objection?
We're taking out the highlight, not or principle.
Isn't that what's highlighted?
Yes. So she's agreeing to the highlighted part.
Oh, you are agreeing to it. Okay, all right, then leave that in. Is that also with first-degree murder? Okay, I misunderstood. All right. Then on manslaughter on the next page, which is an instruction with 2 elements, any objection?
No objection to taking the highlight out and including the language or a principle as to the second element. Also, no objection to removing the justifiable or excusable homicide.
All right, so that's both a line in paragraph 2 and a line in paragraph 3. All right, very good. All right, then we have burglary with assault or battery in count 2. One thing I noted is there were some words missing in after element 2 in that first paragraph that says you may infer after the word crime, there should be inside a dwelling. It just says crime dwelling. Inside a dwelling, correct. And then in the 3rd big paragraph, you have and or, which is always problematic at jury instructions, and considering it's burglary with assault or battery, I would suggest that the and needs to come out.
No objection to that suggestion, Your Honor.
All right, well, I just need to find it.
It's in the 3rd line of the 3rd paragraph. So take out and, correct. Okay, with those edits, any objection from either side? All right. Then we have the principles instruction on the next page. And I had a question about this in terms of its placement. Is principle only applicable to the first-degree murder case? Or the state's theory is it's as to both cases?
That's to both.
Okay, so it will come after both instructions.
That's right.
And does the defense agree with that? I mean, I'm giving it either way, so.
Right. No, the placement I'm not concerned about.
All right, what about the language? Because there's some highlighted language in the principles instruction. Because he could be a principal to the crime charged or to any of the lesser included crimes.
I would ask for lesser included offense to be taken out. I think it just is confusing.
But then would that lead the jury to believe that principle only applies to the crime charged and not to any lesser? Because it does apply to the lessers.
No, it certainly does.
What I think I would add, though, is instead of saying or lesser included offense as the evidence supports, since they're being presented with different lessers or any lesser, I would just add the word any before lesser on both of those sentences. That's my suggested clarification.
Well, and isn't the state seeking this for the burglary as well?
Yes.
So wouldn't you just want it to be, it is not necessary for a principal to know every detail of how a crime will be committed? Because before that.
Well, the instruction requires you to name the crime. Well, let me say required. It is a very strong suggestion, and it has in brackets that you have to name the crime charged. We can do a crime, if you all agree to that, but.
Yeah, I understand what the point is.
Yeah, this instruction is only as to first-degree murder, not burglary. So if the state's proposal is that it applies to both crimes, then we need to clarify this.
this part of the instruction deals with the concept of how the murder occurs, where burglary, I mean, the defendant has to have a conscious intent that the entry be done with the intent to commit a crime therein.
Right?
So the details of how that occurs applies really more to first degree murder than to burglary. I think we can fashion it with both. It's just, I believe this is a standard with regard.
Yeah,
to
this is the
first-
standard.
I'm saying with regard to first degree murder. So I don't think, let me pull it up, but I do not believe that,
Yeah, you're right. This is a standard instruction for being a principal to murder, not necessarily to be a principal to a burglary.
that's the reason why I did it like that, because it's the concept, yeah. So it says for first degree, for murder,
Right.
has that special, it says only, and it says in attempted homicide cases, or homicide cases.
Well, then
Although the next paragraph says that it doesn't know if it says it's not necessary for the principal to know every detail. So I think it's perfectly allowable and permissible for the court to say to know every detail of how the murder in the first degree or burglary with assault or battery were committed, or any lesser included offense, as long, so I mean, I think we can do it.
I'm fine with that.
It's just wordy.
Yes. Words that I'll have to say, but that's okay.
And obviously, I like instructions to be simple. I don't think this is an issue because the state's evidence is the defendant made entry, made the assault. So the principal theory, although applies to the burglary, is not nearly as important. So I don't think it's necessary to give the burglary, and we're fine giving the instruction that we gave,
So without adding the burglary
adding the
language.
burglary and
Okay.
just eliminating not the words, but the highlights. And I think we could put or any lesser included offense, or any lesser included offense. I think that's it.
Your Honor, actually, I would request that final paragraph is not included. Because it actually dictates that that paragraph is for situations where the criminal statute includes a higher degree because a firearm, deadly weapon, or weapon was carried during the commission of the crime. So it's trying to capture those situations where perhaps I conspired with Mr. Cooper to, do some kind of robbery. I didn't know he was going to bring a firearm. So
Can you pull up the instruction again? I thought it was a preceding paragraph.
I'm looking at the standards on the Florida Bar website, Your Honor.
All right,
And
let's see.
I'll go ahead and read it into the record. Before that paragraph that we're discussing, it actually says, oh, well, the court can see it. It's on. And that's not the situation. There's no weapon alleged in the burglary. There, of course, is a weapon alleged in the homicide.
So what are you saying? Because the state has alleged 775 language involving a firearm in the indictment for first degree murder, but they have not alleged that for the burglary. So that's what the state is saying. They're not going to include the burglary language in this instruction. They're willing to forego that, but since this is a first degree murder and does involve a firearm and is charged with 775 language, I think it would be appropriate to give as a principle.
Okay, so I guess the only question at this point is how we deal with lessers.
Right, so the suggestion was, as is highlighted, I don't disagree with that. I think it makes sense to say, doesn't need to know every detail of how the first degree murder or any lesser included offense as the evidence supports, or as the evidence establishes, or as the evidence justifies. Those are the languages used in the instructions otherwise. I think it's appropriate to say that because the principal theory would apply to second degree murder and to manslaughter.
I would have to concede that it does.
All right. So if you will make those slight corrections, just add any, there we go. All right, thank you. All right, date of crime instruction, any objection? Next page.
No objection.
I'm getting there. I'm just making the corrections.
All right.
Others. I'd like to
Venue instruction, any objection?
No objection, Your Honor.
We have the standard plea of not guilty, reasonable doubt, burden of proof instruction, any objection?
No, Your Honor.
Weighing the evidence instruction. Number 7 and 8 are duplicative. 7 should be pressure or threat, not inconsistent statement. You put that in there twice accidentally.
Yeah.
But with that correction, I believe 6 applies, 8 applies, 9 applies. I don't believe there's been
Yes, Your Honor.
any testimony of reputation under 10 and actually no testimony on 7.
Your Honor, there was testimony in regards to 7. Mr. Varner was impeached by myself.
About being pressured or threatened.
And, oh, I'm sorry, I thought.
Yeah, 8,
It's sort of inconsistent.
8 is prior inconsistent statement, and I will give that for sure. But what I'm saying is 7 and 10, I don't believe there's been any testimony to support the giving of those factors.
I concede on 10, I would ask, based on all of the evidence and cooperation agreements that were in here, I think one could logically argue that Dominique Varner and Abdul Robinson Sr. do feel the pressure and threat of their pending charges. They've also received a benefit in order to testify that has to be considered, but their current situation, I would say that that is worthy of the jury's consideration when they're evaluating the credibility.
All right, any response from the state, or you agree we can give 7?
I agree we can give 7, but I need to get the language right.
We need to get 7 corrected. All right, so 10 is the only one we're eliminating from the factors for consideration. All right,
Just give me, I know we want to go fast, but
okay.
I'm trying.
Something like, has any pressure or threat been used to?
I just want to get it directly from the.
Sure.
You have the language?
Yeah, he copied it from the standard.
Oh, my God. Oh, my God. Obviously, I didn't do it.
Maybe not.
I just read it. I can't understand. Go ahead, read it. Read it.
Read it. Has any pressure or threat been used against the witness that affected the truth of the
Well, you're
witness?
going way too fast.
Yeah, I don't think he can type that fast.
Oh, sorry. Had any pressure or threat
That,
been used against the witness
yeah.
That affected.
that affected the truth of the witness's testimony?
And it's apostrophe S on witnesses. Sorry.
No, that's not right. That's right. Right?
Okay, and did you eliminate number 10?
Yeah.
Okay, on that next page also? Oh, yeah, unhighlight those. All right, on the next page, the defendant becoming a witness, obviously he didn't testify, so you can eliminate that paragraph. The other thing I noticed on the paragraph beforehand, there's just some ors missing. So on line 2, you must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, or, right there.
And strangely enough, Your Honor, I only know this because it's also part of my PowerPoint. There isn't the word for.
No, but they're brackets.
Oh, so then you're.
They're not ands, is what I'm saying. Yeah. And there's another or. Can you go back to that paragraph?
I can. The gallery was telling me what to do. So.
Oh. All right, so or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case. So before the word hopes, if you'll add an or.
Trying.
Huh?
Our Dell desktop is very,
It froze.
it locks up on us.
Okay. There you go. Did it unfreeze?
Okay.
And Your Honor, in regards to the next page, defendant not testifying, I agree, defendant not testifying.
Yeah, those are the two paragraphs I give.
I
Okay. We just need to unhighlight them as soon as we get there.
Okay.
Okay, yeah. So you agree to defendant not testifying instruction?
yes, Your Honor.
Okay, next page, rules for deliberation. Those are the standard 8 rules. Any objection?
No objection, Your Honor.
Cautionary instruction, any objection?
No objection, Your Honor.
Notes instruction, any objection?
No objection. I apologize, though, there is one instruction.
On notes?
Single defendant.
Oh, that comes later.
Okay, it's coming.
It does. Yeah, it's coming. Verdict instruction, any objection?
No, Your Honor.
Okay. Then we have the verdicts, and there are 2 of them. There's verdict count 1, any objection?
No, Your Honor.
Verdict count 2, the only suggestion I would make again is removing the and or. It should just be or on both of the special findings. Well, on one finding, and the other it says nor, it should just be or on both of
No
them.
objection to that change, Your Honor.
All right. Otherwise, any objection to verdict count 2?
It should say or nor.
It should be or. There's not a neither preceding it, so there shouldn't be a nor.
I got it.
Okay. All right. Then we have single defendant multiple counts instruction. Any objection?
No objection, Your Honor.
Verdict and submitting case to jury instruction. Paragraph 3, I eliminate because I do not let them have cell phones, tablets, or laptops in the courtroom. So with that edit, any objection to that standard instruction? All right. And then, of course, I did receive from the defense the request to include the motion for independent act instruction. That's 3.6L in the standards. Any argument you wish to make?
Just based on the facts that they have been produced by the state of Florida, obviously, it is our intent to argue that this is not a proven that Mr. Whitaker is a principal of any kind, according to the one and only witness produced by the state who speaks of Mr. Whitaker's alleged involvement in the homicide. The undisputed testimony has been that supposedly there was some kind of plan which in some way Mr. Whitaker acquiesced to and ultimately did not do it. Therefore making it an independent act of the actual shooter in this case. And I believe I cited to the court, I didn't, I just needed error in not doing that. The case of Gary v. State found at 330 Southern 3rd 118. It is a November of 2021 decision from the 2nd District. And talking about under their analysis, and in this particular case, the issue was requested jury instruction, which was denied. And the court, in reaching their decision, talks about this discretion of the court is limited in criminal cases because the defendant is entitled to have the jury instructed on his or her theory of defense if there is any evidence to support this theory and the law of the theory is recognized as valid under the law.
Okay, I'll hear from the state.
Yes, Your Honor, the key word there is any. And the state is very cognizant of the fact that we should not have a reversible error based on jury instructions. However, there has been zero evidence that this was somehow an independent act. No one has testified that the defendant was a limited participant and, did not contemplate what would happen. The
Supports the giving of the independent act instruction. That said what specifically?
And I will somewhat paraphrase, but in my process, specifically in my cross-examination, Mr. Garner ultimately said that he was not aware. I'll start with, I guess, the absence of evidence. He was not aware of any statement that Mr. Whitaker ever made indicating a desire for Mr. McCormick to die, and any kind of statement even acknowledging the plan. His testimony was limited to, we all just knew. And then I actually brought out in cross-examination more than that his testimony is, well, I just assumed there were conversations before they picked me up. Everyone just knew what time of day it was. Then his only statement is at the apartment complex, he claims it was spoken about. He doesn't attribute any of those statements to Mr. Whitaker, but in a very general group sense, it was spoken about that when Charles McCormick walked out of his apartment, that Leroy Whitaker and Hakeem Robinson would both jump out of the car and actually ambush him. And he kept using the phrase, rundown, I think was the phrase. He then indicates that they go to the complex. He says, again, there's no discussion. And then ultimately, he alleges Mr. Robinson jumped out of the car and ambushed. He doesn't speak about when this plan supposedly changed. He doesn't attribute any kind of statement or act by Mr. Whitaker. According to Mr. Barner's testimony, Mr. Whitaker is literally just sitting.
Well, I think he said that Mr. Robinson got excited and jumped out ahead of time.
I don't know, but he doesn't attribute Mr.
Well,
Whitaker to anything.
at that point, no. But what about the burglary? Because you include this as part of the burglary. And the testimony from Ms. Buckley was that two people went in, both people assaulted her. And according to Mr. Barner, that second person was Mr. Whitaker. And of course, both Mr. Barner and Mr. Whitaker's DNA was found on her clothing or on her person.
I would concede this would be inappropriate for me to even attempt to argue in regards to the charge. But I do think, based on Mr. Barner's testimony himself, that he has provided us with ample ammunition to be entitled to this.
And Your Honor, can I say something?
Okay, one more thing and then I'll rule.
Um,
Because your request did request it for both homicide and burglary, but now you're conceding this does not apply to burglary. Okay.
Everything that Ms. Schlacht just argued is arguing against the principal instruction. Is what the cross-examination against Mr. Barner is whether or not he had a conscious intent that the act be done and participated in some way in making that accomplished. Everything she just said. Independent act occurs when a person is a participant somehow in the crime, and when they participated in, let's just say, the petty theft from Walmart, and then the defendant goes in after a petty theft and decides to kidnap and murder everyone in the store that was not contemplated and outside the foreseeable context of the agreed upon plan. So the cross of Mr. Barner goes directly to whether or not the defendant is a principal, not that he was subject to an independent act.
All right, having read the Gary case and now having read this independent act instruction and recognizing that if there is any, as we learned, scintilla of evidence that supports a defense theory, the instruction should be given. I don't see that being the case here. I'm not going to give the instruction. All right, so that is denied. Anything else on behalf of Mr. Whitaker or the state in Mr. Whitaker's case? So let's get a clean copy of the instructions otherwise. Anything else?
No, Your
Okay, then let us move on to Hakeem Robinson's jury instructions. All right, who's going to be handling the instructions? Okay. So similarly, as we just did with Mr. Whitaker, we'll go page by page. So tell me if you consent or object, the cover page. Members of the jury page. Statement of the charge. Then we have the introduction to homicide with justifiable and excusable. All right, so we'll take out that entire highlighted portion.
Can't get. It's just glitchy. It's just glitchy.
All right, then we have the instruction on first-degree murder, which I think we need to remove the language or a principle on element 2. Okay. Otherwise, any objection to that instruction? Then lesser included crimes or attempts. Again, I would suggest removing or attempts, but otherwise that would be the instruction and the 2 required lessers of second-degree murder and manslaughter. Okay. And the instruction on second-degree murder, just removing the or a principal language off element number 2. Any objection to the remainder of the instruction? Manslaughter instruction, eliminating the highlighted language of justifiable and excusable. Do you agree with that? Okay. All right. And with the rest of the instruction? Right. So let's remove that page altogether. Can you just move it up a page? There's a blank page, Mr. Mizrahi.
I can.
Okay, then we have date of crime. Can you just, on that, it says the state must prove the crimes were committed. He's only charged with 1 crime, so let's just remove that S.
I got most of them. I missed that one.
Thank you. Venue instruction, any objection? Plea of guilt, of not guilty, reasonable doubt, and burden of proof instruction, any objection? No, this is not the page. This is just the standard one that I've read already. No objection? Okay, weighing the evidence, we have similarly 7 and 8 are duplicative. We need to add the 7 of pressure or threat.
Got it.
Okay. And would you agree that 10 does not apply? There's been no testimony of reputation evidence. Okay. But we'll give 6, 7, 8, and 9.
Yes, and I think I had the same problem, but I can see that Mr. Mizrahi is switching it out with the language that was,
Inadvertently left out, yeah.
Just give me a second to catch up.
Why are you eliminating number 9? That was fine.
I was eliminating the,
Oh, okay, I got it.
just give me a second to cut.
it does say has to do with convicted of a felony. I would rather that it, include also false statement.
I don't think we had testimony of anyone being convicted of false statement. Yeah, felony, yes, but not misdemeanor involving dishonesty or false statement. That's all right. We'll just have number 7 typed in.
I don't know if it's faster to do it that way or not. But
Yeah, that was
that's the way
better.
I did it.
Okay, we are on the next page of that same instruction. Oh, there we go.
Almost.
Almost. Okay. Moving along, similarly, Mr. Robinson decided not to testify, so we can remove the paragraph about the defendant becoming a witness. And then this is the page where we were adding the ors. So if you can do that in that 3rd paragraph.
That's in the you must consider the testimony.
Correct. There we go. And then the next instruction on defendant not testifying, any objection? No, no. Yeah. Yeah. Thank you. All right, we have rules for deliberation, any objection? Cautionary instruction, any objection? Notes instruction, any objection? Verdict instruction, we just need to do, instead of as to each crime charged, as to the crime charged, since he's only charged with one offense. With that revision, any objection to this instruction? Okay. Then there's the verdict with the 4 options, any objection?
Yes, Judge, the defense would request that since Mr. Robinson is innocent unless he is proven guilty, that it should start with the jury find the defendant not guilty and then follow it. So I would request that might be first.
Okay, and I get those requests sometimes here too, that'll be denied. It's the state's burden, they have to prove the main crime charge, so we put that first. Thank you. And last instruction, verdict and submitting the case to the jury. Again, I don't let them have electronic devices, so paragraph 3 can be eliminated, but otherwise, any objection to that instruction? All right, that will conclude the charge conference. And if I can get, obviously, 1 clean hard copy of each and clean hard copies for counsel. I don't need to wait to have them before we start closings, obviously, but I do need them by the time we charge, which at this juncture might be tomorrow. I'm hopeful that we can get through all the closings today. If we can't, we'll see how we go. I don't know how long y'all are going to be, but I'm not going to charge them today and let them start deliberating at nighttime. So my hope is that we can do all the closings today, and then I'll bring them back tomorrow at staggered times to instruct them on the law. The state is going to give 1 joint closing, and then we'll excuse Mr. Robinson's jury for the defense Whitaker's closing and any rebuttal the state might make to it. And then I will excuse them for the day and tell them to be back here tomorrow at 9 o'clock. At that point, we'll bring in Mr. Robinson's jury, let the defense do their close, and the state can do any rebuttal to it. And then I'll excuse them and have them come back at 9:30 tomorrow where I can instruct them. I mean, y'all can stay here and listen if you want. Sure, I'm not saying you have to leave the courtroom. You don't have to, but okay. Well, if you're leaving it to Ms. Schlack, she can decide if she wants Mr. Robinson in the back or seated there, but the attorneys, of course, can stay. I don't have an issue or a problem with that. Yes.
Just so I can gauge, and I don't have to interrupt while we, other attorneys are going, is there a time that your Honor is thinking of going until, because it will let me know that I'm not going to be going today, I am.
I guess I'll have a better indication of that after I hear the states. I mean, I have no idea how long you're going to go. We've been going till 6:15. I mean, I'm not keeping them here till 8 o'clock at night. So, you know, we'll see. If we might have to go till 6:30 to finish it up, I don't mind going beyond 6 o'clock. Ideally, if we can put this all in, it's 2:30 now. So I would hope that in the next 3.5 hours, we could do all the closings that are necessary. I will say before closing, again, just so we can all be on the same page, and I know there's some additional matters that the attorneys raised. I do expect everyone to act professionally, civilly, and according to your rules of professional conduct. There shall be no name calling of defense counsel or the defendants. There shall be no denigration of defense counsel or the defendants or of the defense theory of the case. You all know what you can and can't say. There shall be no send a message arguments. There shall be no golden rule violations. There shall be no just what we call bad behavior. You all know how to behave. I expect you to continue to behave. While during the course of the trial, I did not allow, as we discussed at sidebar, any objections of improper, because certainly that's not a proper objection to evidence. That is a proper objection during closing. So if either party believes that an improper argument is being made, you absolutely may stand up and say improper. I do need grounds for an objection, so don't just stand and say objection. I need grounds, but improper is a proper objection during closing. Does everyone understand that?
Yes, Your Honor.
Yes, Your Honor. Okay. Anything else we need to address before we bring the jury out to commence with closings?
Yes.
Okay, let's start it in order. State?
I just need a moment to load up PowerPoint real quick.
Okay, that's fine. Mr. Whitaker? Okay, we'll do that. And Ms. Kawas? Understood. And so, Mr. Mizrahi, have you had an opportunity to read the Lena case? That's 901 Southern 2nd 227.
I have not, Your Honor, and obviously the defense claims they've listed all these witnesses as well, so there's that.
Well, let me read the case and see if that makes a difference.
And certainly that argument should not be made to the unlisted witnesses.
Right, I think they said it was only to be made to regarding Raekwon Howard.
This argument is to, for example, Jarvis Roberts, Michael Williams, and the two police officers that we presented, they were all state listed witnesses that we failed to call, that we decided to call in our case. But I would agree with Mr. Mizrahi that we couldn't say they failed to call Johnny Schatz. That's not the same, because that wasn't on their witness.
Understood. That's what you meant, Mr. Mizrahi?
Yes, and
Okay.
there's a distinction. I'm glad that
Or the sister?
there's a distinction between Howard and the state witnesses. Based on the Lena case, although I haven't jeopardized it yet, I believe that argument is permissible for them to say, these are state witnesses, they didn't call them, we had to call them.
Right, to witnesses that they call.
Right.
What Halliburton addresses is witnesses that neither side calls, and that defense says, where's so-and-so? If they're peculiarly within the province of, or the jurisdiction of the state, right?
The only witness I think that falls into that category is the witness Raekwon Howard. So Lena is only applicable to the cases that, the state witnesses that we call in our case.
Okay, understood.
And then for Halliburton, we believe we should be able to make that argument as to Raekwon Howard. He is peculiarly within the control of the state in that he currently has open cases with the state. He refused to answer questions in our deposition. We can inability, we can't call as a witness. The only ones that could call him is the state because they can confer immunity on him to be able to testify in this case. They made a big deal about this witness. This is the incident where they, which came to our knowledge on the day that Arnold testified, that he is now saying, oh, there was this call to Raekwon Howard right before the murder, and he confessed to the murder. We objected to that being a discovery violation. We had no idea because he had never mentioned that before. We, of course, now our hands are tied. We can't call Raekwon Howard to the stand to put him on to rebut that evidence in any way, shape, or form.
But let me ask you, and if I recall, because this is different than a prior motion to compel I had involving Dominique Berner and Abdul Sr., who refused to answer some questions, which you all certified. I had a hearing on and determined they didn't have to answer those. With Raekwon Howard, along with Torgon Williams and Antoine McLaren, it was not a motion to compel answers. It was just a motion to exclude them as witnesses. I excluded Antoine McLaurin because other than provide his name, he would give no other information. So I excluded him as a witness. Raekwon Howard and Torgon Williams gave information, answered questions. When they invoke their Fifth Amendment rights is when I believe the attorneys were getting into the facts and details of their pending cases that would have implicated them. And what I said was certainly if they testify, the fact that they have pending cases is admissible, what the minimums, maximums are is admissible, facts and details of them, I was not going to compel them to disclose, nor would I exclude them for those reasons, but they did give answers to other questions. So I don't know if we have to parse out Raekwon Howard's testimony with regard to whether he's available to you or not, or whether he's peculiarly within the state's purview or not. But if it has to do with a phone call made in the car to him, alleged to have been made in the car to him by your client, I don't know that that comes under the Fifth Amendment right to remain silent. He did not invoke for that question. Okay.
So if you recall, when we did this motion to exclude, the main issue when I actually brought this up was, normally we wouldn't be able to go into the facts and circumstances surrounding pending cases under their relevance. We've now established through the trial the relevancy since the state put on Natalie Dance as a witness who testified that Raekwon Howard tried to kill her and Torgon Williams months later.
I don't know that Natalie Gant testified to that.
She did, it came back across.
Okay, but how does that make the state, the phone call in the car relevant?
So here's the
I mean, how does that make, how is that relevant?
Because I shouldn't be, if I wanted to put him on, limited in the fact that, oh, I'm only going to put on his testimony about the phone call. I should also be allowed to explore, for example, the fact that he's an impeachment witness to Natalie Gant, because Natalie Gant wasn't the person holding the firearm, it was Torgon Williams. I would have not been able to go into that testimony with him because he would have then invoked his right to remain silent. It's unfair to say that, oh, well, you could have called him for the limited purpose of addressing the phone call. I wanted to call, if I wanted to call him, I should be allowed to explore everything, including any bias that he may have or any reasons to color his testimony. He would not, on the advice of his counsel, and that case is still open, would not answer, and it's not to the other open pending cases, Judge. That one is peculiar because it's him being accused of trying to execute two of the witnesses in this case, one of which testified. So I'm now in this weird position of, oh, well, you can put him on, but you can't go into all this stuff that the jury should know about him and what he did, and, just present questions on that limited issue.
How does that make him peculiarly within the purview of the state?
They can give him immunity and put him on the stand. I can't.
All right.
They could have given him just a subpoena, no promise of, hey, listen, we're not gonna do anything more than give you immunity, which is inherent in their subpoenas, just for the testimony here. Allow me to then say, and be able to explore with him, you tried to kill Natalie Gant and Torgon Williams, who are from opposing groups, which they made as an issue. But more importantly, too, Gant is the one that had done, it was Torgon Williams. It's not
But doesn't the law preclude either of you, both of you, from putting a witness on the stand knowing that they are going to invoke their Fifth Amendment right in front of a jury at trial? Neither you nor Mr. Mizrahi would be able to call him as a witness knowing he was going to invoke on the specific facts of that pending crime that he has.
That's the liberty of just, well, I just don't want to. He has immunity. So what would happen there is the court would inquire and say, we have to compel him to answer the questions because it's not a legitimate assertion of a right. If the state is agreeing that anything you say won't be used against you. So you can't assert your Fifth Amendment privilege under immunity. So that's where that makes him peculiar to the state because they're the only ones that can confer immunity on him. Just because he says, well, I'm not going to answer any of those questions. I think the case law is clear. The next step would be we move to compel him. The court would then say, well, does he have immunity? If you have immunity, you can answer the questions. You're not properly asserting your Fifth Amendment privilege if there's a promise that it won't be used against you.
All right, how do you respond to that, Mr. Mizrahi? If you and only you have the authority to grant him immunity, how is he not peculiarly within your control?
Well, first of all, he could still invoke. I mean, if every person that we conferred immunity that had a pending charge, we would take sworn statements of every criminal defendant, confer use immunity, and then we know what their testimony is going to be at trial. The invocation is anything he say can be used in his pending criminal case. Me giving him use immunity doesn't absolve him of that. He still has a right of not against self-incrimination. So this whole concept of conferring immunity, maybe that works in a case where there's not a pending charge, or we give transactional immunity, but this is a collateral matter that has nothing to do with this particular case. It is impeachment on a collateral matter. As the court has pointed out, Raekwon Howard could be subpoenaed as easily as anyone else could be subpoenaed to come to this court and testify about what he knows about this case. And that is not peculiar within the state. We didn't even try to do all these things. They could have done it. We could have had this hearing on this Gantt issue that came up in the middle of trial. But whether or not they're calling a witness to impeach about whether or not he shot at one of the state's witnesses is so collateral to this case. It should not be admitted. They should not be allowed to make that argument. It implies that Raekwon Howard's answers would not be consistent with Mr. Barner's, which in fact they are.
All right, so I think I've heard enough from both sides. Based on the Lena case you gave me, I'm going to allow you to make the arguments as to the witnesses you did call. Based on Halliburton, I'm not going to allow you to make that argument with Raekwon Howard. I'm not finding that he's peculiarly within the province of the state to have been able to call him despite your arguments regarding immunity. I am also going to find that that is a collateral matter. I understand he's been accused of trying to kill two of the witnesses in this case. That doesn't make it material to this alleged phone call that he may or may not have made or had with your client. I do find that to be collateral, not material, and it would be in violation of Halliburton. So I won't allow you to make that particular argument as to Raekwon Howard. I think it's abundantly clear. And let's try to avoid as many sidebars as we can, please, during this closing so we can have a smooth and orderly closing argument for all parties. So at this time, if there's nothing else, can we bring out the jury, please?
And they have to rest, I think.
They do. They have to rest, and they're going to introduce their CAD report and then rest, correct? Okay, do you have that? I have the exhibit here. Let me hand it to you so you can formally move that in the presence of the jury. That's defense exhibit number 4. Okay. Let's bring the jury out, please. again for this delay. Things come up, they have to be dealt with by the court outside your presence, and so we have done so, but I assure you the case will be moving along much quicker from this point forward. I do have to ask during this lunch recess if any of you read, watched, or listened to any newspaper stories or even saw anything on social media with reference to this case. If so, please raise your hand. All right, and I see no hands raised. Did anyone attempt to speak to you, approach you, say anything to you about this case or the people or places involved in this case? If so, please raise your hand. All right, and I see no hands raised. Thank you very much. All right, we're still in Defendant Hakeem Robinson's case. So, Mr. DeCoste, you may proceed.
Thank you, Your Honor. Defense offers into evidence what's been pre-marked as defense 4.
I can approach.
Okay, yes. All right, defendants 4 will be accepted into evidence.
May I show it to the jury on the overhead?
Yes, you may.
And go to the next page.
Oh, that was sounding like cheering going back and forth. All right, y'all. The defense is about to rest. Then we're gonna get into the closing arguments. Hopefully, closing arguments ends today, so that tomorrow the judge will
Okay, thank you.
instructions and send them to deliberations. But we will see. It seems like it's gonna be a long afternoon.
All right, thank you very much. All right, ladies and gentlemen, now the state and both defendants have rested their cases. The attorneys are now going to present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Now, each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing. And of course, a little unusual in this case is we have 2 juries. So the state is going to give one closing argument to both juries. Then Defendant Whitaker will give its closing argument only in the presence of Defendant Whitaker's jury. You all will then be excused. And then Defendant Hakeem Robinson's jury will hear the closing argument from Mr. Robinson's attorneys. And then you all will be excused. This is our tentative schedule. So then I think that will take us through the rest of the afternoon. And tomorrow we will return at 9 o'clock for Defendant Whitaker's jury so I can instruct you on the law. Tomorrow, Defendant Robinson's jury will return at 9:30 so that I can then instruct you separately on the law. And then you will retire to each deliberate your separate verdicts. So while we are now nearing the end and likely will not be here, well, I don't know, but we had told you this would take to Friday. We might actually end a little early. I do want to still stress the importance that you must not talk about this case among yourselves or with anyone else. This case is not over yet. You still have arguments and the law. Those are 2 very important parts of the trial. So do not discuss this among yourselves until I excuse you to deliberate your verdict. But at this time, I'll call upon the state for its joint close. Thank you.
May it please the court?
Yes.
Why are we here? We're here today because on January 15th, 2020, a group of individuals, a family, co-defendants, Leroy Whitaker, Hakeem Robinson, their good friend Dominic Varner, and a few others, fulfilled their collective premeditated design, their plan to execute Charles McCormick. What was the reason? It was personal. was no justification for it. Charles McCormick did not deserve to die. He made a song. That song was disrespectful. But it's not just that it was a song. It's what the song referenced. Specifically, who it referenced. Willie Addison. Because Willie Addison wasn't just another person. You heard from Hakeem Robinson's sister who Willie Addison was. He was blood. Brothers. And Leroy Whitaker is Hakeem Robinson's cousin. Their blood. And Willie Addison's blood was spilled on January 15, 2019, along with Duval Robinson Jr., Hakeem Robinson's brother, Oregon Williams, Duval Robinson Sr., who you know as Blue, and a couple other people in the vehicle. Hakeem Robinson and Leroy Whitaker were not in the vehicle. And you know that from way back in opening statement. I wasn't hidden from you. They didn't have to be. Because again, it was their family that was in that vehicle. It was their family that was killed, and it was their family that was severely injured. It was his brother, Hakeem Robinson's brother, that was shot in the head. In the hospital for months. Had to learn how to walk again. And then Hakeem Robinson and Leroy Whitaker listened to Smoking on Willie. And it's not just the lyric of Smoking on Willie, it's who's singing it. Because it's Charles McCormick, who's part of Six Block. Keep in mind, ATK, Hakeem Robinson, Leroy Whitaker, they don't like Six Block. They're rivals. They hate one another. And then you have a rival, someone you hate already, smoking on your brother. And that lyric buries its way into their minds, into their memories, into their blood. They're not going to let it go. They're not going to let something from Six Block go regardless, let alone something so personal as family, brothers, blood. Can't let that go.
In other news, South Carolina residents are going to be happy to hear this. It just came out, there's a new website where any South Carolina resident, as long as you live within a zip code in the state, you can apply to have your auto insurance rates reduced significantly. All you have to do to qualify is...
And then, next to it, on Duval Robinson Jr.'s account, $365 days in a year, and he dies on January 15th of 2020. The bullseye on the calendar, and he was the target, and they took him out. Date's 2/29. That's just a short clip of the song that you all heard. That's probably the most important part of it. And I guarantee you that that lyric, as much as you all remember it from hearing it before, those who knew Willie, who loved Willie, who considered him blood, they heard that every day. Here's another photograph, States 229. Willie Addison, Boss Boom. Surrounded by Hakeem Robinson, Duval Robinson Jr., and there's Torgon in the middle. Family. You heard from Hakeem Robinson's own sister. They all heard about it. They all knew about it. And they, Hakeem Robinson, Leroy Whitaker, were upset. They were really upset over it. And you know who else told you that? Father, Duval Robinson Sr. And if you could set aside your personal feelings and emotions regarding that individual for a moment, and just think about that one statement that he told you. We were aware of that song. We were upset by it. Hakeem Robinson and Leroy Whitaker were upset. Duval Robinson Jr. was upset by it. You can detest Duval Robinson Sr. He can still be telling you the truth. And how do you know that that statement from him is truthful? Because Hakeem Robinson's sister from that witness stand earlier today told you the exact same thing. Just as she corroborated him that Hakeem Robinson was living with him. They were all living at the same house on Brown Jersey Court. January 6, 2020, this is States 30. Recognize those faces? Cousins, January 6, 2020. In a criminal case, you have heard, and the judge will go over the law with you at the conclusion of this. It is the state's burden. We have to prove the charges. We have to prove them beyond a reasonable doubt. The key term there is reasonable doubt. It's not beyond all doubt, not beyond a shadow of a doubt, a forced doubt. It's beyond a reasonable doubt. You would have to have a doubt that is reasonable. But if you have an abiding conviction of guilt, the case is proven. And I'm going to suggest to you that it has been proven, and it's not even close. We're going to go through the evidence here, but just very, very quickly. I'm not spending much time on this. Count 1, first-degree murder. Both Hakeem Robinson and Leroy Whitaker have been charged with that, as you know. I don't believe there's going to be any debate. There hasn't been throughout the trial that what happened to Charles McCormick on January 15, 2020 was first-degree murder. It's captured on video. Person gets out, runs him down, and guns him down. It's not justified. There's no defense. It's clearly premeditated. So there is no doubt, no debate that this crime was committed. The one and only question is, who is responsible? And if you remember back in opening, brings us back to the two questions. For January 15, 2020, where were they and what did they do? That's what the state has to answer for you through the evidence. And the state has answered that with a mountain of evidence in this case. One additional instruction I want to talk about briefly before I get into the evidence is the instruction on principles, which I anticipate you will see from the judge. And that is because more than one individual was involved in this crime. One person pulled the trigger, but not just one person is guilty. Because this wasn't a crime committed by one person. There were, as you all know based on the evidence, 3 individuals in that Nissan Altima. 3 individuals. And they all, to a man, wanted this to happen. When you go to commit a crime like first-degree murder, you don't bring along staff. You bring along co-defendants, family, those who want the same thing that you want. And so the law of principles is, even if you didn't pull the trigger in this case, you are still guilty if you intended that crime to occur. And you did something, said something that encouraged the other individuals to commit that crime. You intended the crime to happen, and then you did something or said something that encouraged or assisted the other individuals to complete that crime. And then you are to be held accountable just as if you were the one who physically pulled the trigger. So let's talk for a moment about the evidence. There were witnesses in this case, because this did take place at a shopping plaza on a Wednesday just before 11 a.m. But it's a very large shopping plaza. And you can rely on your own memories as you deliberate and talk about the evidence and the witnesses and their testimony, and look through the exhibits, including the video. I encourage you to look closely. Almost every single one of the witnesses in this case were very far away. They were at the other end of the shopping plaza, away from express employment. There were 2 witnesses who were very close to what happened. Lashida Saunders, who owned and was working at Express Employment, who knew Charles McCormick, who her company was helping him get a job, said goodbye, and you recall what she told you she said to Charles McCormick as he began to walk out the door. You remember? Have a good day out there. And she stood at the door, and she watched through the glass as the person she knew, who had just gotten a new job, walked towards the parking lot where neither one of them knew Hakeem Robinson, Leroy Whitaker, and Dominique Varner were waiting in that stolen Nissan Altima, a car they had no right to be in, but they wanted a car that couldn't be connected back to them. And so they waited. And that is where States 187 comes in. Ms. Saunders, you can look at States 187, still see the front door of Express Employment. And you can kind of see through the glass where that desk area is, where she said she was standing, just as Charles McCormick began to walk outside. And she told you she was there, and she saw from the corner of her eye that shooter, that gray and black Nike hoodie, come running towards the parking lot, from the parking lot towards Charles. And Charles ran back initially for the front door of Express Employment. And then, as you see in the video, he turns. What does she tell you? He's coming towards the door. He lock eyes. I see him, he sees me. So he turns. He had a choice. He could have run inside that public office, putting everybody in there, putting the Saunders at risk. But he didn't. He ran around the corner and never made it very far. What did Ms. Saunders tell you? I saw them, couldn't identify anybody, can't identify Hakeem Robinson because his face was covered. 79 degrees outside, but he's wearing a hoodie and it's pulled up and his face is covered. And she gives a description. She says, looked like he had some hair underneath the hoodie. Wasn't a low cut. And we all know Hakeem Robinson did not have a low cut back in January 2020 because we have video. We have photographs showing exactly what his hairstyle was like in the days leading up to this. And she said, I can't put a number on it. She didn't say the shooter was tall. She didn't give a number. But what she could do, what she did do is say, Charles McCormick, the person she knew, the person she just talked to, the person she just walk out her door, the shooter was bigger than him. Was taller than him. Not as thin. And how tall was Charles McCormick? According to the medical examiner, 5'10".
Objection, mischaracterization of testimony.
Overruled.
5'10". And the shooter was bigger than him. And she got a clear front row seat to that event as that shooter, Hakeem Robinson, chased Charles McCormick down right in front of her. Close to this. It's not strangers. It's not 30, 40, 50 yards or more away. It's right there. And it's someone she knows. Shooter was taller, was bigger. What did Victor Kruger say? He doesn't know anybody. He just happened to be checking out his mail. He's sitting in that truck. They run past him. Again, this all does happen very quickly. What does he say? Shooter to me looked like, I don't know, just under 6 feet, maybe 5'10", 5'11". 5'11" or 6 feet. An inch. An inch. We know how tall Hakeem Robinson is. He's 6 feet. Just a tad over barefoot, according to laser scans. Victor Kruger could be 5'11". Pretty close. Again, keep in mind, shooter doesn't stop, say, measure me. He's running and gunning. And this happens very fast. But the two closest witnesses, the two clearest fields of vision, both say very consistent descriptions. Bigger than Charles, 5'10" according to the medical examiner, and Victor Kruger, 5'10", 5'11", maybe just under 6 feet. Very, very consistent. Parking lot, 187. This is a still shot. You have the video. You'll be able to look at it. You see all the witnesses? You have to squint. How far away are you? You know how tall they are? Keep in mind it's a video. But do you have any idea how tall those people are? You can tell what they're wearing. And then this happens in 10 seconds or less. There's more gunshots than there are seconds that it takes for this crime to be completed. and you hear from a few witnesses who are way down there by Bailey's. Mr. Williams, well, the guy looked like maybe he was crouching. You know what happens when you crouch? You get a little small. Maybe 5'8". But then what did he say? Although sometimes I see people and I think they're smaller than me, I walk up and what do you know? They're taller than me. Jarvis Roberts says he's at least 30 or 25, 30 yards away. Saw it for about 2 seconds. That was his testimony, 2 seconds, as he hits the ground. He's way over there. Maybe 5'8", 5'9", somewhere in there. 2 seconds of an individual running and gunning, not standing straight, not standing up, and you're 30 yards away, which automatically means the odds you're small. Common sense. The further you get away from something, the smaller it looks. Anybody ever had an eye test? There's a little tree in front of you where they blow the puff of air. It starts getting further and further away. Hakeem Robinson on January 2020. There were some questions. You don't have photographs of him when he was arrested. See what he looked like. Well, when he got arrested in September 2020, what he looked like really doesn't matter. You know what matters? What he looked like on January 15th of 2020 when this murder took place. Defense 3. January 14th, 2020. The day before their plan was fulfilled. Willie's Day. This is a preview of Hakeem Robinson, what he looked like. He looked fat. Oh, you see the hair? See the legs? Still defense 3. Same day. Keep in mind, the individual in red, the sergeant that testified, said he was what, 6 foot, 300 pounds at the time? Himself, not Hakeem Robinson. And there's Hakeem Robinson. Dates 2:30. January 5th, 2020. 2 individuals who I think everyone will recognize. Leroy Whitaker, and that's Hakeem Robinson. And the over. Leroy Whitaker's 5'6" on the laser scan. Clearly shorter than Hakeem Robinson. And then you put them side by side, and Hakeem Robinson starts bending over. Still, January 5th, 2020. There they are together. Hakeem Robinson, Leroy Whitaker, cousins, blood. Approaching Willie's Day. And look at the hoodie on Hakeem Robinson. Does that shape on that head look somewhat familiar? Anything any of you have seen in this case? About now, states 187 and 230. Hakeem Robinson, Leroy Whitaker, left and right. And in the middle, the shooter. Wearing a gray and black hoodie. Gray and black hoodie you have all seen and will see again, worn by Hakeem Robinson. Pretty good shot at the firearm, too. We'll come back to that. Dates 248. Hakeem Robinson's height, measured by lasers, 6.0302 feet barefoot. And if you recall, there were some questions of the expert about the defense counsel across about, did you tell him he was going to get measured for his height? Did you tell him to stand perfectly straight and put his feet together? Keep in mind, those are two things that Junior never did for any of the witnesses that the defense would like you to believe their estimation of. But if simply spreading your right and left foot apart is going to affect one's height in any observable way, how in the world is running going to affect it? It's going to make you look smaller, right? And to the right, you see Leroy Whitaker and Dominic Garner, 5.6233 feet, 5.5873 feet, very close to one another. Stage 248, still shot from the dash cam. Charles McCormick and the shooter, side by side. Does the shooter look a little bigger, like Ms. Saunders said? How about height? You can ignore the head. Look at the shoulders. Equal distance from the camera, almost the same body position. 5'10" Charles McCormick, Hakeem Robinson. Still states 248. You saw and heard from the expert who did the laser scans and then the 3D kinematic model. Shooter on the left, Hakeem Robinson's body scanned model, right? This shows shooter, Hakeem Robinson, the shooter's kinematic model, and then the 3D laser scan of Hakeem Robinson, Leroy Whitaker, and Dominic Garner. Dominic Garner, Leroy Whitaker, 5.7 feet, excluded. Doesn't match up. Hakeem Robinson, not excluded. Stage 243. This is on November 25th, 2019. Gray and black hoodie. Keep in mind, it's not that Nikes aren't owned by other people. And if all the state had was this photograph or this video of Hakeem Robinson in a similar black and gray hoodie, the case wouldn't be so black and white. But it's not. It's just one piece of the evidence. And you have to look at all of the pieces in totality. And they all point to Hakeem Robinson and Leroy Whitaker. Page 197.
It's Ksoo.
Ksoo is Instagram now. Instagram Live. Black and gray hoodie. You see his hair. See him moving around. Back to the firearm for a second. Stage 243. This is the Bang It Out music video that was filmed on December 11th, 2019. A month before the murder of Charles McCormick. And look at the firearm in Hakeem Robinson's hand, his right hand. Fairly distinctive looking, I would suggest. video was filmed. You see it close to Mosh. Where did Duval Robinson Sr. say? He said, I was there when that was filmed. Over there by the chart house. Right over there in that same area. He knew where it was filmed. It's filmed on December 11th, 2019. Went back to the expert's testimony when he did that comparative analysis between the firearm depicted in that music video, as well as a known firearm he went out and procured for his testing, which is in the center. And then looking at the images from the dash cam, the points of comparison. Does it look similar? Even if you ignore the expert's testimony and you just look at these images, what does common sense tell you? What do you see with your own eyes? The Nissan Altima. This is one of the most important pieces of this case because it was stolen, not owned by Hakeem Robinson, or Leroy Whitaker, or Dominique Varner. So a car they should not have been in, and their evidence of them should not be. And you know beyond any doubt that that Nissan Altima was the car used to commit this crime and flee from it. You know beyond any doubt that it was occupied by those involved in this crime. States 77 and states 187. On the left, that crashed Nissan Altima after it fled from Officer Collins. And on the right, a still shot from the dash cam showing the car that was used, occupied by those who are responsible. Same car. States 187, and this is just a few seconds.
That's the car right there, right there.
Victor Kruger. He saw the car, saw the shooter get back into it, and as you hear, that's the car right there. So there's no doubt that that Nissan Altima was the one that was transporting the guilty from that scene. Let's talk about Officer Collins for a second. He followed that vehicle, not knowing Charles McCormick had been shot and killed, knowing shots had been fired. So he pursued it, turned his lights and sirens on, telling that vehicle, the occupants, to pull over, to stop, and they refused. Varner, who admittedly was in that car driving, and admitted to flying, driving recklessly, reaching very high speeds, going through a residential neighborhood as he was trying to get away. Get away himself, but also those who were with him, his friends. Hakeem Robinson, Leroy Whitaker. And Officer Collins, because part of the testimony and the cross-examination has to do with the description he gave. That he advised on the day of this incident that the shooter that he saw get out of that Nissan Altima running west, 5'5", 5'8", 5'9", somewhere in that range. But where was he when he saw that individual? And on the map, you can see 1, 2, 3, 4 little addresses. Number 1, 1233 Townsend. That's where the Nissan Altima crashed. Officer Collins testified he was further up than that. 1 Townsend, just past Alderman, that intersects with Townsend. And when he saw the person running, he was about half a football field away, about 50 yards. And he saw him for about 2 seconds as they darted across the street. I think we've already covered, but what happens when you're at distance? What happens when someone is running? They appear small. And then factor in, it's a 2-second glimpse. States 80, that Nissan Altima looking back towards the direction that Officer Collins was coming. Based on the map that you were just shown as an evidence and this perspective, can you even see where his car would have been in this photo? Because he was further back. Just use this visual as context. You can see a car, a patrol car at the top of the screen. Doesn't look that big. That's that. Houses. Imagine being further back and looking at an individual fleeing from the Nissan Altima and seeing it for 2 seconds. States 190. Still shots from the Belmead video that you saw, that's in evidence. You can look at it again. And when you look at it, and you can take note of these times if you want. At 11:23, the shooter runs between the houses and passes that car. Camera doesn't move, car doesn't move, just the shooter. Then look at the image on the right. 11:06:05. Almost 3 minutes later, that's Officer Collins. He wasn't right up on him. And you saw Officer Collins. 6'4", he testified. So look at the two images, and on the right, Officer Collins, as he goes past that same vehicle. How do their sizes compare from this image? Is the shooter consistent with someone who's 5'5"? Or is it more consistent with someone that's approaching Officer Collins' height? Someone closer to 6 feet. Maybe 6'1" would choose. Going back to that Nissan Altima, States 87. It's not just the car, but it's what was found in it. DNA, fingerprints. On the Glock, at the top of the slide, not on the handle, not even on the front of the slide, on the rear of the slide, fingerprints belonging to Hakeem Robinson. His prints on that gun in that car. Now, the analyst can't say at what point in time that fingerprint got put on the gun. Dominic Carter can. The expert couldn't. But common sense tells you, based on even the line of questioning, fingerprints can get wiped off. They can get wiped away. You're going to find a fingerprint on the slide of a Glock left behind in a car that the suspect's just flat out of. But that print, maybe that's been on that gun and that gun's just been passed around. And yet you get a print on the top slide, clear enough to identify, and it belongs to Hakeem Robinson, who, coincidentally enough, DNA is found on that rolled up white t-shirt next to it. Greater than 700 billion. The analyst says we stop at 700 billion because we can't comprehend numbers bigger. Can you imagine if you were told you had greater than a 700 billion chance to win the lotto? It was over 700 billion times more likely that you were going to win when you purchased that ticket and lose? Would you have an abiding conviction to go out and buy that ticket? Would you think you could lose? Well, I suggest to you that this piece of evidence is a loss for Hakeem Robinson. Because it's over 700 billion times more likely that that's his DNA on that shirt next to his prints on that gun in this stolen Nissan Altima that was just used to flee the scene of the murder. States 88, that same shirt, rolled up, balled up, And it's a size large. It's 89. You have the shirts, you can look at them. The one in the back's a medium, where Leroy Whitaker was, a little bit smaller. Also states 92. You see a rifle in the floorboard, and then that white shirt, that medium-sized shirt, with Leroy Whitaker's DNA. Again, greater than 700 billion. And I want to talk for a moment about the firearms. All right, you got the Glock. You already saw where the fingerprint was on it. And that gun, Dominic Varner says is his. It serves him no purpose in the world to admit that gun is his. He's just feeding the story. Why say that's his gun? How does that help? Does it serve any purpose? No. But yet he's admitting that not only was he involved, but yeah, that was my gun. And he's just telling a story based on what he knows in discovery, and he knows Hakeem Robinson's prints on it. Why not say that was Hakeem Robinson's gun? It's got his prints on it. But he doesn't. He says, that was my gun. He admits it. And again, you don't have to like Dominic Varner. I'm not saying he's a good person. He's a criminal. He's just their kind of friend. And if you're going to plan a murder, who do you take with you? Is it not a Dominic Varner? You want someone you can count on. Their friend. Someone who shares the same goal. Page 92, again, is that rifle. What I really want to point out, states 103. Because Dominic Varner says that rifle is Leroy Whitaker's. And it's in the back seat next to the item with Leroy Whitaker's DNA. And he didn't pull the trigger, Leroy Whitaker, but he is a principal. He knew what was going to happen, and he wanted it to happen. And this rifle tells you that without speaking a word. Look at it. It's an assault rifle. Okay? It's set to fire. That tab, set to fire, tells you everything about the intent for that weapon is to be used. Not only is it set to fire, there is a live .223 caliber round chamber. One small muscle contraction of the finger away from discharge. Stage 104, that live round. Leroy Whitaker's live round. Leroy Whitaker's intent. If that one wasn't enough, 107, 26 total rounds. 26 individual statements of intent. Leroy Whitaker didn't have to say a word in that piece on all. You show up with a loaded AR-15 and chamber around, set it to fire. You don't have to vocalize anything. Your actions have made it more than clear you're in agreement with what's about to happen. And if he didn't know what was about to happen, why is he bringing a rifle? Because they were on a hunt. So you bring the tools of the trade. 1214 Timber Lane, page 189. Leroy Whitaker, Dominic Varner. Right after they have fled the murder, Hakeem Robinson's gone west, they go east. And they leave their guns behind. Leroy Whitaker, not just a spectator, he's an active participant. He was roped into all this, had no idea what was going to take place, no idea what was about to happen, didn't want it to happen, stayed in the car. He could have got out, laid down in the front yard, put his face down, spread his hands, because officers were coming, and said, "Officer, officer." But he didn't. Consciousness of guilt. They're getting out of there. Left the guns behind, left the DNA behind, left the fingerprints behind, and then Dominique Varner and Leroy Whitaker are not leaving anything else behind. They're getting out of there. And from that moment, where do they go? 1033 Townsend Boulevard, where Dominique Varner and Leroy Whitaker both collectively committed burglary and assault or battery. To commit a burglary, to prove that, the state has to prove, in this case, because again, Varner already pled to it, admitted to it, to what he did. But Leroy Whitaker did the exact same thing. You have to prove Leroy Whitaker entered a dwelling, Buckley's home, and at the time of entering it, he had the intent to commit an offense therein, other than burglary or trespass. It's not like Leroy Whitaker was homeless, and it was 30 degrees outside, and he needed a warm place to sleep, and he thought this was an abandoned home, nobody's home, and I'm going to sneak in, commit trespass so I can sleep, protect myself from the elements. That is not what happened. He was protecting himself, but not from 30-degree weather or rain. He was protecting himself from the police. The police who were on his trail, trying to find him, trying to find Hakeem Robinson. And so, just like Dominique Varner, who behind the wheel was fleeing at a high rate of speed to escape, this is just a continuation of that on foot. So, with the intent to thwart the police, to escape the police, to resist the police, to ignore their orders, to stop, Leroy Whitaker and Dominique Varner both entered the home of Barbara Buckley without permission and with the intent to hide from the police, and that is a burglary, plain and simple. But they went a step further, because there's an assault or battery. You also have to believe here from the judge that you can infer that there was an intent to commit a crime inside that dwelling if it was done stealthily and without the consent of the owner. What did Barbara Buckley tell you? She didn't invite him in. She didn't even know they had entered. That's stealthy. She thought her cat shut the door to the bedroom. States 114, the enclosed patio that Dominique Varner and Leroy Whitaker entered as the police were closing in. And then states 115, the back sliding glass door to the home. And then once inside, states 125, that bedroom to the front of the house, door open. And when that door got opened by Miss Buckley, looking back at her from states 126 in that closet, Dominique Varner and Leroy Whitaker. Two people she didn't know, had never met, had never been in contact with. And then the assault and battery by both Dominique Varner and Leroy Whitaker. Both, not just one, both. So if you find Leroy Whitaker guilty of burglary, you have to determine, was an assault or a battery committed? An assault is simply an intentional and unlawful threat by word or act to do violence when they have the inherent ability to carry out that threat. So, for example, when Miss Buckley is thrown down on the ground and she's cowering on the floor, and Leroy Whitaker asks Dominique Varner, "You want me to hurt her?" That's an assault. That comes after the battery. Battery is just an actual and intentional touching or striking another person against their will. Did that happen to Ms. Buckley? States 133. He was 57 years old at the time. Home alone, her husband was at work. She hadn't left her first shift yet. States 121. Front door to her home that she opened, telling Leroy Whitaker, Dominic Barner, get out of my house, opens the door, begins to yell for help. They're not going anywhere. The police are outside. They can't go outside. They have to hide. Consciousness of guilt and proof of the burglary. And states 110. Closed front door, and you can see the brick wall next to it, the little planter box, and there's a metal railing just inside. The metal railing that Miss Buckley told you, she reached out with her hand and grabbed. Kind of a death grip. So much so that even though she's 57 and they're much younger, when Dominic Barner grabbed her to try and get her back inside, couldn't quite get her. So who came to the rescue? Who assisted? Leroy Whitaker. He came and helped break Barbara Buckley free from that rail, pull her back in her home, where they threw her to the ground, and Dominic Barner, admittedly, put his hands around her neck and began to choke her as Leroy Whitaker asked if he should hurt her. And then she complied. That is a battery during the commission of the burglary, and that proves that Leroy Whitaker, just like Dominic Barner, no different than Dominic Barner, is guilty of burglary and assault or battery. And again, states 135. Slight abrasion to Miss Buckley's neck. Wrist, states 130. DNA from those locations matching Dominic Barner. Again, he admits it. No mystery. States 143 and states 189. What states 189? Notice it. He flips his leg on that chain link fence. Catches. And he falls to the ground. And then what do they find on Miss Buckley's clothing? Her pants. Blood. DNA. Whose? Leroy Whitaker. Greater than 700 billion. His blood, after he jumps the fence, catches his leg, on her pants, in her home. She's never met him before that day. Doesn't know him, didn't invite him in. They shouldn't be there. That proves beyond not just a reasonable doubt, but all doubt that Leroy Whitaker, along with Dominic Barner, are both guilty of this crime. Let's talk a little bit more about some of the evidence. And we'll start with Leroy Whitaker's phone number, 803-3671. States 227. Leroy Whitaker's Instagram account, you can see the account name highlighted in yellow at the top, ATK Scotty. You see a phone number, 904-803-3671. Verify. Leroy Whitaker. And you can see at the bottom right-hand corner of the photo, at ATK, and then it kind of cuts off. Scotty. Page 437 and 1057. Text messages on that account where he gives out his phone number. Look at the dates. December 19th, 2019, before the murder. Text 904-803-3671. January 31st, 2 weeks after the murder. Laugh of mine, all. We will FaceTime you later. 904-803-3671. Same phone number. And then, of course, you have this. States 241. A text message sent from 904-803-3671 with the attachment of this photograph. Leroy Whitaker. To 624-3684. Duval County Court. Hakeem's brother, states 246. The maps, in this case, done by Special Agent Corley. And with regard to 904, 803, 3671, and 624, 3684, again, that's Abdul Robinson Jr. And on this map, which we've talked about again in a few moments, you'll see the 478, 305, 9583, which I believe is associated with Hakeem Robinson, was used by Hakeem Robinson that day. So let's look at the calls. Where are they pinging off of? Between 10:17 a.m. and 11:05 a.m. Leroy Whitaker's 803-3671, as well as Abdul Jr.'s 624-3684, are pinging off the tower. And if you look at the sectors pointing back towards that red icon, 7001 Merrill Road, scene of the murder. 478-305 number, also pinging off that same tower, based on a data file, placing it at the scene of the murder, same time as well. Next slide, again showing those same numbers between 11:30 a.m. and 11:51 a.m. So after the murder. After that Nissan Ultimax crash, they're trying to get out. Leroy Whitaker's 803-3671, being right around the area, Townsend Boulevard, 1033 Townsend. Got the time and advance records associated with it, and they show kind of how they intersect. They're in those bands, somewhere in there. You see Townsend right above it, as well as the 478-305-9583 pinging off that tower. This is if Hakeem Robinson using that phone were trying to get out. And where is 624-3684? Abdul Robinson Jr. He is up higher on the map. Going back to he is up near the top by the 7001 Merrill Road, but was also in that area, the Dalehurst Drive, where Torgon was living, where Abdul Robinson Jr. returned. Let's wait. You also have the next slide, again showing Leroy Whitaker's 803-3671 number, Abdul Jr.'s 624-3684, as well as Abdul Jr.'s 478-491-2831 number, because he had two. And if you recall, those numbers he gave out on his Instagram account in messages, both numbers. The 904-624-3684 and the 478-491-2831. Gave them out, just like Leroy Whitaker did on his Instagram. So you can see where they're pinging. And you can also notice that we have in blue another phone number, 904-866-2370, which belongs to Abdul Robinson Sr. Blue. And this shows up by Townsend at around 12 o'clock. If you remember, Leroy Whitaker and Dominique Barner held Miss Buckley there against her will in her own home for about an hour or so. Murder happens a little before 11. Car flies, crashes, they run. So shortly after noon, that's when Abdul Robinson Sr. is showing up, because it's after the phone calls from Leroy Whitaker to Abdul Jr., Hakeem's brother, cousin, Blue's other son, asking for help, sending the pin drop information to a station in Townsend, 1033 Townsend. That's when he's showing up to pick them up. And Abdul Jr. is pinging again back over near Dalehurst Drive. Leroy Whitaker. This whole record's putting him again right there in Townsend by Buckley home, where he feeds after Second, state suggestion 478-305-9583. So write them down. We're going to start with 704-1595. This is the phone whose account information is in his mother's name. And if you recall, his sister, when she testified, she said, Dad, he does, he did give, well, he compared his sons. He did give them the phones. And Duval Robinson Sr. also told you that this number was in Hakeem Robinson's mother's name, and you'll see the subscriber information every wall. His mom's name. His main number. The number that can be tracked back to him. His mother's name. And so, stage 243 on that number, you see on December 28, 2019, a text message. I just got to Jacksonville. So he's back in town December 28th. He was in town on December 11th as well. He filmed the Make It Out music video. Maybe he left and went out of town after that. He was back by December 28th. You know what else happened on December 28th, 2019? Duval Robinson Jr., Hakeem's brother, gets a text from Dominique Barner. What was it about? You can read it for yourself. It mentions McCormick by name. Same day, Hakeem Robinson back in town, and they're talking about McCormick. Let's look for a brief moment at Hakeem Robinson's 704-1595 phone, the phone that can be tracked back to him. Look at the activity and recall the testimony from the experts, especially in the early morning, 2020. It's UTC time, so please remember you guys track 5 hours. 11:06, track 5 hours, and that's 6:06 a.m. My math's right. 6:06 a.m. continues, and then line 42, 12:11. So 7:11 a.m. More activity. Next activity, not till 18:10, which is 1:10 p.m. So from 7:11 in the morning to 1:10 in the afternoon, this phone, his main phone, his phone that can be tracked back to him, the phone that Donnie Shite could get a hold of him on, doesn't want to miss out on a deal or anything. For some reason, for the next 6 hours, that phone, that known phone, no activity, no calls, no data, no instant messages being received, nothing. And then when you look at the logs, January 15, 2020, sometime between 5:55 a.m. and 1:10 p.m., hour one of that. If you remember the last activity, 7:11 a.m. and 1:10, 1:11, right after hour one of that. Oh. Wonder why that is. Is it also the same reason you use a stolen car to commit a murder? Something that can't be tracked back to you? Well, let me make sure my known phone doesn't come back to me at the same time either. Let's look at the two numbers, 478-305-9583, 478-491-2831. Again, Duval Robinson Jr., his brother, through his records, admits to using 478-491-2831. Duval Robinson Sr. said the other number belongs to Hakeem Robinson. And I got it for him. Put it on my account. the activation date for both numbers? November 12th, 2019. Same for both numbers. All under Darryl Watts, as Blue told you. That's the account he was using. Again, you don't have to like him. These records don't lie. Page 239 shows some contact or attempted contact between the two 478 area code numbers on January 15th, 2020. One at about 9:13, 9:16 in the morning, so before the murder. Around the time that they would have been stalking Charles McCormick at his apartment complex, because remember he signed in at 10:08 a.m. So that's beforehand. They're in two different cars. And then after 16:54, which is 11:54, 11:55, shortly after the murder, but when Hakeem Robinson needs help, attempted contact between the two numbers. Not phone a friend, not phone a friend, phone a brother. States 240. Again, 904-866-2370 at Bill Robinson Sr. Blue's identified number. He admitted it. You had the cell phone exam showing that it's his phone. Showing the cell phone location when he shows up at Townsend, where he was coming from. Had the video showing that red-orange Dodge Challenger showing up. And what is this? A selfie photo that was taken of him, and he sends it to 478-305-9583. He's not sending himself a photo of himself. He sends that to both 478 area code numbers. Hakeem Robinson and Abdul Jr. Looking at his outfit. Sends it to both of them. He's not using 478-305-9583. His son. Went back to the maps for 624-3684 and 702-918-4911. You recall that's Dominique Barner's number. And what does Barner tell you? I call Abdul Jr. at around 4:40, 4:45 a.m., letting him know Charles McCormick is back. You have the cell records. It confirms that Dominique Barner was communicating with Abdul Robinson Jr. on his 624-3684 number around that time. Look at the records from the FBI in Eastern Standard Time, 4:44 a.m., 4:45, 5:01, 5:26. Those are calls between Dominique Barner and Abdul Robinson Jr. And then where does the map place those two devices? Barner in green is down by 3830 University Boulevard, where he was living. This is between 4:42 a.m. to 5:26 a.m. Abdul Robinson Jr. up there near Brown Jersey Court. And then it travels down Dominique Barner's address. Dominique Barner told you what happened. These records corroborate. You don't have to like him. But again, that doesn't mean he's not telling you the truth. The next slide shows both of Abdul Robinson Jr.'s phones, the 624-3684 and the 478 area code number, being in the same area. 5201 Atlantic Boulevard, where Charles McCormick lived, over off Atlantic. What did Barner say? We all went over there. Next slide shows how the 478-305-9583 number that was using data and was pinging initially over there by Merrill Road at the time of the murder, then begins to travel south. Also in that same area at the time was Leroy Whitaker's number. number and Duval Robinson Jr. Next slide shows how the 478-305-9583, that device traveling from Merrill down to the area of Townsend, right where Dominic Garner told you Hakeem Robinson was, because he was with him and Leroy Whitaker, where it then begins to travel south again. And keep in mind, he's on foot. He's still trying to get away. And he goes west down through the residential neighborhood where there's a nature preserve. And that's the location that he's allowed to traverse that takes him out to Arlington Expressway, where he then gets his ride. Page 242, this is that preview location of in that area of Lone Star Road that was deleted off of Duval Robinson Jr.'s cell phone. How do you erase maps from that search? You got a little thumbnail that stayed in cache. And you couldn't delete that he received from Hakeem's 478-305-9583 number in that area as he's trying to get the location where he can get picked up. That nature preserve, stage 248, where Miss Gant took then Detective Smith to that apartment complex and said, "This is where I picked Hakeem Robinson up." The defense would like you to believe that she was coached, told what to say. If Miss Gant were just rehearsing a story, she given more details. I didn't even remember what Hakeem Robinson was wearing. I mean, that's easy. Not with these people anymore. Not with Oregon anymore. But I remember and that location, right where Miss Lawson lived. She confirmed a person in a black and gray hoodie that she recognized because of an alert on her phone about a shooting and looking for suspects came from the woods. Now she says 5859. I think we can help with that issue. Again, she got a quick glance. She's upstairs and runs inside. But what's key is right before that, she saw a white female in a silver car driving around the neighborhood, driving around that apartment complex. Looked like she was home, looked like she was looking for someone. And she said the lady was holding her phone up, like she was using her phone. She was looking for someone. When Natalie testified, she talked about the phone. You remember she was had the phone up, just like Miss Boston described. They don't know each other. Buck said, "I've never seen that lady before." Confirms that Natalie was there and that she picked up what she said. And then on this slide, this is between 12:22 p.m. and 12:40 p.m. That 478-305-9583 number in red. We can see it's up there, closer to Dalehurst. Almost as if he got picked up by Natalie, taken back to Dalehurst, and then was leaving to go home. And it's funny, it's about 30 minutes later, across the river, no phone comes back on. I wonder where the 478-305-9583 phone went. Across the river, I don't know. And then, between 2:22 and 5 p.m., let's see, on January 15th, Brown Jersey Court, look at all the phone numbers back in that area. Leroy Whitaker, like Blue and Barner say. Duval Robinson Jr. shows back up, pointing to his device, both of them. Barner's number shows up over there, like he said. Hakeem Robinson's no numbers back on. And then then this slide just shows where Abdul Robinson Sr. Blue was at around the time of the murder. He's way across town. He comes from there all the way over to Townsend after being notified that they need a ride, which is also reflected in the next slide when you see that blue number showing up next to Townsend. And much time on this, but Abdul Robinson Jr., 904-624-3684. Again, just a call log. This is Dominic Barner's number, January 15th, 2020. 13 calls between the two of them. Incoming or outgoing. Barner said, I was letting you know. McCormick's here. They come and get me. Device locations associated from the phone itself. For Abdul Robinson Jr., states 241, starts off Brown Jersey Court. This slide is interesting. Eastport Road and Palm Lake Drive. That's an apartment complex. What did Barner say? We went to an apartment complex to get a stolen car. That makes sense why you would park a stolen car in an apartment complex. You can park it in the back. There's lots of cars around. It's harder to find. And it was off Eastport Road, Palm Lake Drive, apartment complex. And at about 6:17 a.m. That time's incorrect. January 15th.
Hey, listen, if the value don't work from you, hey, y'all can just go find it on another news station, but I can hear just fine on this.
Goes over toward Dalehurst. Oregon lives. This is off his land, close to where Charles McCormick was living. And then back to Dalehurst, around the time of the murder, just after the murder, 11:45 a.m. Then back at the end of the day, 1:22 p.m., shows up Brown Jersey Court. And here, so far, states 241, you see some of the pin drop information between Leroy Whitaker's phone, Abdul Robinson Jr.'s phone, and that location information. 1033 Townsend Boulevard. This Buckley's home. This is another instant messaging just showing that same location information. Only this is between Abdul Robinson Jr. and Abdul Robinson Sr. And Senior's response, I'm about to leave them. What did he say? They didn't come out right away. He had to wait. He's in the right place, and he still had to wait. Getting impatient. There's police in the area. Sends it. I'm about to leave. And it's 1033 Townsend Boulevard. This is for the 478 numbers. And I just wanted to show this on January 15th, 2020. FaceTime audio, FaceTime video, iMessage authentication, that process that takes place to make sure when you're trying to communicate between the two devices, their Apple will work. And remember, FaceTime communications, those types of calls aren't reflected in the records. So if he FaceTimes, sends an iMessage, the location, it's not going to be reflected in the records. House of Pain. Creation date, November 14th, 2019. 2 days after both 478 area code numbers are activated. One for Abdul Jr., one for Hakeem Robinson. 2 days later, this House of Pain iCloud account is activated. Same address as Hakeem Robinson's other iCloud account. And has the 478-30478 area code numbers are activated. One for Abdul Jr., one for Hakeem Robinson. 2 days later, this House of Pain iCloud account is activated. Same address as Hakeem Robinson's other iCloud account. And it has the 478-305-9583 number. Two-factor authentication. And then from Hakeem Robinson's Instagram account, nail salon post that we're all familiar with, an upload IP address, the groupings of numbers for the carrier are what matter, because that's what's assigned by the carrier. The rest are randomly assigned by devices, not the same because it's the same device, you randomly assign. But the first four groupings, that's what matters.
It's characterization.
Overruled.
This first four grouping of numbers that matter is the same as the registration IP address for the House of Pain iCloud account, activated 2 days after he got his phone. House of Pain, page 230. And there's a lot more. And it's in evidence, you can look at it, but we picked out some of the photos just to show you. December 28th, the day you got that account. This House of Pain iCloud account. Same day, Garner and his brother texted about McCormick. There's Hakeem Robinson and Leroy Whitaker. Selfie photo, December 31st, 2019. Series of photos showing Hakeem Robinson's Instagram story posting to this iCloud account. Another photograph of Hakeem Robinson, Ksoo 23X. House of Pain, sure. Did his father start it? Sure. Does that mean he won't use it? No, he won't. He's wearing a shirt. And photos you've seen, with a hoodie and a shade you've seen, next to a person you've seen, January 5th, 2020, but it was taken on January 4th, 2020, 11:48 p.m., and it gets uploaded to this iCloud account 3 hours later. Remember the time difference from California to Jacksonville? It's uploaded to that iCloud account almost immediately after that photograph is taken. His iCloud account. January 6th, Hakeem Robinson, Leroy Whitaker, cousins. January 9th, a selfie of Hakeem Robinson. January 14th, day before the murder, having a good time. Talked on this, so I'll be brief here, but States 177, this is just a photograph of that apartment complex in Arlington Expressway, just on the other side of the curve that you made it out of. Natalie picked them up. If you recall, when she testified, when she finally pulled in, he's coming up from below, just 2 stories here. And Ms. Boston said, I'm upstairs, and I run in, he's way down below. Now, States 194, talk about a few posts by Mr. Hakeem Robinson after the murder. And there was some question as to why would someone post something admitting of what they had done? Sometimes people are stupid. And when you're 21 years old, you can make some good decisions, and then you can make some decisions that make your father want you to take that down. Even bad calls. And when you've escaped the crime that you committed with people you were tight with, and that gun is long gone, that 478 area code number that you don't think can be connected back to you is long gone, well, I can post whatever I want and just say whatever I want. That feeling of invincibility, 21 years old. Now, it's not his song, it's Ace's song, but it's titled Ksoo Homicide. And singing the chorus, and down, right after Charles McCormick. 96, 2 days later, also posted Hakeem Robinson's Instagram account. Video of Charles McCormick. Bye-bye. $195. Now, it was suggested that you didn't have context for this. Five days later, that dash cam context. Did run him down. Well, he might have got a blister. Maybe he needed a pedicure. I don't know. Very, very briefly here, because this case is not dependent on either Dominique Barner or Abdul Robinson Sr. It's not. And we have said and will continue to say, you can think whatever you want about them. We're not asking you to like them. Just evaluate what they said based on the other evidence. Does that evidence corroborate, regardless of what you think of it? And if it does, make your determination. You cut him out completely. Don't you still have enough? His DNA, his prints, his phone location, Leroy Whitaker's DNA, his cell phone location. In that car, right after the murder. And at least with regard to Hakeem Robinson, he tells you what he did. He posts it, he brags about it. And again, with regard to the testimony, also remember Hakeem Robinson's sister, because she confirms the important parts that Abdul Robinson Sr. provided. Gives him home. They knew about the song. They knew about Willie. Willie even asked, well, it's like stepbrother. No, we're blood. We're blood. So were they. And because Hakeem Robinson wanted it, Leroy Whitaker, his cousin, wanted it too. And that's why they're both guilty.
All right, thank you, Mr. Cooper. All right, ladies and gentlemen, I'm going to give each of you a recess now since it's been about an hour and a half. So I'm going to ask Hakeem Robinson's jury to go into their jury room. Please leave your notebooks down. Your recess will be a little longer as we hear from Hakeem Robinson's close, so make yourselves comfortable. We'll bring you out here just as soon as we can. And for Mr. Whitaker's jury, we're going to give you a bio break now, and then I'll bring you out here just as soon as we can to start the defense close. Thank you very much. All right, both juries are out of the courtroom. We'll be in recess. Thank you.
All right, that last part threw me off because what we learned was that Abdul Jr. was actually the blood brother of Willie because they had the same mom. So to say that the sister was speaking as if, oh yeah, that's not my stepbrother, that's my blood brother, it would have been good to determine do she have the same mom as Abdul Jr. and Willie. So that stuck out to me. I wouldn't have had took it there, but I mean they didn't ask the question or the defense didn't clean it up on that. So it is what it is. But that stood out to me because I'm like, well, we don't know if that's really her blood brother. We just know for sure he's not the blood brother of Ksoo. I put up a new poll to see what y'all thought about the closing argument. I'm gonna be honest, to me, it was very, very detailed, but it wasn't mind catching to me. I've been down cleaning up, walking around the house doing other things. I really wasn't listening to the whole thing. It was just too long winded for me with not enough like punches, if that makes sense. It's just not to my liking. I'm hoping that the defense does better. Yeah, it just didn't do it for me. He tried to throw some blows in there, but he really didn't say too many blows that would have caught my attention besides the oh well, maybe he went to a nail salon, get his feet done. That stood out to me because remember that was part of the evidence they put in the trial. But yeah, not that strong for me. What y'all thinking? I'm finishing up my homework real quick. I tell you, I was over here doing all types of stuff, okay? A lot of y'all saying no, it wasn't good. I put up a poll. I'm about to check in just a minute. Let me submit my homework real quick. Alright, I'll finish it later. My next assignment. So far, 45% said no, the state closing wasn't good. It's tied with, the next one is tied with yes and I don't know. Somebody give me some reasons whether you thought it was good or not. Somebody give me some reasons why it was good. Somebody give me some reasons why it was bad. Let's talk about it. Dior said it's not her brother. Well, she got on the stand and said that was her blood brother. So, I mean, if you go off of, her testimony, that's what she said. And to say blood, I mean, y'all got the same blood. Obviously, he's not your daddy's son, So I will assume y'all got the same mother if you say, nah, that's not my step brother. That's my blood brother. A lot of y'all say it was boring. It definitely was that. It definitely was that, okay? Ebony said, what'd I do? State gets to come back one last time after defense closing remarks. This will go well until tomorrow. What they gonna come back and do? Wonder what they gonna say. Cause to be honest, if I was, I'm just let it be what it is. But wonder what they gonna come back and say. Why the hell? Oh, my bad. I'm on the wrong screen. I'm like, what the world? All right, where we at? What's reality said? I feel like it didn't keep our attention. It wasn't strong. This a closing statement. The last thing on jury's mind. It was long and boring for sure. He should have came with a few main points and had more. Like it's all just like with content. You know how like you got to have some onto it to keep them engaged. And I think he definitely had no on for sure. Dior said it was not good enough. Michelle said mainly because I couldn't hear him. Sky said defense already created enough doubt in the trial. In my opinion, state closing was putting me to sleep. I do agree. I do think the case was better put on than the closing for sure. E-Call said it did the job. He pointed out the facts and didn't go longer than needed. Okay. So maybe it's some people on the jury that can keep their attention for long periods of time. I'm telling you. My attention span is very brief. Are they talking? I had to unmute it just in case they start talking. Damo said that closing from state was weak. Ebony said all depends on what the fence says. I always hated that the state can come behind the fence again. It was weak. She said half brother, but we claim blood brother. But it's still not even her half brother. They don't share a parent. Because I like how he pointed out the phone was tracked along with Butter location until it got to the scene, and the next day Ksoo posted a selfie from the same phone. See, I didn't even catch that part. That's actually pretty good to point out. I remember hearing it when they talked about it, but I didn't hear his statement. This one likes to talk loud. I hope the defense do talk loud because, hold on. Oh, I had to sneeze, but yeah. Doesn't change though. As far as how I feel about the case they put on, it doesn't change. But if I was on the seat and needed like a little bit more hold on, I gotta sneeze. But if I was one of them jurors that was on the edge, like not sure which way I was gonna go, the state wouldn't have won me over. For sure, it wouldn't have won me over. Cherie said closing was just straight to the point. I got bored towards the end. Yeah, my thing with it didn't tell like, and I have definitely sat through some boring ones. I've sat through some engaging ones. My whole thing be, you got to tell me the story. Like, you know what I'm saying? You got to, go through it. It's supposed to be you finally put all the pieces to your story together, right? And it just didn't do it for me. It may have clarified some things that may have been missed, but it just didn't tell me. It didn't give me the story. Like, you're supposed to be giving a story. Okay, nah, they're not back. I didn't know what it was on. That was long and not direct. The prosecutor doesn't add any style. Exactly. That's what it was. You know what I'm saying? Because again, you gotta remember, everybody cannot pay attention for long periods of time. Some people are visual learners. Like, you got to incorporate all that in your opening and your closing. Why do you think Johnny Cochran, OJ closing goes down in history? You know what I'm saying? You have to, like, you say it, you got to show it so that it can just feel for everybody. But, that's just how I be looking at how I expect closing arguments to be. Tell me the story. You're telling me a story. Put it all together. All right, maybe I missed the piece halfway through the trial. This is your time to put it all together for me. D said it was boring, but at this point he's guilty and there's no one to blame, no hurdles to jump. I hear that. Defense better add the blue butter brown to the close. They better. Hey, they better. I'm telling you, they better come hyped up because again, and I'm gonna be honest. I have been honest with y'all. I think the state put on a good case. I feel like they told the story, right? So this will be the defense time to put on the show to see if they could win me over if I was a jury on this case. Like, you know what I'm saying? I feel like they definitely did some reasonable doubt, but it's not enough for me to say I think it's another shooter. You know what I'm saying? So, like, they got to come with it. And like I said, vice versa. If I was on the defense side the whole trial, the state needed to win me over. And they didn't win me over. I'm hopeful that they powwow with each other, the state, all the lawyers for the state, and they come up with something to come back with after the defense. But if they send that same guy up, they doing the same thing. I don't know. He really didn't point out key points. Maybe I wasn't listening hard enough. Tree said, remember the state goes last, right? Dior said, summarize, not retell the case. Right, you tell the story. Like, you tell the story. You start with like he started off pretty good. How they got together for a purpose to kill this person, right? They sat in the car, they talked about the plan, and then you continue. So yeah, you summarize it, but again, you retell the story in your summary. That's what a summary is, Dior. You know what I'm saying? You ain't got to go in depth like you did in the trial with the witnesses, but you tell the stories that's going to stand out to the jurors so that when they go back there, they be like, you know what? Y'all remember he said this, that, that. Look at the evidence here. He said we can find the cell phone records that's pinging together. That's going to help us. Like stuff like that. But yeah, now the defense still got to come with it too. I'm just saying. They definitely got to come with it for sure. They're saying no way the police saw two people. Well, they said they saw two people. That's what they put on record. It was later found out it was three people, but you know, somebody must have been running fast. It probably was because I remember when it was like, I think Butter said he caught up with Scotty, so Scotty probably just dipped off real quick because obviously they saw who they alleged to be Ksoo because they said he had the gun. So, ideally they should have took all the guns out of the car. To be honest, leaving the guns behind, even though there wasn't a murder weapon, was really a bad choice at the time. Does Ksoo have the same lawyers for his second murder trial? Not sure, Keena. Cherie said, I believe though these prosecutors did good with their case too. They were very organized. The defense was good up until their rebuttal. Right? Yeah, the rebuttal they could have just not put on the case. Like for sure, because honestly, none of the witnesses was like boom, and they still like even when they asked the sister if she seen the video, she still like for the fact that it was a thought in the family or a thought to them that it was Ksoo for her to even be like, nah, that's not my brother. Is just that stood out to me. I'll be honest, you know. The dry eye commercial is crazy. That's funny. The state going to clean it up after the defense finished their closing argument. I hope so. You know, there was no cell phone data either. It was cell phone data. The question is, Ksoo is saying that's not his phone. Okay, so the phone is under the dad's deceased homeboy, and Ksoo saying it's not his phone. And remember, Detective Smith was saying how it was 12, like it was stuff on the iCloud from Ksoo, and that's why they say it got to be his phone, because why would it be dozens of pictures or whatever? Y'all remember that part? So again, they match a phone to it, and then the dad said he gave Ksoo the phone, so they matched a phone. But again, you know, some people may be like, hey, that still don't prove it was him with the phone. Siani, thank you. I appreciate it. Super sticker. Shout out to everybody that has been not celebrate, my bad. YouTube tell let's celebrate. That has been donating, whether you're donating super chat, super stickers, or cash apps. I appreciate it. Really appreciate it. Been putting a lot of work into being on here with y'all every day, and we still got time to go. I do want to ask y'all, when the jury goes back to deliberation, what type of content y'all want to do? Because we're gonna be live the whole time until a verdict comes. We're gonna do, for those who've been around with the Melly case, y'all know we stay on until a verdict comes. So definitely y'all let me know what y'all want to do while we wait for it. But yeah, definitely. Oh, thank you for another super sticker. All right, what's next? Who I left off? Dior said, let's go based off the evidence. That man innocent. Nobody ID case, so they should have fingerprint in the car. They did, and his fingerprints was in the car. The fingerprints was in the gun in the car. Like, what do y'all like? I'm gonna be honest. Okay, we can take out Butter and Blue. Was y'all here the whole 5 days? Why y'all keep saying there wasn't no evidence? Like, I don't understand. Like, it was literally evidence and people to corroborate the evidence. Like, I don't get what y'all saying. Like, I don't get it. That's just me. I don't get it. That's still not credible to hear say on Pop saying he gave the phone with no proof. What you mean? If a person physically said, "Hey, yeah, I gave this directly to my son," that's not hearsay because the person is saying they directly did it. Now, if he would have been like, "Oh, my other son gave it to," so then that's hearsay. So that's this trial is over and the defense never gave us anybody. Well, they did in the record say,
That will take us to 5:45. So I think I am going to excuse Mr. Robinson's jury for the evening. We will not get to Mr. Robinson's close today because if it is going to be an hour and a half, I don't want to begin that at 5 o'clock, or excuse me, at 6 o'clock.
Yeah, I mean, I don't
Because
need
then the
nobody
state
to
is
tell
also
me.
entitled to a rebuttal of that close.
I'm
So
actually
I'm going to
watching
excuse them now and tell them to be here at
today.
9:30 tomorrow. Because while we're going to finish Whitaker's closings today, I'm going to instruct them at 9 and they will begin deliberating. And while they are deliberating, we will conduct the closings for Mr. Robinson. And then I will instruct that jury and then they will begin deliberating.
So DNA was
So
in
I'm
the
going to bring them out now if there's nothing else
The
to
defense
raise by
tried to
anybody
do a
before I
great
do
job
so.
on why it was in the car, but it was in the car.
You just need to be here at 9:30. I'm going to be instructing
Okay.
Whitaker's jury from 9 to 9:30. So unless you want to be here, I'm not ordering you to be here. 9:30 is for Mr. Robinson.
Tree.
All right. Are we ready to bring Mr. Robinson's jury out so they can be excused?
So it was in the car. That's not
Yes.
debate.
They emailed it, we're all set, thank you.
All right. Let's bring out Mr. Robinson's jury.
Oh, is they talking? My bad. Y'all know I can't hear on my computer. Hold on. Oh, is they talking? My bad. Y'all know. Okay, I'm assuming they stopped. My bad. I had to cut down my phone, so I didn't even know they was talking. Hopefully, I ain't talking over them too bad. Mickey, if they took the guns and came upon the police, they would have been a shootout with police. We do not know how that would have turned out. I mean, the other suspect took the guns. Why not?
We have a slight change of plans.
Regardless, y'all consider
Having spoken to the attorneys for Mr. Whitaker between the close that's anticipated and the state's rebuttal on that close, that's going to take about an hour, and it is now 4:50. That means it would be 5:50 or perhaps even 6 o'clock before we begin with your close. So we're not going to do Mr. Robinson's close this evening because that's too late. Because then the defense would be entitled to give their close and the state a rebuttal to that close. So I am going to excuse you for the evening and ask that you all return tomorrow here in courtroom 407 at 9:30 a.m., a little later than our usual start time, 9:30 a.m., where we will then do the closings from both the defense and the state's rebuttal. And then I will instruct you on the law and then excuse you to deliberate. So during this evening recess, please be very mindful not to read, watch, or listen to any stories on the television, anything that might appear on your social media accounts if you have social media. Also not to speak to anyone about this case, friends, family, those that might be curious, those that might try to approach you as you leave here today or arrive tomorrow morning. And that's because this case has to be tried by you only in your collective presence and in the presence of Mr. Robinson, his attorneys, the state attorneys, and the court. We're going to take your notebooks, we'll lock them and secure them, return them to you when we reconvene. And of course, tomorrow, what I would also add is, I think the majority of you have been eating lunch. I should say all but one of you have been eating lunch in the jury room. Once I excuse you to deliberate, I'm not going to let your recesses will all be in there. There's not going to be going out and roaming the halls. So if you could, I would request you all bring your lunch to eat lunch tomorrow, because it may be that by the time I conclude with instructions, it'll be lunchtime, and I'm going to excuse you to begin deliberating at that time. And you can do a working lunch. You can eat lunch and deliberate at the same time, but I don't want a 1 hour lunch recess where one is absent, but the rest of you are in there. So hopefully if you all could bring your lunch and then eat lunch together and deliberate a verdict at that time. So with that said, I wish you all a good evening, and I will see you back here tomorrow at 9:30.
Not providing lunch is crazy. I thought they at least fed you during the liberation. Dang. Yeah, they gonna be ready to get that over with, Sharice. Like, they gonna be ready to go ahead and say, yeah, all right, guilty or not guilty. They gonna be ready to get up out of there. Now I want the Popeyes. That's crazy. They don't give them people lunch. Like, dang. So they gonna what? Finish out Whitaker today? I think they're gonna do finish out ATK Scotty. I'm getting sleepy. I hope they got a microwave in there. You got to bring in your own lunch. Shoot. I missed it. Fill me in, Mick. I mean, you really ain't missed nothing. Ksoo defense closing and rebuttal, state rebuttal won't be done till tomorrow. Scotty will finish today, and then his juror probably will start deliberating tomorrow. If I got that in the right order, y'all. Y'all know I was over talking the thing and didn't even realize it. Each state is different. Maybe they pay more since no lunch is provided. I know my state don't pay Jack Squad. When I went, they talking about we only get paid $7 a day or something like that. I was like, what? But my job paid for me to be doing it. So, I mean, I wasn't tripping, but I was like, Jesus. So, I'm hoping a lot of them people got jobs that pay them to be there. Creole said it's over for them. Pat said, Judge ain't ugly. If I was Ksoo, I'd be showing Judge all my gold team. He better not. That be like he trying to do something with the judge. At least give them people a meal of their choice. Right, pizza or something. Jesus. Boom. So yeah, I had it right. So yeah, Scotty jury will go to deliberate in the morning. You know, it was like $7. I ain't gonna lie. Cause I was like, what? I sound glad I'm getting paid. I really think it was like $7 for the day. I might be tripping. It wasn't that much. I think it was $7 for the day. I really think that's what it was. It was real. Yeah, it was. Because now that I think about it, they gave you like a gift card. And that's how much was on it, $7. Because I was on there one day because I didn't get picked. I was so mad. I wanted to do jury duty so bad. So bad. But I had to go back to work. So we just waiting for them to come back so we can listen to Scotty's defense closing. Hope they be animated. My state only pays half of what you make an hour, but my job still pay me too. See, that's what I was thinking. I was like, sure, I can get my regular pay plus some more. I mean, that would have been still good if you still get paid half, but yeah, they don't do that here for sure. They don't do that here. Each employer is different for jury duty. Yeah, because I got a homegirl whose job won't pay for jury duty. And I said, sheesh. Shout out to them benefits. If y'all just joined, we just waiting for them to come back in so we can finish out day 6. It seemed like, you know, we gonna just be rocking out for a few more days. I have heard that the trial for Govan and the Dolph case will take place in about 3 weeks. We will be back for that. In the meantime, y'all know I drop videos every day. Well, I'm gonna start back dropping videos every day, August 1st. So I'll be dropping video content between then and the trial for Govan, and we'll be back doing lives when Govan trial starts. After that, September, y'all already know we back with the YNW Melly case. Okay, we'll be back doing lives for the YNW Melly case for sure. Yes, that trial should be live streamed. Yeah. So August we got Govan for the Young Dolph case. September we got YNW Melly. And I need all my Melly people to pull up. Y'all know we had a great content time last go round. And y'all know I'll be ready to debate with everybody. Okay, so definitely be prepared to debate. Then we gonna come back in October for Lil Dirt. Then we got Mo 3 in November. We just gotta find something to do in December. To be honest, we just gotta find something to do in December. Because nobody dropped the info on the cases like you. I appreciate it. I appreciate it. Okay, we back.
And at this time, I'm going to call upon counsel for Mr. Whitaker for her closing argument.
Thank you, Your Honor. May it please the court.
Yes.
Would you please? Thank you very much, officer. I appreciate you. May it please the court, counsel. You may have realized that we stand every time you enter this court. We do that. This courtroom is literally the great state of Florida behind your honor. We're on this road. Two flags. The Florida flag. This and I point that out to you, ladies and gentlemen, because you have sacrificed. You have sacrificed your time. Time away from your family. Time away from your jobs. Time away from your pursuits. Be to see. When we're in this hall, when we're here, not on the internet doing anonymous comments. We're not in some kind of chat room where everyone's spousing their opinions. Put on and on about beyond and to the exclusion of a reasonable doubt. And I want to briefly go over that actual instruction, word for word. One of the things we've been doing while you guys have been stuck behind closed doors, not pursuing your own interests, we've been working on what exact words, what law, claims as you can see, a reasonable doubt. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving, and the state always carries that burden, of proving the crime with which the defendant is charged was committed
and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. And they go out of their way to define it. Whenever the words reasonable doubt are used, and this is what I want you to pay attention to. You always hear, and it's common because it is within the law, prosecutors say a reasonable doubt, and we even have a slide of the state's presentation. Reasonable doubt is not that statement is an accurate statement of the law. If you add the rest of the sentence, and the rest of the sentence is, ladies and gentlemen, if and only if you have what's called an abiding conviction of guilt, one which does not waver or vacillate, because if it does, even if you have a conviction, but it's not stable, it's one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. And you must find the defendant not guilty because that doubt, which could be imaginary, forced, speculative, it's reasonable because you don't have that abiding conviction of guilt. An image I imagine most of us. What do people see when they look at this image? Do they see two faces? Do they see the same face? When you have equal explanations, is it a vase beyond a reasonable doubt? Is it a fake two faces beyond a reasonable doubt? Ultimately, you all decide. You all decide what evidence. You're the fact finder. We can get up and pound on the table and do all kinds of crazy stuff, but at the end of the day, what I say, it's not evidence. The same thing says it's not evidence. Evidence comes from that witness. You have to decide what you think is actually credible evidence that you can rely on. That could give you an abiding conviction of guilt. And I will start at the outset from telling you we saw a lot of graphic violence in the past 2 weeks. This homicide was caught on video. We've seen horrible autopsy photos. We've seen horrible scene photos. And I don't think any of us would be human in disturbed somehow. And when you think about reasonable doubt and what the state's allegations, what I think about is I think about the concept of hitting one side of the river to the other. Chances are, most of y'all, to get to this courthouse, had to go over a bridge. By water. should be walking with us today is no longer, is not, never will be. They got to do it for you with evidence. There are, in this case, 2 charges. One of the instructions, and I submit to you a very important instruction, that there are 2 separate charges. Murder, aggravated assault. We have tried those counts together, honestly, to ultimately reduce the amount of time jurors would have to be in the courthouse. But they could have been tried completely separately. They could have been, a burglary could have been tried, a homicide could have been tried. We tried them together. Your verdict as to one of the counts has no bearing on the verdict as to the other. You are free to reject evidence. You are free to accept evidence. You are free to determine that maybe evidence supports one charge, but woefully falls short as to the other. I want to talk to you a little bit and never let you forget this image as you think about the state's obligation. Because I want to talk to you about what their actual evidence was. And we heard, and I will tell you at the outset, probably should have started with this. You all not making a determination in regards to Mr. Not asking that. I was going to argue to evidence. So let's talk about what evidence actually applies. Leroy Whitaker and is worthy of your consideration. I would suggest you are basically kind of 4 categories of what we heard that had any application in regards to Leroy Whitaker. We have DNA records. We have cell phone records. We have Duval Robinson Sr., AKA Blue. And we have Dominique Barner. Let's kind of start with some of the most straightforward evidence. And I will say it's straightforward. The DNA evidence. Now you've got to consider what that tells you, what that helps you to determine. We have 2 different kinds of DNA evidence. DNA evidence that was found in the car, and DNA evidence that's alleged to have been found in the drug group. Now, the DNA analyst, you will remember, was very, very clear. DNA is transferred. You might remember the example of I can hold an object, give that object to another person. They have it. They place it somewhere I've never been. It doesn't tell us when DNA was left. It doesn't tell us how. You've heard this statistical significance that she gives 700 voters. But remember where that number actually comes from. It comes from the community. They actually created a database with, if you remember the number, 1,197 people have had their DNA analyzed and put in this system. They use that to determine, well, out of these 1,197 people, only 2% of those people had a certain DNA character. And then they try to extrapolate that. Okay, the rest of the world must be like that too. And that's why I said, you keep saying no 2 people have the same DNA. That means that.
of time establishing IP addresses, who called who. Did we have that kind of testimony? In regards to this alleged phone used by Leroy Whitaker? Hold out for you. You're the fact finders. Oh, evidently in evidence. Look at these maps. What do they tell you? They tell you, and remember his testimony. I've drawn these maps, and I put up these arrows, and it's, anywhere in this area. 1.5 to 2 miles radius where his election is. So is it truly helpful? Because let's think of these population centers. We saw from all the photographs how many people are out at that Merrill Road. These phone records give us the exact location. Let's assume for a second you was chosen to act as a jury. The phone records are helpful. We think the phone records tell us where Leroy Whitaker's phone might have been traveling. Let's say we further even decide, you know what? I think that evidence was pretty compelling. I think it shows that he was at Merrill Road, and he was at Townsend Road, and he was at Oakley's house. That is guilt of first-degree murder. No. Then we have Mr. Abdul Robinson. Mr. Abdul Robinson Sr., and we know cooperator, just like John Parker, done it before successfully. He comes in. And what does he say? That I had a certain phone number and I got some calls that day. One was from my son, Abdul Jr., one was from Leroy. Somebody I know because he is the and I don't know anything else. Ultimately, I decide I'm going to go for my work. Right? Did you articulate to you all any evidence that Leroy Whitaker known about, thought about, participated in? Did you hear any evidence of Abdul Robinson Sr. saying anything close to that? I submit you did not. I certainly didn't hear it. I heard Abdul Robinson Sr. take the stand and claim, I picked him up. I had no idea what was going on. And then I took clothes and I went. But I asked him, did you ever hear Leroy Whitaker express a desire for anything to happen to Charles McCormick? Did you ever hear Leroy Whitaker say anything about wanting to do this, or going to do this, or encouraging anybody to do this? Not one word. But he doesn't give us anything. What do we have? We have something on. And the state of Florida just got up to their end of their argument, and they told you, hey, listen, we don't need these guys to prove this case. Take them out. If you don't have Dominique Farmer, if you can't trust what Dominique Farmer say, have no principle in murder. Because he is the one and only person who claims Leroy Whitaker was a full participant. And I asked you in the opening statement, I hope you write down in your notebooks evidence that Leroy Whitaker was a to get out of jail. That's why I'm doing it. That's why I'm coming forward, is to help me. And what else does it tell me? Okay. Raised his right hand in a criminal setting. I'm going to swear to tell the truth, the whole truth, and nothing but the truth. Knowingly lied. And he knowingly lied for his own personal purpose. He told you. Because he wanted the person to get out of jail so he could kill him. He wanted to handle business himself. So he literally used our criminal justice system for his own personal aim. Openly commits perjury. Tells us all about it. That's the evidence they want to use of the most serious charge you could ever be. Donald Arnold. It had 5 years to provide some kind of corroboration to that claim. That's Leroy Whitaker's gun. He brought a loaded gun. Of course, we must assume he knows what time it is. We must assume he's all in. This is Leroy Whitaker's gun. And remember the testimony. For 5 years, they have this guy's iCloud. They have everything he's ever posted. They have every photo he's ever taken. You're telling me that someone who owns a gun like this, someone who's so down with, hey, it's the middle of the day, let's go and stop somebody and shoot him in broad daylight. If he is that person, we don't think there aren't 50 photos of him with this gun? This Mac Daddy gun? He's not putting out a picture of himself with it? We don't have some video of him flashing around? We don't have anything of that. Detective Smith, 5 years, and that's the piece of evidence. All guns have serial numbers. Detective Smith ever try to trace this gun? It didn't just magically appear. There's all these bullets. They're huge. Search warrant ever conducted on Leroy Whitaker's house? Where he asked Detective Smith that? The interviews of his family. Surely somebody has seen Leroy Whitaker with this gun. This isn't just some handgun. This isn't some just revolver in the back of your pants. This is a Mac Daddy assault rifle. And if you're the kind of person that uses instruments like that to gun people down, you're damn proud of it. And of course you know. No. We have a claim of Dominique Armour. Oh yeah, that's who he is. I imagine we might get an argument. Well, we think there's 3 people in the car. There were 3 guns. Were there? Who testified to that? Even Dominique Armour himself. He said, I know I had this and Leroy had that other gun. Shooter had some other gun. We know supposedly the shooter left with his gun. Just because there's an extra gun in the car, it automatically, logically, beyond a reasonable doubt, is Leroy Whitaker? Without any other evidence? Think about all the things Detective Smith could have, but didn't, or maybe did, and just the evidence isn't available for this rifle. Because we know there's no fingerprints. We know there's no DNA on it. We know there was no search warrant for his home, any interviews of his home. We know he didn't attempt to trace this gun in any kind of way. And most importantly, you know the biggest thing you didn't have? Yes, might have been a little helpful. You didn't have an iCloud or a phone from Dominic Buck. It is important to remember how and why Detective Smith explained that. Why didn't you get an iCloud for Dominic Buck? Why didn't you try to get the physical phone by August of 2020? He's a state witness. He's a cooperator. You have, with acknowledging his lawyer, access to him. He wants to please you. He is trying to work on 2 homicides. Would it be helpful to have all of Dominic Barner's photos? Are there any photos of this gun? When you consider it a state, you didn't do a conviction of guilt, one which does not waver or vacillate. I want you to consider absence of evidence. Because again, Leroy Whitaker, 19 years old, good statements. They were very upset about this. They didn't like this song. They got to the point where they were murderous over it. Was the testimony at Leroy Whitaker. Even, I think everyone in the courtroom forgot I was here this morning. Hakeem Robinson's sister, and the state of Florida asked her question. You all were very upset about Will's death, weren't you? You all, we, they. She said, oh yes, yes. And then it's like, wait a minute. Man, what's the age difference between Leroy Whitaker and Willie Addison? We're talking, he's 27, 28 years old. Leroy, 9. You heard his sister explain. Well, Leroy Whitaker didn't have a relationship with them. Not Leroy Whitaker's brother. Leroy Whitaker is only the cousin to Hakeem Robinson. He's actually not the cousin to Abdul. There are multiple different family members involved in the Robinson. Mr. Robinson himself told you he had 11 children. So where was this evidence that Leroy Whitaker has this big motive? We've heard they, we've heard we, all those kind of group words. Actual evidence that's Leroy did. Because again, a lot of other evidence that we've heard in this case, we've heard a lot about Hakeem Robinson's iCloud, how he's posted pictures, how he's having pictures at Willie Addison's actual tombstone, like in memorial, in honor of him. Leroy Whitaker even in that photo? No. How about an investigation? Was Leroy Whitaker even at his funeral or any kind of memorial? Is Leroy Whitaker, I'm sure we would have heard about it if he did, he even had this diss song, this truly diss song in his phone. No evidence. Nothing. Let's remember what the evidence was. The evidence from Dominic Barner himself, and the only evidence you were presented to support a theory of guilt for first-degree murder were phrases such as, y'all knew what time of day it is. I never heard anything directly out of Leroy Whitaker's mouth. He was for it. his gun. Claimed, and he tried to claim to us, oh yeah, I'm really good friends. I'm 26 back in 2020, 31 now. I'm 26. And Leroy Whitaker's 19. And he tried to tell you, oh yeah, we keep meals together. I had to impeach him. I had to show him his own transcript. It's like, yeah, never should deal with that guy. But supposedly, they're so, I guess, in tune with one another. What, they just telepathically speak? Oh, I know that you're okay with this. One of the reasons we're just left with, he's right. He's been on it. Nope, never said anything, but I just know. I just know because he supposedly brought this down. Right? That it's really hard to just go up in detail. You just leave it to, hey, the problem is when you are deposed for over 9 hours and every word is transcribed, you're locked in. You're committed to that story. And once somebody lying about everything, no, we know he's not. We know he was there on January 15th. We know he drove them to the Townsend, drove them to Merrill Road and then drove them directly to Townsend. We know John. From physical evidence, we also know as an action. And that's the reasonable doubt instruction contemplates. Every good lie has a crime of truth. You're not just going to make up something outlandish. You're going to pepper it with work off 2 murders. He's got to work off an aggravated fleeing. He's got to work off a burglary with assault. What does he need? Conditions. Wants conditions. And so doesn't it just make it easy for Dominique Barr to say, yep, and by the way, Leroy Whitaker was totally part of this. He was all in. Those are the magic words. You heard him explain. Did you do an arrest warrant after you got these phone numbers? No. Did you do an arrest warrant after you got the DNA? No. Because what do those things do? Those things tell us he was in a car, he was in a house, he was there. And the one thing you're never going to get an instruction on, ladies and gentlemen, is you're not going to receive an instruction that if you're at the scene of a crime, what is required for the state of Florida to actually prove to be a principal? It is far more for one, things that must be proven on the exclusion. Meaning, not wavering, not vacillating, finding conviction. That's where it comes down to. The only evidence you received of these 2 elements was Dominique. And at the best of Dominique Barber's testimony, it was, I assume there must have been other conversations he brought supposedly. That, ladies and gentlemen, is not proof beyond actual participant, if someone was actually encouraging someone. Bring testimony. Hey, Leroy Whitaker brought everyone ammunition. Leroy Whitaker stole the car. Leroy Whitaker yelled out encouragement. Go get it. Do it. Nothing. What does Dominic Varner claim Leroy Whitaker did? The one and only thing that he claims. And I submit to you, even if we wanted to believe that, that would still be insufficient for a principal. Because what would bringing a gun do to incite somebody else? I mean, according to Dominic Varner, he didn't need any inciting. He's up at 3 o'clock in the morning driving out to McCormick's house with his best friend, Chris Brown, to stalk him out and plan it out. And you remember, it was interesting. I asked Mr. Varner, I said, well, you certainly remember the details. You and your best friend, Chris Brown, driving out there that morning, talking all about the details, how you wanted to do it. You know all those details. And what's truly interesting, I submit to you, Jacksonville Sheriff's Office already told you what you truly think about the veracity, the truthfulness of Dominic Varner as being the one and only. Brown, never arrested. Oregon Williams. Even though, according to Dominic Varner, he could tell a jury all about Chris Brown's involvement. Chris Brown looking up at the complex. Chris Brown evidently wants to be involved in this so much. According to Varner, he comes back out there. They talk about it. Morgan Williams is allegedly arranging rides and going out there. What was besides Dominic Varner? Oh, that's not even probable. Now, fast forward, Dominic Varner, in regards to Leroy Whitaker. Now, Dominic Varner can be believed, right? Because they have some any corroboration to Dominic Varner's claims that Leroy Whitaker had a conscious intent that the criminal act be done. And that he did some act or said somewhere. Only. Who was it that supposedly incited and how? Because we had no testimony. The other thing that I will tell you is probably the most telling. I'm going to get into the Jacksonville Sheriff's Office. For a little bit about it yesterday, is that as an investigative technique, Jacksonville Sheriff's Office can do something that's called surreptitious tape. So you have 2 suspects. And they'll do this oftentimes when 2 people are arrested together. They might put them in the back of a police car, put them on camera. Same with the interview rooms. Put them in there. From the timeline is somewhat critical. August 27, 2020, Dominic Varner agrees to be a state witness, files a sworn statement. All of the arrest warrants are completed at that point. Jacksonville Sheriff's Office didn't charge Leroy Whitaker with murder until Dominic Varner said the magic words. But then you have them. I'll die. I swim.
Another technique they could have attempted, and we heard they evidently thought well of it because someone wore a wire on Dominique Varner. Why not on Leroy Whitaker? Why not? We're about to charge a 19-year-old young man with first-degree murder that you've heard from Dominique Varner. He had to make sure that he cooperated. He did not want to go for mandatory life. He has to say something. And so it becomes Leroy Whitaker was involved. He was all in. I can't give you any details. I can't point to a text message. We just saw some text messages between evidently Abdul Jr. and Dominique Varner. Was Leroy Whitaker copied on that? Do we have text messages from Leroy Whitaker and Dominique Varner or anyone even mentioning Charles McCormick's name? Do we have any kind of posts that Leroy Whitaker acknowledges ATK, acknowledges Six Block, acknowledges some kind of rivalry? No, we've only heard they have a rivalry. They were upset about Willie Addison's death. What has been shown to you about Leroy Whitaker? Ladies and gentlemen, I submit to you nothing. We have magic words from Dominique Varner, not supported by a single other piece of evidence. I want to skip to this slide because it is an important instruction in that actually set out these instructions. And they spent a lot of time doing it. They actually put this in the law because it's that important, because they recognize that you must consider the testimony of some witnesses, snitches, with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity or hopes to gain more favorable treatment in his case may have a reason to make a false statement in order to strike a good bargain with the state. May. As kind of an aside, because I know you guys have been here long, I'm going to tell you about my husband's and mine's first date. Because strangely enough, our first date was to see the movie Indecent Proposal. I don't know if you ever saw that movie. It was Robert Redford, Demi Moore, and but essentially you had this married couple, and Robert Redford ends up propositioning them that Demi Moore will have sexual intercourse with him. And I have to tell you, as a first date, it was kind of an amusing movie to watch. Prompted a lot of fun conversation afterwards. We're still married, so it all worked out. But I think about that kind of scenario in the scheme. It's not mine. Something's arguing for it. He's 31 years old. We know, and we know it's much less than that. If he ends up getting 20, he's got 5 years left. He doesn't have any remaining toys, so he ends up getting out even. He has to do a long time to be. What would Dominique Varner do? You know, he
aggravated fleeing, and he's got burglary with assault or battery. Dominic Varner needs convictions. It's not going to be sufficient, not for his sentencing hearing that he has planned, just to say, oh, well, yeah, we went into the house. No, Leroy Whitaker needed to be part of it. He needed to be part of it so that Dominic Varner can have one more conviction to try to hang his hat on of why he should get out of jail. As he said, well, I think I should get the 20 years because I'm bringing justice for the family. And with that, you do have to recognize, and I mean this in all sincerity, homicide detectives work very, very hard. I'm confident of that. And I don't think Detective Smith is any stranger or anomaly of that. I'm sure he works extremely hard. But there is pressure on homicide detectives. Because as I asked him, they're the ones that have to go and sit down with the family to explain your loved one's not here. And so there is pressure to get anyone that was a part of the death of their child. That pressure is understandable, but it doesn't erase their obligation that they do actually have to prove it. It's not enough to simply say, he was in on it. I'm sure there were conversations. Because at the very end of the day, ladies and gentlemen, even if you wanted to try to believe Dominic Varner, when he claims, well, once we got to the apartment complex, there was this discussion that both Leroy Whitaker and the shooter were going to shoot. Both were going to do it. What do we know? We know Charles McCormick was killed by a lone gunman. So even if you believe every single thing the state has presented to you, the reality is he didn't do it. They've shown nothing, not through photographs, not through Instagram posts, not through phone calls, not through text messages, not even through that Leroy Whitaker had any intent for Charles McCormick to die. I am going to sit down in a few moments, and I ask you to indulge me for just a few moments while I go through my notes. Because let me tell you the worst thing for a trial lawyer, and it doesn't matter what side you're on. You sit down and 2 seconds later, I'll think of something that I was dying to tell you that I just simply forgot. Another difficulty in terms of that lack of evidence, and reasonable doubt can come from it. There was zero investigation in regards to this car. And Detective Smith, again, was like, well, it had been gone for 2 months. But again, they're trying to ask you all to convict of the highest charge in the land on Dominic Varner's testimony alone. Nothing else they presented proves the principle or even alleges it. He didn't even have probable cause until Varner said those magic words. Why? Because being at the scene of a crime is not a crime. You need to do more. And they've literally not shown you anything. But why wouldn't? Detective Smith, you have this car that's stolen. 2 months ago, did you even bother to talk to the person who owned the car? No. Did you even talk to the last person who drove it to understand how exactly it might have gotten stolen, if there's any potential lead for us to figure out where this car was for 2 months? No. Detective Smith, you have, as a Jacksonville Sheriff's Office tool at your disposal, these license plate readers, various spots in Jacksonville that you just type in the license plate and it will tell you, hey, on such and such day at such and such time, this car passed this intersection. Here's a photograph of it. Been helpful. Ladies and gentlemen, I suggest it might, because we have a complete lack of evidence. The most simple thing, and if you think about the allegations are that all of this involves this big drill music, rap music. Ever turn the car on and figure out if anybody actually connected it? No, our software can't do that. How about just manually looking if there's a phone attached? Not done. That's a lack of evidence, ladies and gentlemen. We have no evidence of social media posts of Leroy Whitaker, of rap lyrics of Leroy Whitaker, of notes in his phone of Leroy Whitaker, text messages bragging, none from Leroy Whitaker, text message to Leroy Whitaker, talking about McCormick, talking about being with them. None there. We have no evidence besides Barner that that's his gun. We don't have anything tying him to the gun. We have no investigation as to the serial number of where this gun came from, how it might have gotten into whoever's hands had it, how it got in that car. None of it. We just assume. It's almost as if Leroy Whitaker is almost a footnote, an afterthought. Oh yeah, and Leroy Whitaker. Oh yeah, he was all in. We don't have any actual evidence that he ever manifested any desire for Charles McCormick to die, that he ever did anything besides potentially sit in an Altima car. That's what they've shown you. Detective Smith told us all we ever asked from Dominique Barner was the truth. He didn't ask him anything. The last question that I asked Detective Smith, if you remember, because we had these questions about how even after arrest, the investigation continues. And on September 11th of 2020, Detective Smith had executed that arrest warrant that talks about phone records, that talks about DNA, and most importantly, contains those magic words because Dominique Barner has come forward. But if you remember, my last question to him was, after the arrest, number one, of Dominique Barner, did you, Detective Smith, ever sit down with him and say, okay, let's really talk about this. Let's make sure that there aren't any other investigations or your iCloud or anything else. Never spoke to him. And even worse, I asked him, after that arrest warrant, did you ever, I know your investigation supposedly continued, did you ever develop any
vacillate. Leroy Whitaker was involved in this homicide. Leroy Whitaker manifested some intent. We have no evidence of that. My greatest wish for you as jurors, after you ultimately leave our hall of justice, is that you feel pride about your experience, pride of being part of the system that we all do cherish, pride in a system that upholds the law and is bound by the law. And you all are bound by the law. The burden of proof in this case is beyond and to the exclusion of a reasonable doubt. And to illustrate just how much, just how high of a burden, really think that all of these things, if we were somewhere not in a hallowed hall of justice, and we thought to ourselves, you know what? Three people, I think it's pretty. You think, you know, their family, yeah, he probably did know what time of day it was. Those are all guilt, most likely. Legally, that's not guilty. Guilt, likely, not guilty. Probably guilty, not guilty. Possibly guilty, not guilty. Suspected, not guilty. Perhaps not guilty. May not be guilty, not guilty. Possibly not guilty, not guilty. Unlikely guilty, not guilty. Probably not guilty, not guilty. Less than likely guilt, not guilty. Not likely guilty, innocent. When the state falls short, ladies and gentlemen, your constitutional burden is to find him not guilty. On behalf of the board, and we urge you to follow the law, analyze evidence, Charles McCormick Jr.
All right, thank you, Ms. Schlax. State rebuttal close.
You may please the court.
Yes.
Counsel. There is a lot of pressure. There's a lot of pressure on the state of Florida and on the Jacksonville Sheriff's Office to bring justice. Charles McCormick. Justice. Lil Buck. For the horrible crimes committed against them. And the defendant is not guilty because bad things happen to good people. You better believe that there's pressure. Because what the defense will have you believe is that these two crimes will go without justice, full justice, based on DNA evidence in multiple locations with a 700 billion times more likely ratio that is this defendant than anyone else in the world. And his phone records will put him every single step of the way exactly where he's supposed to be and totally corroborate
beat a woman to make sure he got away. Innocent people don't run away and break into the houses of citizens on Townsend Boulevard because they're just along for the ride. We heard an hour closing argument from Ms. Schlax, and God bless her. She is upholding the defendant's right of counsel to zealously represent him within the bounds of the law, and she did that. And she spent 59 minutes and 30 seconds talking about Charles McCormick. About 5 seconds talking. Why were these crimes charged together? And Ms. Schlax is right that you're to consider their verdict separately. We considered all the evidence in the case. The evidence against Hakeem Robinson and the evidence against Leroy Whitaker were both charged together because you can't unwrap it. This is one criminal episode. And the evidence against Barbara Buckley, 1,000% proves he was involved in the murder. Why else do you break into a woman's house and grab her and say, I'm going to hurt her? Why on earth do you do that? Unless you're with the big gun. And that's why it wasn't discussed. Because if you analyze this case in total, there is no reasonable doubt. She talked about the evidence is DNA. The evidence is cell phones. The evidence is blue, and the evidence is barter. She left out a really, really important thing. And that is your God-given common sense. Your ability as a human being to realize that 2 plus 2 equals 4. You can make logical inferences from evidence to speak to what the truth is. Not only borrow and lie all day from the witness stand, but you have judgment. I'm going to go through a whole bunch of things that prove that Dominique Barter didn't lie. Is a liar. And a criminal. So, first, I want to have nothing to do with Dominique Barter or Abdul Robinson. The Addison family and ATK was dissed by the victim in 6 Block in a song making fun of their loved one. That limits the number of people in the world. Mr. Cooper is going to pull up proof. Ms. Schlax said there's no evidence that Scotty is involved in ATK. There is. The fact that his Instagram has ATK on it. You can just circle that straight to the top of us. Life of ATK with big ATK written. Huh. I know, listen. I consider Mr. Cooper far better visual ethics than I am. You saw they did most of that. We threw a lot of stuff at you, and I get it, and these things are missed. I don't think the Schlax is trying to mislead from the same generation. But it's in there. Testimonies uncontroverted. This Robinson, who we heard from today, said, oh, they're not just friends, they're cousins. They're blood, and we were all there. Mr. Whitaker is in for a penny, in for a pound, just on motive. That should not be in dispute. He is objective. He is part of that group. Now, is he as big as Hakeem Robinson? No. Is he a rapper? No. But he's with them. We see the pictures of them together. We see videos of them together. They are hanging out thick as thieves. So the number of people that were willing to kill Charles McCormick, who's showing up at an employment service, is limited. It doesn't mean it's Leroy Whitaker exclusively. No, it doesn't mean that. But it's limited. That's objective. Number two, that both defendants, and remember, the evidence against Robinson corroborates the evidence against Whitaker and vice versa. That's why we tried them together. And I agree with Ms. Schlax's point that the verdicts are separate. That's why we have two juries. But you have to consider all the evidence and see how all the evidence fits. Both of the defendants had the opportunity. The whole point of the cell phone evidence, Ms. Schlax is right. It's not GPS. It doesn't put him everywhere at the possible location. What it doesn't do, it doesn't exculpate him. It doesn't show he's somewhere else. In fact, it shows he is everywhere the Dominique Barner sends cell phones. Mr. Whitaker's cell phone stuff is actually the TDOA, the bands, and actually gives us a little bit more precise. And if you remember that testimony, he is at every location. He is at the Maryland Road, Townsend Road, at both of them. Receiving calls, texting locations, all his phone. We prove it's his phone. We went over this, I'm not going to do it again. The Instagram for the defendant, this Instagram was verified with this number. He has all these little selfie pictures. That's how we prove it's his selfie. And it's corroborated because it's going exactly says this. Again, this is objective. Selfie stuff is objective. It puts him in Townsend Road and it puts scene. And that stuff has nothing to do with Dominique Barner. Oh, and guess what? Robinson evidence does the same thing. He turns his phone off with his real phone, his burner phone. The data is hitting on all the points it's supposed to be hitting. Corroborating everything. Objective evidence. We know that the Nissan car is the murder car. There is no dispute about that. The Nissan car that crashed is the murder car. That was trailed and followed by the police from the scene of the murder, from the dash cam, until it crashed on Townsend Boulevard and people started running from it. Right? And we know that the shooter fled from the car with the weapon. The same weapon he used to kill, and it's Hakeem Robinson, there's no doubt about that. The same weapon he used to kill Charles McCormick is the same weapon somewhere in Tree Hill Preserve. The same weapon he had in that video that you can see, the video, Bang It Up video, is the same you can see. And that guy ran out with his gun. These guys were in murder, but these guns are considered relevant and very important to prove the case. They're not murder. He took his murder weapon and got rid of it. That is what Dominique Barner went and used his pistol. Because he's like, hey, you're not using this, you gotta throw this away afterwards. You can't even call it a murder weapon. You can't have my gun. You gotta use your own gun. Anyway. And so we know that there's two guns left. The murderer took the weapon, and we know that we found two guns in the car. Mr. Robinson was linked to the murder car in three ways. The shirt in the driver's area, his DNA in the driver's compartment, and the print on Dominique Barner's slide of his handgun. Three different ways he's placed it. Whitaker was placed in the car in two ways. Leroy Whitaker was on both shirts. One of them was with Hakeem Robinson. Both of these shirts, whether they were worn or not, maybe they were worn earlier, maybe they were worn as masks to cover, we don't know that exactly. But we know that they were kind of balled up, especially the one in front. And wrapped up right next to the gun. They're wrapped up. And they both have their DNAs on them. 700 million times more likely. Okay? It doesn't just jump around. It doesn't just jump around. So, that two shirts puts Whitaker in the car. He's in the driver's side and the passenger in the rear part. Schleck said over again, there's nothing that puts him on this to this gun, which was swabbed, tested, nothing was on it. That means no one's ever touched it? Of course not. I mean, and fingerprints are sometimes tough to get. You touch something, it doesn't almost, it's not on top of it. It shows in the seat. The gun's right there on the floorboard. You can't sit back seat without touching that gun. I can see it. And Leroy Whitaker's DNA on that shirt. No real dispute about that. We hear a lot of dispute about that. His DNA is on the shirt. A lot of dispute about it. She screams over and over again, there's no evidence. But if your DNA is on the shirt, the backseat, right, almost touching a huge rifle, that's pretty good evidence that that defendant had that gun. It's pretty good evidence if you use your God-given common sense. Robinson possessed the similar unique firearm before the crime. We talked about that. Now this is, I can't stress this enough. I opened with this. But Whitaker and Barner were so desperate to get away from this crime scene that they broke in to a woman they did not know, a 57-year-old woman's house, and they left their DNA on her pajamas. It wasn't just DNA. It was blood. It was blood on her pajamas. And the testimony from the DNA analyst was it was both single source from the mixture. I have to explain this. You're gonna find Miss Buckley's DNA on Miss Buckley's body and on her clothes. Right? If you're wearing clothes, you're gonna find my DNA. She's looking for the DNA on the neck, the hands, and the clothes. She tests, or she can find DNA. All tests for blood. Barber's blood and Whitaker's. But it's not a mixture of the two of them. Blood that matches this defendant is only his blood on her vagina. That cannot be transferred. Then it would be Barber's mixture. His blood, how does his blood get on her hand? The only way. She described it, by the way, calling him the squirrely one. Squirrely one hit me. Squirrely one participated in holding back and grabbing me. Squirrely one threatened to hurt me. Ask Barney if I should. Proof beyond the exclusion of every reasonable doubt. That's proof beyond all doubt. That's proof beyond a shadow of a doubt. He committed a burglary and assault act. What that means is your God-given common sense that you're going to believe that he had nothing to do with the murder? What? When he's leaving his DNA next to the firearm? When they're sitting with him for hours and hours leading up to all of this? Whitaker and Barner got picked up by Blue. We have the pin track. We have the cells. Blue pled to doing that. He said, Abdul Robinson, I came out, picked these guys up, and they got me on the hook for the accessory after the fact. These are undisputed facts. Robinson is right-handed, wore a black and gray hoodie, just like the one the shooter has. Robinson was very happy about the murder and liked to brag about it. The video proves that the descriptions of the shooter were all wrong. So let's talk a little bit about motives to lie. All of that evidence, I submit to you, we don't need one at all. But we still have to analyze what he has to say to compare it to the known evidence. Is he telling the truth? He is a liar. Why should he lie? Two very different questions. Very different questions. Barner, first of all, this is a minor point. Barner and all witnesses, every witness, met with the prosecutors and the defense attorneys before testifying. We heard a lot of questions like, well, how many times did you meet with the state? That's implying that somehow Mr. Cooper and I telling these people what to say, doing a little crappy job. We meet with our witnesses because we need to know what they're going to testify to. And you know who says it's okay to meet with your witnesses? The law and Judge Salvador. Quote, you will hear this later. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Quote, Judge Salvador, when you're charged to hear this case. No witness should ever be discredited because they sat down and talked to both sides about what they would testify to if called as a witness. That is the law. So Dominique Barner shouldn't be discredited because he met. Dominique Barner, and this is a fact, Dominique Barner wants to get the best deal for himself. I don't think there's any doubt about that. He's doing this for selfish reasons. He's not doing this out of the goodness of his heart. He may say that. You know, I want justice. Okay, whatever. Talk a second about his deal. There is no evidence he's getting $20 million. That is the minimum Judge Salvador can give him. And she can give him life without parole. Anything in between is her decision and her decision. The whole concept that we bought this testimony, that's a real bad deal. He just pled guilty, confessed over and over again on the road, 9 hours of deposition, confessed to multiple murders. He knows that this judge can say, I appreciate what you did, Mr. Barner. I'm giving you life. That's the deal they're talking about? To strike a good bargain? What kind of bargain do you strike with the state? But his plan, according to the defense, his plan is to lie. When we have that much leverage of him, Judge Salvador has life to hang over him. And he's going to go, you know what? I'm going to make up who did this. He's going to make it up. Leroy Whitaker had no idea what he was doing. Right? He was just sitting in the car. We tricked him. This is the argument. What if we find out evidence he was lying after pled and looking at life? How would that look in his sentencing hearing? Your Honor, Mr. Barner agreed to testify and cooperate, but he lied about who was involved in this case. He said Mr. Whitaker was involved, and he wasn't. What? That's where you have to critically analyze what Barner's saying. Of course, he wants to make sure that the truth comes out because it'll help him. Help him, the evidence will corroborate the truth, and all that pressure. Barner doesn't know that Blue's going to testify. Blue doesn't know Barner's going to testify. Well, maybe he did by the time he flipped. Barner didn't know Natalie Gay and Renata Boston were going to testify. Again, this relates more to Hakeem Robinson, but it doesn't. He says Hakeem Robinson is the shooter. He doesn't know Renata Boston's going to come into this courtroom and Renata Boston's going to say, yeah, it was some dude, I got an alert on my phone. Some dude wearing a black and red jumpsuit came crawling out, walking out of the woods. And some white girl was driving around looking to pick somebody up. And Natalie Gant, who is not, we have no leverage on her. None. Nobody's arrested. Nobody's in trouble. Natalie Gant, just take a sworn statement once we figure out who she is. Take a sworn statement. Yeah, I went and picked up Hakeem Robinson from the exact same location that his phone's pinging that we have that little map. That corroborates Barner. And that means he's telling you the truth about all this stuff. Barner didn't know that the digital expert Latham was going to do a body morphology and conclude the defendant could be the person behind the mask. Same argument. Has to do more with Hakeem Robinson. This means he's telling the truth. When he says it's Hakeem Robinson, he doesn't know that we're going to spend $70,000 on some digital expert to go, yeah, that sounds like him, kind of looks like him, it matches. It's consistent. Barner didn't know that we would be able to link Whitaker's phone through Instagram and prove everything that he testified to. Barner couldn't have known that the cloud would capture proof that Robinson's burner phone was his and would link Robinson to the murder. I mean, for all of Dominic Barner's issues, I don't think his brilliance is going to be argued by anyone here. So he's supposed to know all this stuff and predict it? Barner could not fabricate the DNA evidence, and it proves this defendant's guilt. Barner didn't know that Robinson's known cell phone would be turned off during the murder, but his cell phone data from his the cell phone from the burner phone would be hitting off the towers. He also didn't know that the cell phone data from the known phone, which we remember when we did Google searches. And the analysts said we don't do that because the data is 95 to 98% reliable, but that's not good enough for us. So we don't chart where the data is because we know there's some anomalies. So we can chart that. The defense went up and put the numbers in anyway. You know what that shows? It shows that the known phone of defendant Robinson was at Dominic Barner's house picking him up and then driving to Atlantic Boulevard where they picked up the Nissan Sentra. Then it magically turns back on when everyone's together and all the crime is over. That's interesting. How does Dominic Barner know that? So let's talk about the principal instruction, because we heard that over and over and over again. Mr. Powell's going to pull that up. So again, using your common sense, this is how we prove it's a principal on Charles McCormick. Okay? We're past the burglary of that. Past proof beyond reasonable doubt, and that is really, I said to you, enough evidence to prove the murder, because nobody does that to an innocent woman unless they're fleeing from the police for a reason. But let's analyze it a little bit more. We know that they were all together for hours. This plot is all night. They're actually sitting in the apartment of Charles McCormick waiting for him. They didn't kill him. They were sitting there for hours. It was like a stakeout. Unfortunately, they're not as good at the police at doing stakeouts because they got distracted and they're playing with their phones or whatever it is. They miss McCormick leaving. But they're there for hours. Mind you, with all these guns, this rifle is not concealable. Hakeem Robinson's pistol rifle is not concealable. They're all sitting there. Having a conscious intent of the act be done is like going to a football game, being invited to a football game. Hey, we're going to a football game. You want to come? And it's driving all the way to the stadium, sitting there for 4 hours, shaking a pennant in the air, watching the game, having to come out. I didn't have a conscious intent to go to a football game. I didn't say I wanted to go. I just sat there cheering. So, we all know they were together stalking the victim. We know that there's a huge rifle in the back seat that he could not have missed. Whitaker, and this is an interesting point. When the crash happens, Robinson goes his way at the passenger side. Whitaker and Whitaker both go together. Whitaker is leading. Whitaker does everything from that point forward in terms of getting them away. He jumps over the fence first, presumably cutting his leg. Barner's right with him. Then they follow each other, Whitaker leading, into Miss Buckley's home. He is leading the escape, leaving his blood unmistakably on her leg. Barbara Buckley's testimony proves to you on Dominic Barner nothing from legal. Why are we in this woman's house? What just happened? Why did we shoot that poor man in broad daylight in Merrill Avenue? you want me to hurt her? Brother? You want me to hurt her? Barbara Buckley doesn't hear a word of animosity, doesn't hear a word of fighting, doesn't hear any conflict between the two. And both of them working together and in conjunction proves what Dominique Varner says. It proves that the defendant is a principal, because what's the common sense? I just witnessed a murder I had nothing to do with, and now I'm breaking into a woman's house to get away. Am I going to work with the person that was obviously in on it? The driver? No. No. They were picked up together, both wearing the Buckley pajamas, having both left their blood all over Miss Buckley. Working together as principals. And they all have the same motive. They all have the same motive. Couple points about the DNA. The defense says, oh, it's flimsy, 700 billion. This is science. This is scientifically accepted in the community at large. This is what DNA evidence is and has been for decades. This is the statistical certainty that they can provide, which is much lower than the actual statistical. Remember, she said it's way more than 700 billion, but we only provide the 700 billion. If you try to count to 700 billion, it would take you 25,900 years to get to that number. You would count 1, 2, 3, without breaks, never sleeping, never drinking, never eating, never dying. It would take you 25,900 years to get to 700 billion. There is no doubt that the blood is the defendant's, the DNA on the shirts is the defendant's. There is no doubt. 3 people, 3 guns, couple of small points. The search warrant of the Whitaker home, he's arrested months later. Remember, we didn't arrest Whitaker for the burglary with assault or battery because we didn't have the DNA for months. Hakeem Robinson was developed as a suspect very early because of the fingerprint. He had those results. Jacksonville Science Lab itself. DNA took months. Once Leroy get a search warrant months later, try to find something, all that time he was out, he had the ability to delete, to get rid of phones. We don't have his phone, to get rid of clouds, to do all kinds of things that he wanted to do to make sure the evidence wouldn't be discovered. Wires and putting people together. The defendant was in jail, charged with a crime that we are trying here today, and had a lawyer appointed to him. He had counsel appointed. So all these neat little tricks that they think we can do, stop by having a lawyer, and he's charged in this case. You know, they say that Varner is a bad liar. He's bad, he's a liar. Okay. Then she spent about 20 minutes at the end of her closing saying how Varner doesn't say what my client did. Why on earth is he lying about this? Not exaggerating. Why doesn't he just say, yeah, I'm down for it. He told me, let's kill that guy. That's not hard to remember. I'm going to kill that guy. I'm going to do this again. Doesn't say that because he doesn't remember it. He's not bought and paid for. He says, listen, I know he's down because he's sitting in the car in an apartment complex for 3 hours, raising bar. Remember, he doesn't have to say, the principal instruction is act. By word or act. He doesn't have to say, all right, let's all huddle up. This is what we're going to do, which they did do. All he has to do is be there and clap out of the huddle. Really good analogy. Think about this. God orders calling plays. Everyone's in the huddle. Trevor Lawrence says, we're going to run off tackle right side to ETN. Everyone goes, ready, break. Who talks? Trevor Lawrence. Everyone will. Most everyone's on the same page and they'll jump off sides and they do it all right. That's exactly what happened here. That is what the principal theory contemplates when it says word or act. Beyond and to the exclusion of a reasonable doubt, maybe the defendant is just the most unlucky person on the face of the earth. That his DNA is everywhere, that he didn't know anything that was happening, and everybody's just coming in here and lying on him. He's just guilty. Beyond and to the exclusion of a reasonable doubt is not possible doubts. It is not x-ray machines at the airport. We talked about that in jury selection. Have a blow dryer or a gun. The person who's checking the x-rays has an absolute duty to confirm what these things are. Right? How are we going to do that other than the presentation of all of this? We don't have time. The law doesn't contemplate all doubt. If there is a possible doubt that a gun is getting on a plane, don't let it on the plane. That is not what the law contemplates. The law says that such a doubt should not influence you to return the verdict of not guilty, even having a body conviction of guilt. Reasonable means logical, well-founded doubts. That's what reasonable doubt means. Reasonable doubt, I agree, we have to get you across the river. It can mean that the boat gets wet. It can mean that there's a hole in the boat, but you still get across the river. That's what reasonable doubt is. We have to show you common sense and evidence that this man was a participant in the murder of Charles McCormick and beat and battered Ms. Buckley when he entered her home to escape the police. And when you combine all of these pieces of evidence as one and analyze Abdul Robinson Sr. and analyze Bada and say, I don't like him. Arm, we say, checks out. And you have an body. It is the same level. Proof is the same as if you steal a pack of gum. You commit first-degree murder. It doesn't change. Not proof beyond possible doubts, all doubts, shadow of a doubts, but well-founded, logical doubts. That is what a reasonable doubt. And you can have pride. You convict this person. It's the right thing to do, based on the law, based on the evidence. He's guilty. He's not the unluckiest man on the face of the earth. Just was in for a penny and in for a pound. Everything he could. He didn't count trail of evidence that he would leave behind. He didn't count on Dominic Barner and Abdul Robinson coming to this courtroom. He didn't count on the cell phone records and Instagram records that would prove where he was. He didn't count on the Ksoo who played the acid and how the tiniest little bit that you leave behind can be discovered by forensic. Didn't count on any of that stuff. Hardest part about doing this is knowing that Charles McCormick's family, Charles McCormick, nothing that we do here change now. Will forever be as he was on that slab of metal. What we can do who's involved. Not who's responsible. Probably this evidence screams that Leroy Whitaker is a responsible murder. We'll have pride or jury service. Individually and collectively. Find that body condition good. Check that box. Pull that man accountable.
All right, thank you, Mr. Mizrahi. All right, ladies and gentlemen, as promised, then we are recessing for the evening. If you will, please leave your notepads behind. We'll lock them, secure them, return them to you when we reconvene tomorrow. Tomorrow, this jury is coming back at 9 o'clock. We are almost near the finish line, so it is incredibly important during this overnight recess, as you leave here today or as you arrive tomorrow morning, that you not speak with anyone or allow anyone to approach you or speak to you about anything involving this case. Please make every effort not to watch TV, read the newspaper, hear the radio, or see anything on social media if you even have social media and are on your phones. And that's because we don't want any outside factors or distractions impacting your ability to impartially and fairly try this case. Because as you have heard and will continue to hear, this case has to be tried by you based only on the evidence that comes out in court, based on the law that I instruct you tomorrow, and no outside factors. So with that, I wish you a very good evening, rest up, and I will see you back here tomorrow morning at 9 o'clock. Thank you very much.
All right, y'all. We are done for today. It's been a long day. We had 9.5 hours. All right, a lot went on today. I'm gonna tell y'all my ultimate ending now that Scotty. Hold on, why is this talking? It's been a long day. We had 9.5. All right, my bad. Y'all, I gotta listen to myself on the other phone. But now that Scotty case is done, in the morning they'll charge the jury and his jury will go deliberate, and we'll still have to go through Ksoo stuff. But I'm gonna tell y'all this. As the closing arguments was happening, I was like, well, shoot, y'all know I already said my thoughts on Ksoo, but I really haven't talked about how I feel about how they painted the picture for Scotty. And I'm gonna be honest, I had some reasonable doubt for Scotty because I'm like, well, technically, other than Butter, they don't put him actually at the scene of the murder, right? It could have been questions of how he ended up in the neighborhood, since the police only said they seen 2 suspects, right? But you know what crossed me over is when the state rebuttal and he was talking about, I kept wondering why he talking about Ksoo, right? And then he said, if Butter is telling the truth about Ksoo, then he's telling the truth about Scotty. I said, you know what? You right. You right. And it crossed me over. I'll be honest. So now I'm like, yeah, I'm thinking, okay, that Scotty is going to be found guilty on both charges, right? I'm kind of thinking he may not get murder 1. He may get a lesser charge. But I just don't foresee him getting found not guilty on either one. Like, I knew for sure he wasn't going to get found not guilty on the burglary. But now I had a little hope that, you know what I'm saying, he would have been found not guilty on the murder. But yeah, I think he's going to be cooked on that. I mean, this is just my opinion. Ultimately, it's up to the jury to decide. But I don't think he's going to get found not guilty. If he does, hey, we'll be live and we'll talk about it. But yeah, I don't think he's going to get found not guilty. I'll see how I feel about Ksoo tomorrow once they do the closing arguments. But yeah, I definitely don't feel like Scotty is gonna be found not guilty. I agree with you too, Sharice. I'm trying to click on y'all comments. Hold on. I know Scotty hard as in his ass. Hell yeah, you know that. Ecop said that lawyer brought up so many good points. Yeah, and I rebuttal way better. I thought it was the same lawyer. Kind of found out it was a different lawyer that did the rebuttal. But yeah, the rebuttal was kind of long, but it was like to the point. Like he highlighted the points. He was engaging. He was confident. Like yeah. What the dad facing after snitching? What 20 years at max? Low end 7 years with 2 left, basically. So Ksoo ain't fighting the Bibby murder too. Not right now. Y'all been talking about the Bibby case all day. But nah, you got to get this one done. Then he still got to face trial for that. What else y'all talking about? As Algrave said, you think he's looking good for Ksoo? I missed a lot today. Nah, I still think he's cooked. Still think he's cooked. Same goes to say that Butter is lying on both. Yeah, but y'all know I believe Butter on his testimony. So, like I said, it makes sense to me. But if you don't believe Butter, then the same will go. Then if you think he's lying on Ksoo, then he's lying on Scotty too. So yeah, you right, Bronco. It go both ways. The prosecutor sounded confident in season for sure, for sure. Jay said he's so cooked. Jeremy said Ksoo was just too thirsty. If he didn't jump out the car, they would have had a better chance. That's why Butter was mad at Ksoo. That's true too. Betty said so cooked. I believe Butter too. Facts, Butter. That's why I kept telling y'all Butter matched what was happening. Nothing he said was out of whack. And I ain't gonna lie, Ksoo's sister didn't help the defendants to me. I think she more so helped the state. Hell, the state said it. So Go Jane says, so you're one assassin out in these streets. Crazy word. That's crazy. Steve said the video and 3D scan proved that the cop was off a lot. So I don't think the 2 people or Ksoo being short is enough for not guilty. I for sure agree with you on Ksoo being short for sure. But at first, like I said, I was like, shout out to BC for the super chat. Said giving him the wrong charge, it should be accessory to murder before the fact. Yeah, I'm telling you this. This is why I believe he didn't get that is because he was actually there for the murder, according to the state's theory. See, the dad got after the fact because he wasn't at the murder. He came to pick him up later. I'm surprised the rest of them didn't get before the fact, like Chris Brown and all them. But yeah, they're not gonna get the accessory thing for somebody that actually in their theory is a part of the murder for sure. Betty said he was very confident in everything he said. He didn't blender through any of the question that was asked. Yeah, he definitely, he had a straight face, chin up, chest out the whole time he was on the stand for sure. Ecop said if you ride along and aren't the same scenes, that's not such that's a participant. I agree. KG said he lied a few times before CJ, so people think he's lying now. Yeah, but y'all know with me with the Butter situation is that they couldn't pinpoint. Y'all remember, for those who was around when we watched that on day 3? They never pinpointed him lying in this case. They never attacked anything he said. They attacked what he said in a previous case. They attacked his character. But at no point did they attack anything he said about what happened that day. I'm talking about he went from A to Z. Neither defense attacked anything he said. That just stood out to me. Because if he's such a liar, then why not attack what he's saying? They didn't challenge nothing he said about that day. They only challenged what he had going on previously, and he stood on it. He didn't waver from it because the time that they said he lied, he said he didn't lie. The lawyer just ain't reached back out to him, so that's why it went like that. So I mean, I get the lying point, but when you got somebody that stand on it, you know, you know, like what can you say? GTA, what it do? I'm feeling good today. Feeling good. Feeling better. Go say you think they're gonna come for Ace? I smell Rico. I already told you I'm gonna say no. And if this is just my opinion, if Ace ever get a Rico, it'll be federal for sure. The DA rebuttal. Nah, that rebuttal was fire, Lamar. You capping on that. Now the original closing was definitely there, but nah, that it was straight. He was very, very credible witness. Yeah, to me, he was. You know, the truth team is divided on that. You know, half of us think he was, and half of us think he wasn't. So we definitely divided on that one. Right, attack this character, not his testimony. That stood out to me. That's why I believe what he said. Defense didn't have very good witness at all. At all. Yeah, story of the universe, you know. The defense didn't have anything to work with. Yeah, they did. They could have kept them witnesses. I ain't gonna lie. Okay. Yeah, man, if I was Ksoo, I'd be pissed because the mail order was weak as hell. Is Ksoo going home if he wins or staying for Bibby? He's not getting out. He got other cases. Unless he has a bond on that case and can make the bond. I don't know. I didn't look at the Bibby case. Say hire Brian Steele. I mean, I'm gonna be honest though, just period. It's a hard case to win as a defensive attorney. And we still don't know if they didn't win, but it's just a hard case to argue. This was a hard case to argue for sure. Them ninjas hung themselves. What was the lawyer supposed to do? Right? It's a hard case. Like, you know. I don't even think if the lady with the accent would have tried the whole thing. But so much, you know, she could do, you know. A said he going broke on lawyers for Ksoo on his new song. He said he went broke when he had a baby on the way. I seen the lyrics. It's all on the blogs. I saw that though. Appreciate it. I'm gonna try to do a breakdown for y'all tonight. Or a recap of why I feel Ksoo and Scotty gonna stay despite what, you know, Ace thinks, because Ace thinks they're gonna be home soon. I don't know if he's been watching what we've been watching for sure. So Butter says he was out in the parking lot arguing with Chris Brown when the victim drove off, and you telling me the victim didn't peep all this? Sounds like a bit like, nah, it wasn't arguing. Say he drove up, he went, gave him a little signal, he drove off type thing. It wasn't like he said it was like a big scene. They ain't really got no, okay. Yeah. Oh, this is to record us up. Right. All right, y'all. I'm tired. We almost at 10 hours. And I do want to, because I haven't dropped a actual video in a couple days. And y'all know that's why I get my money on from is dropping videos. So y'all make sure y'all hit the like button, share the live. Tell a friend to pull up on your girl, Make It Truth. And make sure y'all turn your bell notification on. We are back at it tomorrow at 9 a.m. Eastern time. Y'all make sure to check out the videos I dropped this evening. And with that being said, y'all make sure y'all have a good night. And I will catch y'all later. Mickey talks the truth.
Okay. I got truth on my mind. I got truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey. Mickey talks the truth. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast.